morning, and welcome to our 10th annual Elder Advocacy and Law Boot Camp. Can you believe it? A whole decade of fighting for the rights of our elders. I think even though we're all just getting here and getting settled, we should just give ourselves a quick pat on the back or round of applause for 10 years of getting this done. This is amazing. Woo woo! Now, this fight isn't for the faint of heart. It takes dedication, it takes passion, and sometimes it takes a little bit of travel. So this boot camp, we've actually had a really wide expanse of attendees from all over the place, and I'd like to just do something real quick to see how far we came. So if you drove more than 10 miles to be here today, raise your hand. Okay, fair. That was an easy one. That was an easy one. If you drove more than 20 miles, raise your hand. All right, that's awesome. If you drove more than 50 miles, raise your hand. Check this out. All right, now, for the real warriors, I mean, this is really impressive, but if you came from out of state, please raise your hand. Woo! Yeah, see, there are here, and there's actually more online, so let's give everybody a round of applause for that, especially this early. That's the real boot camp experience. So I think this room, as we can all see, is just packed with passionate advocates and online, everyone at home, packed with passionate advocates who understand that the needs of our elders don't stop at the border of our city. And that's the kind of energy that we need to keep this fight going. So I have on this slide here, this is a blast from the past and the future, all in one frame. So this slide includes some of our team members getting dressed up to celebrate a few of the themes that we've had here at boot camp. And for the past 10 years, we've been rocking different themes, but the one thing has stayed constant, and that's fighting for the aging adults of our community. We've seen wins in elder law. We've seen better resources for caregivers. We've seen a growing awareness of senior issues. And why? Because of you. Everybody in this room and online, social workers, nursing home administrators, case managers, elder law professionals, and just elder care professionals like you are really the ones that are pushing this momentum forward. So really just give yourselves a round of applause for all of the work that you've done over the last decade. And just by being here today, you're all making the future brighter for our elders. So thank you. Okay, so here's just a look at our day ahead. We do have one slight change to our event. Our keynote speaker, due to a really unfortunate event, family emergency, we had to make a last-minute change. So Sally Pung, she's going to be sending her assistant, Carrie Craig, who's going to be in her place, which is still, she's an amazing speaker, and you're going to have a lot to learn. So that is the one change. We would like to do a few quick shout-outs to our sponsors. First, thank you to our platinum sponsor, Crown Real Estate Group. We actually get the opportunity to work with Crown and Tom Farrell and his team quite often throughout the estate planning process, and we know that he is truly here to look out for our clients, your clients. They have this reputation, and they've really earned it, of being one of the most dynamic and innovative real estate brokerages in the state of Michigan. And I really do think that if you have a client who needs an appraisal or needs help moving, that Crown is your guy. So thank you. And actually, if you need to get in touch with them, you can look on their website. It's crowngroupmi.com. We'd also like to do a quick shout out for the rest of our sponsors, our premium sponsors. So we have today gourmet coffee that you've enjoyed thanks to Amara Hospice. We have Sovita Credit Union, who has supplied our virtual snack bar, which this is something new for all of our at-home attendees. They were able to actually go online and pick out snacks that they wanted for themselves, and they were mailed out. So thank you so much for Sovita, because that was really nice. It's the first time we've done that. And we got a lot of good feedback, so shout out. Oh, yeah, thank you. Yeah, we can clap for Sovita. I'd also like to thank Vibrant Life Senior Living Lodge of Durand for our popcorn at the end of the day. As you're leaving and getting your certificate, make sure that you grab that bag of popcorn on your way out. We also have CenterWell Home Health. They're going to be here, they're here now. Leanne, woohoo! So at lunch and at snack, Leanne with CenterWell is going to be setting up her Margarita bar, which some of you probably have experienced that before. Just raise your hand if you've experienced the Margarita bar. Oh, it's new. Oh, we've got one. All right, Leanne, this is going to be on you today at lunch and snack. Definitely see Leanne. And then we also have Humana, who has sponsored our power station. We've had a power station for a few years, but this is something that we really think is important because we know a lot of you are still connected even though you're here. You still have clients who need you. You still have people who need you, and so you need to stay in touch. And so we really like to thank Humana for allowing us to do that today. And then we have Advice from Your Advocates podcast, who is sponsoring the breakfast. We really could not do this without the support of our partners, and the collaboration from everyone for this event is really what pushes it forward. And speaking of collaboration, all of you should have inside of your bags your Circle of Care cards. Those you'll just go around to visit the vendors. They'll give you stickers. At the end of the day, we'll have a contest. Or, sorry, not a contest, I can't talk. A raffle. And we'll just pull your name out if you put it in the box at the Mannor Law Group table. And hopefully, if your name is drawn, you'll win a really grand prize. Okay, so this is another important piece of paper that's in your folder or online if you're at home. It is your evaluation form. So I'd like to go ahead and let everybody take that out right now. So with this, it's really important that we all follow instructions and fill this out together. You can't move ahead because then your form might not be invalid or might be invalid. Also note that because this is a CEU event, you do have to remain for the duration of the day. We don't offer partial CE credits. It is a full day. So first, you're going to put your name on the form. If you're a nursing home administrator, you'll put your license number. You'll add your employer or your organization. If you're retired, you can just put that. You'll also check your license type. And then you're going to put the check-in time, which we have our lovely timekeeper, Liz. Liz is going to tell us the official time, which is 8:16. So go ahead and put 8:16 as the check-in time. And then you're going to push that form aside. So for the next few forms, let me make sure the changes. Okay. I'm actually going to invite Attorney Bob Mannor on the stage, and he's going to go through these next few forms that are in your bag with you. So Bob, come on and join me up here.
Okay, so I want to say a few different things. I want to talk about the Circle of Care just for a second here. This has been, 10 years. This has been our theme for 10 years. It's just the concept is that this only works if we all work together. And what I mean by that is that there's not any organization, any one of the elder care journey that can do everything themselves. It often starts out in the hospital. Ideally, people start preparing for this before they have that crisis where they go to the hospital, but in real life, it often starts out at the hospital. So we kind of need the hospital. We need, all right, what happens next? Do they just leave the hospital and go home? Do they leave the hospital and go to rehab? Then from rehab, is it going to be back home? Is it going to be assisted living? Is it going to be independent living? Is it they going to move in with their daughter? All of those things, and then we need home care. It all works together. And the only way that our patients, clients, residents are going to get the best services and best quality of life that they can still maintain is if we all are cooperative and working together. And so this has been an honor over the last 10 years to see the support, to see everybody working together, to see our sponsors. And so I just wanted to make a highlight of that. The reason I'm here, Savannah always doesn't know what I'm going to say when I get up here. So
This is true.
The reason she brought me up here is to talk about these two sheets. So I speak at a lot of events, and I go to a lot of events to learn, nuances, learn new things. And one of my favorite ones, they hand out a version of the Brainstormer worksheet, and I think we recognize their trademark for the Brainstormer?
Yeah, it's on the bottom.
All right, good. So the Brainstormer worksheet and the Insights and Actions items. So I know when I go to an event, when I might be very engaged or very interested in the speaker, but they trigger something in my head that makes me remember that I gotta pick up milk on the way home. Or more likely that, I've got to do something with that one client, or I got to do something with that one resident. Or, hey, this would be a good idea for marketing, or hey, this would be a good idea for that. The problem with that is that then that activates your mind for a while, and you, at least for me, I don't know about you, for me, I then kind of zone out the speaker for a little bit. And so what's really helped me is these two sheets, because when I got an idea, when they've triggered an idea, if it's a brainstorming idea, I write it down on the brainstormer, I'll come back to it later. But it allows me, we've done a little brain study, and read a lot of books on how your brain works. Activating, even if it's saying something kind of secures it, writing it down probably secures it more than even saying it. It's the act of writing down that action to say, I've got to do this later, that brainstorm, helps you then refocus. So you can, all right, I got that out of my head, now I can refocus. Same thing with the insights and actions. That I think is even more powerful, because some of you have a team that you work with, and you say, this would be really great for Miranda to hear about. And so I want to make sure I get this information to Miranda. Or I really need Savannah to add a post to our website, or whatever it is. And so the insights and actions is you write down the thing, write it down, and then you're able to refocus again. So it's something, I don't know, if you like it, you like it. If you don't, you don't. But it's something I always enjoy when I have that at certain events. And so I thought I got permission to use these, and thought I'd pass them on to you. One final thing, just to set the stage for today. There is, 10th year, we're trying to do a retroactive kind of a thing, but one of the themes that we're going to have, and you're going to see this through, so, and I'm okay, you can write whatever you want on the sort of criticism, or the, what do you call it, not the criticism?
Our evaluation.
Evaluation, thank you. Write whatever you want on the evaluation.
Constructive criticism, thank you.
My intention is some of the stuff will be a bit repetitive. It's intentional, because there's so much nuance in things like, who can make decisions for this elderly person? Who can make decisions for this person with dementia? There's so much nuance in it. And we always address that subject, but later on we're going to talk to you about, we'll offer lunch and learn. So if you want us to come out to your place and train the staff, do whatever, we'll do these lunch and learns. We'll get some Taco Bell or something, and then and then do a little lunch and learn. But after having done these for a few years, what I realize is the most popular topic, the thing that people want to talk about the most, is how do I get a decision maker for this one patient I have, this one resident I have? How do we deal with this public guardian that never returns our call? Do we need to get a guardianship? What about this paperwork that seems to be missing 3 pages and was copied sideways? This is the most common topic. And so we're going to, almost each of the speakers, I think, pretty close to each of the speakers, going to talk a little bit about what I refer to as substitute decision making. And so when it seems repetitive, they each have their own little bit perspective. So I just wanted to mention that. And actually, one of our, we have the, I'll get to that later, but there's one of our tables that has some funding to promote not having to run into court on this type of stuff. That it's basically providing dignity to elders, that instead of taking away their right to make their own decision, is there a way to do this without having to run into court? Because when a judge, and there's nothing wrong with that, of course we need that, but if a judge takes away your right to make your own decisions, that's a difficult, then they can't make their own decisions. And so are there alternatives, less expensive alternatives? So one of our sponsors actually has some funding to promote that. So anyway, I wanted to mention those few things, kind of the theme for today, and I'll stop talking now.
Oh, there's more, Bob.
Oh, there's more, okay. Yeah. Oh, yes, okay. So there's 2 things, I forgot. So there's 2 things. This is something we've handed out every year. We update it. Okay, so there's 2 sides to this. We call it the 2024 Medicaid long-term care Medicaid qualification worksheet. On this side, the side that you're seeing on the screen, it is just a kind of a checklist to say, hey, these are the red flags. If you have any, if the family that you're working with is looking at Medicaid and they check any of those flags, or they check any of those boxes, that's probably a red flag. It might not go through as smoothly as you think it will. And so we just thought that would be a useful thing. On the other side of that page is what I know is useful, which is the 2024 numbers. So numbers for what is the income limit for waiver and PACE? What is the monthly, what is the divisor for gifting? What is the, how much money can you have and still get those aid and attendance veterans benefits? What are the years of service for veterans? Is that on there? I think it is on there. And so we try to update that every year. We try to think about what would be useful information for you, but a lot of those numbers change every year, which is if you have one from a few years ago, throw that one away and use this one, and if you need more, we'll send you more. This is something that we always try to hand out or have with us when anybody goes out to talk to you. All right, next one. Okay, this is something that has been kind of our pet project for years, and this is when we get to mine and Amy's presentation, we're going to spend a lot of time on this form. So we decided to laminate it for you because my entire presentation is going to be about this form. One of the things that we find, and again, we're going to get into this later, is that families are so overwhelmed when they're first dealing with this crisis. The landscape of options seems overwhelming, and it's really difficult for people to understand the difference between an independent living and a skilled nursing facility. There's, the general public doesn't necessarily understand the difference, and there's obviously a big difference. And so what we're going to do is we're going to walk you through how when I meet with the client, how I kind of walk them through and help them try to narrow down their options. And this form has been very helpful for me. A couple of years ago, I presented this form to a lawyer group, the Institute for Continuing Legal Education, and what I realized was some of the lawyers didn't know what waiver was, doesn't know what PACE was, didn't know what adult foster care was. So I did, on the back of the sheet, there's like a definition of terms kind of a thing there. So we find this to be very helpful in narrowing down options and helping families decide what's next for them. Now I'm done, right?
Yeah,
all right, thanks.
Thank you, Bob. We'll definitely see more from Bob later. Okay, so just real quick, I know I've asked you to show some hands before, but I'm just curious, who here is coming to boot camp for the first time? If this is your first time, raise your hand. Isn't that awesome? Yay! I definitely want to clap for you guys. So because this is your first time, I just want you to have some context about who we are. Let me make sure I have it up on the screen. Okay, so what do we do here at Mannor Law Group? We have 3 locations. We are located in Grand Blanc. We have a location in Rochester Hills, and then we have a new location in Brighton that we're just opening. So it is literally brand new. Attorney Kelli King-Penner is leading that office, and we're really excited about all of that. So we help families with estate planning, elder law, long-term care planning, veterans benefits planning, elder care navigation. We help with guardianships, discharge planning, all kinds of stuff. We really can help in many different capacities, and if we can't help you, we find someone who can. So we always encourage you to reach out to us, contact us, ask us questions. You'll hear more about that later, but I think all of us are going to tell you to just contact us if you ever need anything, because we like to help. At our firm, we have 3 attorneys. Yeah, isn't that a nice picture? I heard someone go, aw. Probably was Nikki.
Danielle.
Oh, Danielle. Oh, okay. Yeah. So we have Attorney Kelli King-Penner, Attorney Melissa Dixon, and Attorney Bob Mannor. And they are all just incredible people. They really have a passion for helping the aging adult members of our community. They're all actually certified dementia care practitioners. They're all certified or VA accredited to help veterans with claims and appeals. They're just really experienced. And later we like to joke that Bob is the Yoda of elder law, which we'll talk more about that later. And we also have our social workers. So at this table here, you can also see Nikki and Danielle, Nikki Inches and Danielle Chwalibog. Did I say that right? Because I feel like every time I get on stage, I say it differently. Okay. So they are our care navigators. We also have a team of elder care coordinators. We actually have Liz right here, who's an elder care coordinator, and Amy. They together make up our planning services team, which if you do refer a client to us, chances are you're going to be working, or they're going to be working with those members of our team. If you do have questions throughout the day, I just want you to know that it's okay to ask them. Most presenters will leave space at the end of each presentation to ask a question. Sometimes questions come up and, it's okay. We'll be walking around with microphones, or we'll try to, so that we can hear everyone's question. If you're online and you have a question, you might have a chat option. If you don't, I'm sorry, we were having a little bit of technical difficulties, but save your question. You can email it to info@mannorlaw.com. Or you can just even reply. If you're a virtual person, you've been getting a lot of emails from me probably, you can just reply to that email and we'll make sure that your questions are answered no matter what. So don't worry about that. And for now, I would actually like to call up our first presenters, which are Nikki Inches and Danielle Chwalibog.
All right, good morning, everybody. How's everybody doing? Feeling good? Everybody's awake? Because I know I had 3 cups of coffee so far. So, as Savannah said, I'm Danielle. I am a care navigator, social worker at Mannor Law Group. I've been with the firm for about 2 years now, and when I came to the firm, care navigation, Mannor Law Group had done it in the past, and we were kind of rebooting the program. And 2 years later, this program has been very successful. Our clients really love our program, and we're here to talk to you guys today about what that looks like, what is care navigation, and how we can work together.
Hello, I'm Nikki. I am also one of the care navigators here at, move it up.
There you go.
Is that better? Can you hear me better now? Okay. So I'm Nikki. I'm one of the care navigators here as well. I've been here for getting closer to a year now. So I was here last year for the first time, just like some of you are today, and learned so much. And so we're glad that you guys are here today.
All right, so this is going to be a really strange request, but I want everybody to close your eyes for me for a second. And I want you to imagine this. Imagine you're alone. You're scared. You're isolated. You're navigating through this complex healthcare system. You're lost, overwhelmed by the unfamiliar terms, confusing processes, and endless choices. You can open your eyes now. So that's the reality for many people seeking care today, which is where care navigation comes in and how we can work with our clients to navigate through that complexity. So this is kind of what it looks like for somebody trying to navigate that healthcare system. You start living alone. Then you have some forgetfulness, and you continue on the journey, and something happens. Something changes. Now you're on a different path. Maybe you go to the doctor. They start you on new medications. You now have to go see a specialist for that. And then you go back home. There's really no follow-up. No questions are answered. Then you start wandering. Now you're on a different path. This can be very confusing for anybody, even us in this room.
Yeah, it sure does look confusing, Danielle. I can't imagine being in that situation that you talked about where you're feeling alone and lost and then having to go through all of this on your own.
Absolutely. So let's look what it was like back in the day.
So things were different back in the day, right? We had people that were getting closer to their 100 days in rehab. We had higher expectations for where people were going to be functioning when they were leaving rehab. We had some less medically complex cases that did allow for those extra days. We had less managed care Medicare, so we had more opportunity where it was our therapists, it was the people who were hands-on involved with that care that were making decisions on when therapy should come to an end. And now we don't have so much of the hands-on people that are making those decisions for us. Where back in the day, we used to have people doing cartwheels out the door. And now we're looking at who can push them out the door in their wheelchair.
Absolutely, Nikki. And I know when I used to work in the nursing home, Our goal, like Nikki said, somersaults, cartwheels out the door. We'd have a lot of elective hips, knee surgeries coming in. They do their rehab, they go home with home care, and they continue to live independently in their home. Now, that's a little different. And the level of care and the goal of the nursing home is to transition to the next level of care, which could be long-term care, assisted living, memory care, home with 24-hour care. So things look a little bit different. So what is care navigation? Show of hands, has anybody heard of that term before and knows kind of what that is and the background of it? So just a few people. So care navigation focuses on the individual by guiding and supporting patients throughout their healthcare journey. We can help families to understand their options. We care navigators break down complex medical details into understandable, clear terms. For example, you go to the doctor and they spew out all these medical terms, and as an elderly person or even as an experienced medical social worker, you might look at them like, what the heck are they talking about? And then you start Googling. That's not always the answer. So, we can help make sure that they're understanding their options better.
We can help them with making informed decisions. So like Danielle said, maybe they don't understand what was said. So we can help to clarify what was said. We can get that information from the doctors. We can make sure that the decisions that they're making are based on information that they understand. We can help them with weighing the pros and cons of different treatment options. We can help them consider the cost. What is it going to cost to do this? What is their insurance going to cover? What isn't it going to cover? So they have all of that information available to them so that the decisions that they are making about their health care and about their life are informed.
And Nikki, I know we worked on a case one time where a family member called about a certain medication, and that medication was going to cost $3,000. Who can afford that nowadays? Right. And we were able to help step in and call the VA and call the insurance company and actually get it covered completely.
Yeah.
We can also make sure that we're accessing the right care. So as care navigators, we can streamline the process and remove roadblocks, such as finding the right specialist. We get a lot of phone calls that say, my doctor recommended for me to see a cardiologist. Who do I call? They don't know. Scheduling appointments and coordinating care across different providers. How many of us see different doctors? You see a cardiologist, you see your primary, you see a neurologist, a gerontologist. That's a lot of care providers, and making sure that that communication between that team is streamlined.
We can help with advocacy and support. So making sure that our clients, that their voices are heard. How many times have we gone to the doctor and we've walked out feeling like they didn't hear what we had to say, right? We can help with that support. We can help advocate for them so that they are being heard, so that they do feel like that their doctors are listening to them. Insurance is crazy, right? All the different little pieces of it. We can help them walk through that so they know what their insurance is doing for them. How many times do we get letters in the mail from our insurance company and they don't know what it is, or big booklets of information?
Or when you're admitted to a skilled nursing facility and the insurance company 2 weeks later sends you've been approved for this many days, and now families are already talking about discharge.
Yeah.
It's a lot of confusing information.
Absolutely. We can also help them with looking at alternatives. Maybe that's not the approach they want to take to whatever's going on. Maybe they want to look at something that's more holistic or something that's completely different. And so we can gather information for them and share that information with them so that they have all of that to make their choices.
So what are the benefits of care navigation? It's more than simply making healthcare easier. We have improved health outcomes. So clients who receive care navigation are more likely to adhere to treatment plans, experience better chronic disease management, and have lower rates of hospital readmission. Imagine somebody just getting diagnosed with COPD. Now you have to go to see a pulmonologist. You have to see your primary. You have to get durable medical equipment for at home. Maybe you need oxygen now. Making sure that we're helping experience that better chronic disease management at home?
We can help by reducing cost. Staying out of the hospital reduces cost, right? So being able to help them set up those things that Danielle was talking about is going to help to keep them out of the hospital. And that's a savings for both our clients and for the healthcare system. We don't want our clients going in and out of the hospital, and neither do you guys, right? When you have a client come to you, you don't want them bouncing back and forth in and out of the hospital.
And Nikki, CMS is really hammering down on hospital readmissions right now and the penalties for that. And with Care Navigation, we can help try and eliminate some of those rehospitalizations. We can also help with overcoming barriers. So helping clients overcome barriers to care, such as lack of knowledge or financial constraints. We see all the time family members come in and say, we can't afford this, but they don't know about the benefits that are available to them and that we can help them receive those benefits.
Enhanced client satisfaction. Everybody likes that, right? Our clients like that, we like that, you guys like that. When our clients are feeling supported through this healthcare journey and all of these decisions that they have to make, they start to become more comfortable in those decisions, and they become more satisfied with the services that they're receiving, and they become more loyal, right? So when they come to your facility or to the hospital and they come in and they have what they consider to be a good experience in that, when something comes up and they have to go somewhere again, they're going to want to go back to that same place. Or when they have a family member who needs rehab, they're going to say, well, I went here and I had a good experience there. So we have kind of, as we increase that customer satisfaction, we're also increasing that loyalty.
So who can benefit from Care Navigation? Anyone. Anyone that's going to navigate through the healthcare system can benefit from this program, especially individuals with complex health needs. Managing multiple chronic conditions or undergoing complex medical procedures often require a coordinated approach where we can come in and can provide that.
People that are facing barriers to care, whether they have a lack of insurance, they have transportation challenges, or language difficulties, all of those things are barriers to care. Imagine that you are new out of the hospital and you're at home and you're in a wheelchair and you're not able to transfer yourself anymore, but you have a doctor's appointment, right? And you need to get out to that doctor's appointment, but you can't get in and out of your car. So how do they get there? If they don't know that the resources are out there for, wheelchair transports, things like that, that's gonna be a barrier to that care, and that's something that we can help with. We know those resources. We have the ability to say, here are some companies that are going to be able to help you get to those appointments.
Yep, and we've built relationships with you guys, and that's where we can draw on those resources too for our patients. And anyone that's overwhelmed by the healthcare system. So even the most informed individuals can feel lost in the labyrinth of healthcare choices. I know for me, when I had my baby last year, I was lost. My doctor was talking about all these terms. I didn't know what the heck she was talking about. And I think that I'm pretty knowledgeable in the healthcare world, but I was still confused. So Care Navigation provides that much needed lifeline and helps individuals make that informed decision about their health. But most importantly, who do we serve? We serve the elderly. Our most vulnerable population. They're alone, isolated, they're afraid to ask for help. And this is where that Care Navigation portion can come in and be a huge benefit. So Nikki, what services are provided by Care Navigators?
Well, we can provide assessment and education. And one way that we can do that is we can go into their homes and we can see where they're living and see where they're comfortable. We can go in and we can make recommendations that are going to help to keep them in their homes for as long as we safely can, if that's their goal. We can go in, we can spend time getting to know them. I know Danielle and I both worked in the nursing homes, and I don't know about you, but when I worked in the nursing home, I didn't have time to just sit with the residents and just visit and get to know them on that personal level.
Not when you have 12 discharges in 1 week, you can't.
Exactly. And we do have that ability. We have that ability to go in there. We have the ability to just spend time getting to know them and finding out what pieces of education are going to help them. And that's all done through our assessments and our home visits with them.
And we can gather background information that's going to be beneficial to you guys. Like Nikki said, we understand that time is tight when you're in the nursing home or at the assisted living, and you only have a short period of time with them. Maybe there's something that's going to help them transition easier into your facility. We had a client one time that all they wanted to do was watch Western movies. But it took us a lot of time to dig that out of family members. He would act out. He would have behaviors. And as soon as we found out he liked Western movies, we got a whole bunch of VHSs, popped him in, and it was the one thing that calmed him down. So through that assessment that we can sit with the family and find their likes and dislikes can help you guys too. We also do advocacy and support. So helping patients navigate insurance claims and billing issues. We are connecting patients with community resources, with you guys, making sure that they have the right information on what services you provide, what's available in your communities. Communication, we've talked a lot about this. Making sure that communication is streamlined from each provider. Providing emotional support and guidance. This is a hard time for our patients, hard time for our family members. You may not have the time to spend with the families to help through this process and understand truly what is going on and how to help them through that. We take that off of you. We have that time that we can spend with families explaining and showing them what is to be expected. We do legal and financial guidance and planning. We make sure they have documents. We make sure they have a decision maker that they love and trust. We make sure that their benefits are going to be and their assets are going to be protected. And we're going to help determine the best plan of care. We're going to work with the families. We're going to give our advice. We're going to work with our team at Mannor Law Group to make sure that we're guiding them into the right plan of care.
We do care coordination. So we can assist with scheduling appointments with doctors and specialists. We can arrange for transportation like we talked about. One of the big things is following up with our patients after they go to the doctor. Oftentimes, there's that lack of communication piece there, right? Mom and dad go to the doctor says something, mom and dad come home, and the kids will say, "What did the doctor say?" "I don't know." Right? My parents tell me that all the time. I don't know. So we can kind of assist with that. We can help the families get the information that the doctor is saying so that they can make some informed decisions. When they come to a nursing home or an assisted living or foster care, we can attend care conferences, and we can provide the facilities, we can provide them with that information that we've gathered through our home assessments. We can bring that in and say, hey, you know, they really like to sleep in until 11 o'clock in the morning. Well, that might help alleviate some of the situations that are happening. We can act as that go-between too with the families and talking to the families about what they, like Danielle said, what they should expect when they go in. We can help with discharge planning. We can help with that. There's a lot that goes into that. It's, you know, you guys know you do it all the time. It's ordering the equipment. It's checking the home. We can kind of help take that burden off of you guys and work to make sure that those things are done.
And Nikki, let's be honest, with managed care products, you get 48 hours notice of discharge pretty much. And we're supposed to start discharge planning on admission, but how hard is that sometimes when you have somebody who's completely dependent, or maybe they're really struggling at first and you don't know what that discharge plan is going to look like? We can spend the time with the family members and make sure that they're prepared for when that time comes and that managed care issues the discharge date, that we're ready to transition them out of your facility or maybe to long-term care or home with care and make sure that they're going to be safe in their home. So it's a growing demand. Care navigation is starting to be a huge demand in our world today. Personalized care and virtual care integrations are driving the demand for this service.
And now with technology like telehealth visits and virtual sessions, we can help with that with families that are maybe not in town or out of state, right? We can still have everybody coming together to come up with the best plan of care, even if they can't physically be in that same location, so that all of the family that our clients want to be there are there and involved in making these decisions.
Yeah, Nikki, and we do a lot of Zoom calls in our office. Ever since COVID, Zoom's been pretty big, right? So we can have those family conversations, and we can utilize that telehealth and those services of technology to really bring everybody together, and there's not going to be that miscommunication. So what's changing? Things are changing today. The population.
We got baby boomers.
So the demographic makeup of skilled nursing facilities are changing.
The baby boomer generation was born between 1946 and 1964, and it is the largest generation in U.S. history.
According to the U.S. Census Bureau, there's 76.4 baby boomers. That's a lot of people.
That is a lot of people. What do you think that's going to mean, Danielle?
I don't know. Where are we going to put everybody? So that's going to lead to a significant increase in the number of people needing long-term care.
And the family dynamics are changing. Our baby boomers were kind of that first generation that took care of their parents and their children at the same time. And so they experienced what it was like to be taking care of their parents, right? And oftentimes we find that they don't want to put that on their kids. That's where the I don't knows come from. Don't worry about me. I'm okay, right? Well, as kids, we know that's maybe not true, but they don't want to put that burden onto their children, or what they perceive as a burden, right? And so with that change, we're looking at a situation where we kind of have to step in and help a little bit.
Yeah, and the nuclear family is changing. How many of us here in this room had parents that, took on their parents and moved in and cared for them? We can't do that today. I know for me, if my mom said, hey, I need to move in because I need some care, I've got 2 little ones at home. My husband works full-time at home. I can't have my mom living there full-time with me. Nikki, you have a daughter.
Yes.
Do you want her living with you full-time?
I don't want her living with me full-time. And as the mom in this scenario, I don't want to move in with her and have her telling me what I can and can't do.
And that's how our clients are feeling, especially with this population of baby boomers coming up. So let's look at a case study. A case that we worked on together. We've got Jim and Pam. If anybody's fans of The Office, that's where I pulled Jim and Pam out of. So Jim and Pam, Jim's 81, Pam's 76, retired Persails. Married 58 years. That's a long time.
That is a long time.
And they were living at home alone.
So Pam is a diabetic, and she has some memory issues. And those memory issues lead to her forgetting to check her blood sugars and take her insulin. And because of that, she's been admitted to the hospital 10 times over the last 6 months. That's a lot of hospital admissions. And even with that memory confusion, and when her sugar is off kilter, she's becoming combative. With all of those things happening, she is still driving.
And Nikki, 10 hospital stays in 6 months, wow, that's a lot of readmissions.
Yeah.
That's a lot of yo-yo, what we call the yo-yo effect, going from home to the hospital, back home again, maybe with home care. And she would do great for a week or two, and they'd discharge her off services, and then we'd start that whole process back over again. And it wasn't a safe picture for her. And we've got Jim. Jim thought that they were doing great. However, Jim had unsteady gait. 7 falls in 6 months. Knock on wood, Jim didn't break anything during any of those falls. He was having balance issues, memory issues. He was still driving, but guess what? Jim was getting lost. He couldn't find his way home sometimes, and his family started to become more concerned. And we were unable to get a clear diagnosis of what was going on with Jim. All these doctors that he was seeing, and unfortunately nobody could answer the family's question. We needed more answers.
Their children were working full-time, so they weren't able to be there all the time and see what was going on. They weren't able to provide that extra level of care that they needed.
And they came in and they just had some basic estate planning documents. They had a power of attorney, a will, and that was it. Doesn't really help for any future needs that they might need. So with their current planning and no care navigation involved, we had a repeat hospitalization. Hospital staff were starting to get concerned about Jim and Pam, and why was Pam constantly coming to the hospital? What was going on at home that family couldn't manage? They didn't know that the children were working full-time. Pam and Jim were telling the hospital staff that family was providing care for them.
There was a lack of communication between the family, the healthcare providers, and Jim and Pam, right? I don't know. Doctor said I'm good. Doctor said don't worry about me, right? So there was that lack of communication going on with everybody.
And Jim would go to the doctor, and he would come home, and the daughter would say, Dad, what happened at your appointment? I don't know. Did they change medications? Yeah, I got some new medications here, but I don't know what they're for. The daughter tried calling, and just with her basic estate planning, she really couldn't get any information out of the doctor. There were no services in the home. Jim and Pam were out there all alone, trying to figure out how to not involve their family in their care, to try and make sure that they could stay in their home as long as possible, which really wasn't feasible.
And even with his own confusion, Jim was acting as Pam's power of attorney.
Which is not great, because Jim was having memory issues. So if Pam went into the hospital, Jim was making those decisions for her. That's kind of scary. And on top of it all, if Jim or Pam passed away and the other needed Medicaid, their assets would be exposed. And that's scary. So with updated planning and care navigation and us being involved, we were finally able to obtain a concrete diagnosis of frontal temporal dementia for Jim. We finally got that answer. We were able to call and make an appointment for Jim for somebody who could actually give us that concrete answer. Family felt better about that. We knew what was going on with Dad.
Yeah, and getting that diagnosis, Danielle, that was huge because that led to other things being able to happen, right? Once Dad knew that he had that diagnosis, once that was confirmed to him, after lots of long talks and tough conversations, he did give up driving.
Well, and Pam did as well. Pam ended up getting into a car accident and realized she probably shouldn't be driving anymore. And that's huge. I don't know about any of you, but if my kids told me, Mom, you can't drive anymore, I'd laugh in their face. I'd be like, heck no, you're all wrong. For them to voluntarily give up driving was a huge success, and that was one step in our process. We did updated documents for protection for Medicaid benefits. So should either of them need long-term care, we had protections in place. We also had a decision maker other than Jim or Pam for each other. They chose someone that they love and trusted to help make those decisions, to help pay for bills when that time came. And we were able to get all of those documents updated before any big changes happened.
We can help those families. We have really tough conversations sometimes, right? Sometimes, and in this instance, we can come in with the doctor's backing and we can say, it's not safe to be driving anymore. And that takes that off of the family, right? Because we're the ones now with the doctor's backing that's saying you can't drive. Or we're the ones saying, if you want to stay in your home, you have to have help, right? So we have those tough conversations.
And it's not just a one-time conversation. We have multiple family meetings, and we sit down with everybody. Sometimes maybe with not Mom and Dad involved even, and just hear from the family what their wishes are. Then we bring Mom and Dad in and hear from them and make sure that we're aligning all of the family's wishes with what Jim and Pam's wishes are too. In this case, we secured placement for them. It took us, we had been working on this case for 7 months before we finally got Jim and Pam to agree to placement. And we helped with that transition. Nikki visited them at their new facility. We brought a welcoming basket even. We checked on them. We made sure that the facility understood what their diagnoses were and what their likes and dislikes were. And now, from what I hear, they're thriving. They're doing great. They've made friends. They're attending activities. They can't keep them in their room anymore. They're constantly out trying to see all their friends at the facility.
The last time I went to visit, I was told, I don't know, they're floating around here somewhere.
which is a huge success. And that's where that care navigation really was a success in this case. And it doesn't always go smooth. There are bumps in the road, but that's why we're here to help the families navigate through that. Now look at how cute Angela is. Little old lady.
She's all dressed up.
So this is Angela. She's a single woman. She was widowed 10 years ago, living alone. She's 88. It's pretty old in my book.
I don't know. Angela has a diagnosis of dementia. She has Parkinson's and depression. She's had multiple falls, and she requires the use of a walker. And like a lot of the folks that we know, she often forgets to use her walker,
Or
right?
she would refuse.
She gets up and she goes because she can do it. And because she refuses to use that, that incurred some more falls for her. And every time she had a fall, she got a little bit weaker. And so she started to need some more assistance with all of those activities of daily living.
And family would come visit her, and she'd have bruises all over her face because she had a fall. They were concerned, but Grandma, Mom would say, "I'm okay. I just maybe tripped and fell. No big deal."
She was seeing multiple doctors. So she had her neurologist, and she had her cardiologist, and she was seeing a psychologist. So lots of different doctors, lots of those ologist doctors.
She had 4 children. One child was out of state, not even in the picture, really. She didn't know what was going on with Mom. She thought everything was fine. We had one child on disability, couldn't help, had back issues, wasn't working and wasn't able to care for Mom. And 2 children working full-time with their own families that they were responsible for.
But they were trying, right? The family was trying, and they did hire some private duty caregivers to come in and help Mom. It just unfortunately wasn't quite enough.
And poor Angela wasn't prepared. She didn't have any estate planning documents. She didn't have anything in writing that said, "I love and trust this person and I want them to help make my medical decisions or to make financial decisions for me." There was nothing. So if Angela ended up in the hospital and unable to voice what her wishes would be, we could possibly be looking at guardianship, which is something we always want to avoid. So with the current planning that Angela had and absolutely no care navigation involved, like I said, there was no decision maker. Nobody to act on Angela's behalf if that time came that she couldn't. Nobody to help her with finances, to help make sure the bills were getting paid and making sure that things weren't being missed.
And like I said, the family did hire some private duty caregivers for her, but we all know that that's very expensive. You know, to have somebody in the home with you as often as what we need. And because of that, Angela was running through her funds pretty quickly.
Even with the private duty caregiver at home, Angela was still having falls. She was falling multiple times a day, multiple times a week. Thankfully, she never broke anything, but the caregiver couldn't stop those falls.
And the family was struggling, and they weren't recognizing the fact that it wasn't safe for Angela to be home anymore. Mom was able to say, "I'm okay." And because they weren't there all the time, they weren't seeing all of the pieces of the puzzle. They were just seeing those little bits that Mom was giving to them. They would come in and they would spend a couple of hours, and Mom would sit on the couch with them and chat with them. And so they weren't seeing her in what she was and wasn't able to do.
And Nikki, to touch on that, the caregiver was not somebody that was from an agency. The family found this person on care.com. And not somebody that really the family probably should be using because she doesn't really have the liability or could have those conversations with families even to say, "Hey, your mom fell 6 times this week. She was just there to do her job." And the family members disagreed on the plan of care. Like I said before, one daughter lived out of state and thought everything was great, and Angela was doing great at home. Son on disability really didn't care. He had his own issues. And the 2 children that were involved in mom's care fought, and they butted heads about what we should do with Angela.
And through this, Angela was becoming more and more isolated. There was a lack of socialization. And we all know that that affects a lot of things, right? That's why we have dining rooms when we're in assisted living or in a facility, because there's visual cueing with eating. There's all of those pieces that are so important that go along with socialization, and that wasn't happening for Angela anymore. And so because of that, she was starting to lose some weight. She wasn't feeling the greatest. She was feeling isolated a little bit.
And she already had a diagnosis of depression. She was isolated, alone. That only increased her depression even more. And as Nikki mentioned, she was seeing a lot of ologists, a lot of specialists that medications were constantly changing and family couldn't keep a track of them. Nobody, one person was managing it. A lot of confusion. So with some updated planning and care navigation, we were able to sign documents with Angela to help determine who her decision maker should be, who she loved and trusted, who can help her, again, write bills, make medical decisions when that time came, who can help guide her through this too.
We were able to have a family meeting, to have a family discussion and talk about what was going to be the best plan of care. And that's where we can use that technology that we talked about earlier, right? We have a daughter who's living out of state. She's able to be there via Zoom and be involved in that planning and those decisions that need to be made.
And Nikki, it wasn't just one family meeting. We had
Yeah.
multiple family meetings with this family to make sure that everybody was on the same page, and we achieved that. And I mentioned we had a disabled child. We have an ability to use that disabled child to protect assets from Medicaid. That's huge. That's a big bonus for us and for Angela. And we were able to set that up with the correct planning.
So through that, through all of those hard conversations, through family really recognizing what was going on, we were able to secure placement for Angela in a skilled nursing facility.
And we were able to review the care plan with the facility to ensure that Angela was attending activities, that she was going down to the dining room for all of her meals, that she wasn't feeling isolated and alone in her room in a new environment. We were able to make sure and communicate how important that was to the facility from the family. And there was one physician that was now managing medications. The facility physician was overseeing all of the medications. That's awesome. Now with Angela's case, we also, further down the line, she declined. As she stayed longer in the nursing home, her health declined. And Nikki, with your background in hospice, want to have a little conversation about how we approach that.
Absolutely. Hospice is a really scary word, right? We all know that for our families. It's just a really scary, they think that means that mom's dying tomorrow. And so we have those really hard conversations that that's not what it means. That it means that it's that extra support to be able to come in and make things peaceful and make things comfortable for mom for however long she has, whether it's one day, 6 months, a year, whatever it is. And so having those hard conversations and kind of educating on that piece of it as well, right? I often tell people that we talk about, if I talked about all the things that hospice could offer you, right? Somebody to come into your home and manage your medications, come in and help with bathing, get you the equipment that you need, get your supplies for you. We talk about those things, and and I'm going to tell you that it's free. That's like a great program, right? People are like, sign me up. But when I put that tab of hospice on there, all of a sudden it's like, hold up. And so having those really hard conversations with Angela's family, it was with her family at this point, and getting them to understand where we were so that they felt more comfortable with saying, okay, yeah, I think that maybe it is time to bring in hospice.
And what a tough conversation for anybody to have, right? We don't maybe want to sometimes have those conversations. And thankfully with Nikki's background, she approaches it in a very calm, collective way and can have that conversation. So something that is a little different about our office is we're a dementia-focused practice. All of our staff in our office are certified dementia practitioners. And about 78% of our clients have a diagnosis of dementia or Alzheimer's. Yeah,
so they have a lot of worries, right? When you initially get that diagnosis or when you start going through that, our clients themselves have a lot of worries. Our families have a lot of worries about what next, right? Or they look at kind of, Okay, we're in this crisis situation. Sally's going to take tomorrow off work, and Joe's going to take the next day, and we're looking out about 7 days, right, of taking care of our families. That's about how far out we're seeing is 7 days. And so we, as what we do, we can see beyond that 7-day period, because that's not sustainable long term.
Absolutely. And we look at the holistic approach. So a lot of family members come to us in that crisis. And like Nikki said, they can only see for the next 7 days. We see beyond that. We see long term. What are we going to do in a year from now? What are we going to do in 3 months from now? Family members can't sometimes wrap their head around that. And so we're able to guide them through that process and what it's going to look like. And the proper diagnosis is one of the most important things. We make referrals all the time to gerontologists, neurologists, for families to get that proper diagnosis. Family members come in and say, well, Mom's showing signs of confusion. We don't know what it is. Nobody can tell us. Dad's been wandering around and his primary care doctor just says, oh, it's cognitive loss. We need an appropriate diagnosis, and making those referrals achieve that.
Yeah. Or they'll say, oh, they have dementia, right? Well, what kind of dementia do they have? Dementia is a very broad term. So what kind? When we know what kind, we kind of know maybe what trajectory that we're looking at with that. So having that proper diagnosis of what it is very important. And that kind of leads into disease education, right? If somebody says to us, oh, Mom has a diagnosis of frontal temporal dementia, we know that that's going to present maybe a little bit different than a diagnosis of Lewy body dementia, right? And so giving them the education of what they can expect or what they can anticipate may be happening.
Or something that's more frequent, like a urinary tract infection. You're at home providing care for your loved one, and all of a sudden she starts acting a little weird, becoming more combative and confused. That education piece that we provide can explain to families signs to look out for, when to call your physician, when you should make that phone call. And so this is our elder care continuum. This shows the continuum that people face every day. We've got the health and the ability to function. Somebody who's like you and I, who can function independently. We get to remain in our home. We get to be there. Cost of care is really nothing because we don't need anything. And then the public benefit and public resource, it's private funding if you're at home, right?
Yeah. So as we progress down this, Danielle, it looks like we kind of go from no function limitations and then maybe a little bit limited into the point where we need a lot of care. And I see that there's some different options here under the benefits column. What are some of the different benefits and ways to pay for that care?
Absolutely. So like I mentioned, private funding. You can pay privately out of pocket for that. It's going to cost a lot probably, but we can do that. We can look at VA benefits. If mom was or dad was a veteran, and we can utilize that and get some maybe money back for VA benefits, or look at maybe a VA facility even. We can look at that too. Community services, the Valley Area Agency on Aging, or even in Oakland County, the Area Agency on Aging. What services are out of there that we can utilize? Making sure that Social Security benefits are right. Making sure that they're receiving them. We can look at family being caregivers and how we can get that process moving to make sure that family feels supported too while they're doing this. And we can look at Medicare and Medicaid, making sure that they have the hospital coverage that they're going to need, that their prescription coverage is going to be appropriate, and that they have Medicaid benefits too for long-term care, that they're not going to maybe be lost or feel like, oh, I have to spend everything and now I have nothing and now I don't know what to do. So as Bob mentioned this before, and you will see it numerous times throughout the day, this is our levels of available care. Nikki and I utilize this almost every day with our family members. Bob and Amy are going to go a little bit more into detail with it, but we just wanted to bring it up. It's a great tool. It provides families, and we actually give this out to our families too, it provides family a brief overview of what we can look at. Are veterans benefits available? No, they're not, so we cross those off maybe in some cases. Where can we look for Medicaid? Do mom and dad qualify for PACE or waiver programs? Are they over the income limit? This is a great tool to utilize. So how can we work together? How can everybody in this room with our team work together? Care navigation is more than just a helpful service. It's a transformative approach to healthcare. It's going to be the new thing. You go to and this is one of the examples that I know of, is a cancer doctor, an oncologist. They have care coordinators in their office to help you through that entire process. That's what we want to be too, for our clients and for you guys.
By empowering individuals to navigate the complexities of the healthcare system, care navigation paves the way for a healthier, more equitable future for everyone, and that involves all of us, right? We can't do it by ourselves. You can't do it by yourself. We need each other. We need to work together to ensure that all of our clients, all of our residents are getting the absolute best care that they could possibly receive.
Absolutely. And that brings us back to our circle of care. We all need each other. There's no way we would be successful in our positions without you guys. And you guys have clients that need us as well. And we can't do that job unless you guys are our resources and that we're communicating. Our best results require everybody coordinating care, where we can help streamline that process from they come to us, they go to you, they go to the hospital, they go to the nursing home. And we're making sure that that line of communication just continues along that circle of care.
The best results require everyone coordinating together for our clients.
Any questions?
Okay, I have a mic. I'll come to you.
So with the two examples you gave, it sounds like they were all stuck where they were without recognizing the need for care, et cetera. So how did you get involved to begin with? How was a referral made? And what is the cost? Who covers the cost of your services?
So the cost depends on what type of care navigation they're going to need. What happened in both of those cases is at the hospital social worker finally identified that they need help. When you're in the hospital, you got maybe 3 or 4 days and you got to get out. We've built that relationship with our hospitals in the community where they felt comfortable enough to say, you need to call somebody. They made that initial phone call, and we do an intake over the phone and gather some information. Then we bring them in for a meeting with one of our attorneys, and typically Nikki or I are involved in that meeting. From there, we present what we see, what we think might be an issue, what we think might be the best plan. Sometimes we may not recommend care navigation. Maybe they just need documents, but they need some guidance. Other times we may say care navigation is the way to go. As far as the cost, it'll depends on what type of plan we're looking at. So there's no concrete answer for that. Does that answer your question?
All right, I'm coming.
Do you set up like a schedule of different plan services and cost per plan, depending on the services provided? Is it hourly? And are there other people like you besides, affiliation with Mannor Law Group? Because you're only two, and there's a body of millions coming down the pike.
Yeah. So it is an all-inclusive cost depending on exactly what level of care navigation they're going to need. So it's one lump sum. Yes, it is just Nikki and I, but as Savannah mentioned earlier, we have a huge team, and our entire firm works together. So even though it's just us two, we've got a team backing us, and we've got Liz, who's our elder care coordinator, and Amy, who's our planning service director, working together to make sure that all of our clients' needs are being met. Out of state, there are some other law firms that do offer this type of program, but we typically take on really any case that we can handle.
I wanted just to add a little bit to that. So for years, we've been participating in the Life Care Planning Law Firm Association, and there's some folks from there that came today, and a group called the Dementia Focused Practice that focuses on providing services to families with loved ones with dementia. And I know here in Michigan that Shannon DeWall and out of Livonia is also doing some care navigation. Bill, anybody remember Bill's last name? Westerby. Out of Grand Rapids area is also doing some care navigation. C&T does care navigation a little differently than we do it, but they do have social workers on staff. They do. Danielle and I are actually doing a presentation in a few weeks where it shows how different law firms can implement this concept in different ways. So we have somebody from C&T, we have Danielle, we have somebody that outsources it, a lawyer in the Oakland County area that outsources this, but still, participates in that. So it's the more the merrier. Like you say, there's millions that need help, and so we want to promote this concept, and we'd love other lawyers to adopt it.
And like we said, it's a growing demand. There's probably going to be more as we continue on our path and through this journey of more law firms starting to implement this. When I first interviewed with Bob, I was like, that's kind of strange, a social worker at a law office. Like, wouldn't think of that. And now it's like a praise to anybody that I talk to that it's an awesome project to have, and it's an awesome opportunity to offer clients. I think there was a question over here.
I think so too.
Did anybody else have any questions? Okay.
Awesome.
Oh,
One more.
this man,
I'm coming.
What is the range of your practice then, like in the northern part of the state? Do you take people from all over the state then?
Yeah, so if it's something that we have some clients up in Alpena, Traverse City, we may refer out to some of the other attorneys that may be able to be more local, but we go anywhere. We have some all the way in Detroit.
We've been over to Saugatuck.
Saugatuck, yeah. So we handle kind of the whole entire state if needed. Yeah,
All right, I see you.
Savannah's getting her steps in today.
I know, that's why I wear my Fitbit. I charged it this morning and everything.
No, behind
Did I-
you.
One back.
Oh, whoops. Got distracted by my own Fitbit comment.
So elder law obviously can be really important for lots of different families, but it can be expensive too. I'm wondering, does Mannor law do anything for families that maybe can be cost prohibitive or maybe a little bit inaccessible because of how costly it can be?
Does that work? Yeah. Okay. So I mean, we do pro bono cases, obviously. We do cases. We have one right now that we're doing. And sometimes there's things that we can do where we can just give some advice. So we will often do that where they just need to do these 2 or 3 things. And so it doesn't make sense for them to pay us or hire us for that. And so we've got a process to do that. We also are very likely to refer over to Eastern Michigan Legal Services. Seth and the folks over there do a great job. And so, there's a limit as to how much we can do completely pro bono. Sometimes, and I'll just give you a quick example, we have a case that came in, 2 days ago or whatever, and they don't have a lot of money, but they know that they're going to need care for the rest of their lives, and there's a bunch of issues. There's a bunch of medical and legal issues. There's a bunch of advocacy and caregiving issues. They had about enough to pay us, and that was it. And but they were going to spend that anyway. That was just going to be spent down. That was it would have been gone, and honestly, it probably would have been gone, and they would have still been denied Medicaid. And so sometimes even folks that don't have anything, if they have, if there's issues, it's just, it makes sense because we have to do the spend down anyway in many cases. So, but we do, like I say, we try to incorporate, we have a mechanism sometimes to answer those simple questions. We'll take certain cases on pro bono, and then we'll take, we try to cooperate with Eastern Michigan Legal Services as much as possible.
Yeah, and the way sometimes I talk with families, like Bob said, they're going to have to spend that money anyway. So hire us, you get us for 1 whole year, and that's a huge benefit. That's a lot of support during that year's time to make sure we've got everything that we need to make sure care is coordinated. Any other questions?
Okay, we're going to see you. Promise I'll come to the right row this time.
What happens if your services are needed for beyond a year?
Yeah, so we offer a renewal. It is a percentage of the initial fee, so it is a little bit less expensive, but we do offer that renewal. It's another year of service, no matter what. Should someone pass in the middle of that service, especially for a married couple, we're still following the healthy spouse or the spouse that's still living with us. They get all the services no matter what for that year. Any other questions? All right, well, thank you guys so
Yes,
much.
thank you.
We've got a fun day, so if you do have any questions, you can always stop by and see Nikki or I throughout the day, okay?
All right, let's give it up. We're going to take a snack break. Go ahead and stretch your legs. We know it's early and you guys kind of all sat in and we pulled you over here before some of you were settled. So get up, stretch your legs, have a snack, have some coffee. Thanks to Amara Hospice, that gourmet coffee bar is rocking and delicious. And we will see you back here at what time, Liz? 9:45. We're going to get started again. Of standing up for what's right, especially when it comes to protecting our most vulnerable. They're here to arm you with the legal know-how to knock down any obstacle and empower our elders. So let's give a big hand to attorneys Kelli King-Penner and Melissa Dixon.
Man at his craft, but then his number came up and he was gone with the draft. He's in the army now, a blowing reveille. He's the boogie woogie bugle boy of Company B.
All right, good morning, everyone. How is everyone doing? Fueled up, ready to go? Let's talk about the exciting world of estate planning documents, right? All right, before Melissa and I get into some of the more particular portions of it, I want to lay some groundwork. Now, those of you that are repeat attendees, this is going to look really familiar to you. Repetition is really important. I talk about in our estate planning meetings a lot. I tell people I'm aiming for about 10% retention. So if we aim for about 10% retention over however many years you've attended, eventually you're going to be all the way there. So when Melissa and I go through our presentation, it's important to go through a couple of parts of this. This is the more technical aspects of this. When it comes to the substitute decision making, there are a lot of different functional parts of this. The part that we're going to get into more is the technical legal qualifications. You're going to hear a fantastic presentation later today from the Ombudsman's office that talks a little bit more on the advocacy side, the importance of substitute decision making. So as we go throughout the day, you're going to see these principles come up a lot. And I hope that this presentation serves as a little bit more of a groundwork for foundations that are going to keep building on. So the first one that we're going to get into is really a main point in our office. We talk about this very frequently when it comes to how we go about establishing whether or not someone can appoint an agent on their behalf. So whether that's a healthcare power of attorney, a financial power of attorney, the ability to sign estate planning documents, we are really talking about this idea of capacity. Now, you all are probably very familiar with this idea of competency. It is important to understand that those are two different concepts, two different levels of functioning that we're looking at. Competency is that ability to participate in high-level decision-making, right? So that's the ability to participate in our medical decisions, to understand informed consent, weigh pros and cons, understand risk. That is a very important level of functioning. What I typically deal with, and what Melissa and Bob and people in our office are typically dealing with, is this idea of capacity. And we're talking capacity, we're talking testamentary capacity, which is basically what level of functioning do you need in order to execute a will or another type of estate planning document. This is a much lower threshold than competency. So when we're talking about the ability for somebody to execute new estate planning documents, we focus on capacity. This is a legal determination, not a medical determination. And there's a very clear set forth of what establishes capacity, and it's basically very legal and involves some really weird terms. But it's basically boils down to, do you understand kind of what they call it the objects of your bounty? got nothing to do with pirates. The object of your bounty is, can you identify your family? Do you understand who these people are? Do you also have the ability to understand that you have assets? Maybe you don't remember the bank name after 4 or 5 mergers, but you understand that you've got assets, you've got a home, you've got accounts, you pay your bills. And then do you understand that you can appoint somebody to act on your behalf if you're not able to do that level of functioning yourself? So if you can't participate in that competency standard, you're appointing somebody else to be your advocate for you. As long as you can understand those concepts, you have testamentary capacity. So that's always something that we're looking at in our office when it comes to, in the care navigation, this pops up a lot, but this also pops up in the estate planning side as well. Do you have the ability to execute new estate planning documents? Do you have that testamentary capacity? You all probably don't deal with that side a lot. You're probably focused a little bit more on the competency side because that's more in the world that you're living with. They have to work together. The competency standard is also establishing when certain documents take effect. So we definitely need that standard. But we also need to understand that there's that lower capacity threshold as well. All right, kind of beat this dead horse at this point, but capacity is the most important thing. So when we're going through all of this stuff, remember, we're not talking about that competency standard. Sometimes these words are used interchangeably. I know I catch myself doing this quite often. It's that alliteration, that competency capacity portion of it. The biggest part of this is to understand that there are 2 separate standards, one legal, one more of a medical or professional determination. All right, the other thing that I want to talk about is documents versus planning. So as an estate planning attorney, I help people create estate plans. I help them execute documents properly. I help them decide about picking agents. Documents versus planning. The document is a tool in the toolbox. I don't know how many of you have ever engaged in DIY around your house. If you don't have the proper tool to do the job correctly, you might end up in a world of hurt. Estate planning documents are tools. Tools can be misused just like anything else. They can also be missing entirely if you don't have the Allen wrench that came with your IKEA furniture. You're not going to be able to put that together. The tools are really important, but they are not the only thing. Estate planning is also not a set it and forget it type of thing. Documents need to be reviewed, documents need to be updated, plans need to be adjusted as well. So whenever I talk estate planning, I'm not the easy button. I'm not coming in and saying, yep, here you go, we're going to fill out these blanks in a form, we're going to execute it, you're all good to go, see you at the end. That's not how any of this actually works. There is no easy button, and this is one of the things that I've seen. I'm sure you all have probably seen all the commercials out there of the easy online estate planning tools. Those are great when used correctly. I don't know that they're always used correctly. Tools need to be properly used. So it's important to understand those 2 dynamics when it comes to the documents are one thing, the plan is really what we're looking at. And the plan usually focuses, people usually are coming in and saying, this is what I want to have happen when I die. But how often are we typically just going from point A to point B that smoothly? We're typically dealing with a period of somewhat incapacity, whether or not that's a short-term or a prolonged illness. That, to me, is one of the more important parts of estate planning, is to actually plan for that incapacity period, to make sure that if something happens to you, that the people you love and trust have the power, authority, and understanding to do things that you can no longer do for yourself. So it's really important to understand that the document itself is not an end-all, be-all, and there is no easy button for this. That being said, you no doubt have a lot of experience with some of the documents that we're going to focus on today. Melissa's going to get into a lot on the lifetime documents, the powers. But you no doubt have seen these other documents in play, and I always think it's a really good refresher to go through and explain to people what the different types of documents do. Out of curiosity, and I won't shame you if you don't raise your hand, how many people in this lovely area have a will? How many people think a will avoids probate? All right. So here's one thing that there's very few definitives in the law. This is one of those things that is a black and white issue. A will by its very nature is probate. If we are relying on a will, it is basically going through that probate process. The will by itself means nothing. I'll get into a little bit of that later as far as kind of the examples that we use, but it's important to understand that a will is probate. Trust. Trust used to be, way back in the day, something only rich people had, right? If you had a trust, that means that you had a lot of money. You were probably doing charitable giving or some complex estate planning. Trusts are fantastic legal tools that kind of help bridge the gap between that lifetime planning and that death planning, because it can do both within one document. They're private, they're flexible, there's many different kinds. They can be very, very complex, like I talked about with the charitable tax planning, complicated assets, all of that. But they also can be really straightforward estate planning documents that helps keep control with your family. Wendy and I do a lot of meetings together, and one of the things that we typically go through is it helps keep it with the people you want it to and not the people you don't intend it to. So they're really fantastic tools. You might encounter people that have trust or that have assets in trust. The lifetime documents, like we said, Melissa's going to go over a little bit more. These are typically healthcare power of attorney and a financial power of attorney. HIPAA release also kind of pops in there as well. And then the differences between those documents and guardianship and conservatorship. That's going to be our main focus today. And I'm sure we'll have time at the end for questions, and we'll also get into a couple other forms as well, like DNRs and some applied authority. All right, so I promised I was going to circle back to the will. We use the example of a will in our office as a funnel. The big part of that as an example of why it's a funnel is, have you ever tried to put anything in the funnel and then walk somewhere with it? Is it in there by the time you get to your location? No. So we don't put things into a will. A will gets things from point A to point B through that funnel process, but that funnel process is going through the probate court. And even then, the will only controls specific assets. So typically the will is only controlling assets, so like a bank account that was in your name alone, maybe a car that was in your name alone, if your house was only in your name alone, or you and your spouse and you both have gone name alone. The will is only controlling those particular assets. If there's anything that has transferred outside, like a beneficiary designation, or it's got a joint ownership, and that has a whole different complication in itself, that's not being controlled by the will. But even then, the will doesn't mean anything until you file paperwork with the probate court asking them to A, admit the will, and then B, appoint what is typically referred to as an executor. Michigan has a sanitized term called a personal representative, but you're appointing that person to actually do the things in the will. The will by itself won't do any of those things until it goes through that process. So one of the biggest misconceptions that I encounter is that a will avoids probate. A will is probate. That is part of the 10% that we're going to retain today, is that will is probate. Trust. So trust, to counter the will example, we use the example of a little red wagon. Being that it's not a funnel, we can put things into a little red wagon and take them with us. I know my son is really big on that. I have a 5-year-old who's really into Transformers, and I mean really into Transformers. And he had show and tell yesterday at school. So he put all his stuff in his backpack, but let's say he put it all in his little red wagon and he took that with him. That's one of the best ways that I can actually show an analogy for a trust, is you get to decide where your stuff goes, who gets to play with it, and if he's not around, he's going to tell me who gets to touch his toys. It's the same type of idea with a trust, is that we can provide an ability to manage assets for while we're alive and healthy, we have control. While we're alive but maybe not able to manage our own assets, we're dictating what happens with those assets and who manages it. And then when we have passed on, it's saying who gets to inherit our assets. And there's a lot of different things that we can build within a trust. So you might have people commonly come up to you and say, oh, I'm the executor of my parents' estate. They might be meaning that they're named in the will or that they're named in the trust. It's really important to understand what hat that they're wearing. Because if they're saying they're executor and you're looking at mom or dad, they're not the executor at that point. They might be the backup trustee, maybe, if they've been properly named at that point. But it's very common for people to blend the hats. So it's important that we understand executor, will, trustee, trust. Agents are kind of used interspersed there, so we commonly refer to as an agent for a healthcare power of attorney or a financial power of attorney. Those are agents. But it's important to understand what hat we're wearing. All right, so again, why do we care about trust? Trust, avoid probate. One of my better functions of actually trust is most people don't understand that a will becomes public record after you pass. Aretha Franklin's estate is really learning this right now. They've found 3 wills, I think, for her. They kept finding them under couch cushions. All of that is public record. So anybody can go down to the courthouse and say, hey, I'd like a copy of that will. And then you can find out where the stuff is coming. Now, if you've got Aretha Franklin's money, you're making national news. But why do we care if we don't have Aretha Franklin's money? Well, it's opening up your family members, your loved ones, to potential solicitors, scammers, maybe creditors. They've got some issues going on there. All of those things that we can prevent by doing a trust. Because your trust, only people that are entitled to information get information on your distribution plan. So they're more private. They're a little bit more family controlled or loved one controlled if it's not the family that's in charge. Trust can actually even outline care for your kids. Special needs planning is has become a bigger area, which we were fighting common misconceptions on that for a long time, is that people thought that they just had to disinherit a special needs child. But they can't have any money, so I'm going to leave it this place. I can't leave them anything. There are some fantastic advances now with special needs planning that allow these people to have independence, dignity, make sure that they're being cared for in a way that's not going to affect their government benefits, which quite frankly is often their health insurance. So there are fantastic tools that can be customized for individual families, and trusts are one of the best ways to do that. So you do not have to be a millionaire to have a trust. You just need to have someone you love and care about, and you want to see that it gets to the right place. And that doesn't even have to be a person. Let's say you hate your family, you want to leave everything to charity. Great, we can do that. You just need to have, something that you love and care about.
Okay, so now we're going to talk about what Bob mentioned earlier, and Kelly as well, the substitute decision makers. So thinking about substitutes, they step in when need to, and when they don't need to, then they're only there when needed. So sometimes, or going backwards, our substitute decision makers are appointed in power of attorney documents. So they take the opportunity to appoint who they would want to make a financial decision, and that would be in their durable power of attorney for finances, and who they would want to make a medical decision or decisions regarding their health care in their health care power of attorney. So it's very important that our clients and our loved ones know that they need to take that opportunity to say who do they want to step in if they're unable to. So this concept of passing the baton, the document should only take effect, so it may be by its legal nature effective immediately, but it shouldn't be used until their capacity is lost. So they should be making their own decisions and taking care of their finances and making their medical decisions for as long as they're able to. And if they lose capacity or they're unable to manage those things for any reason, that's when that baton is passed. So that is an important note on why we call it a lifetime document, because the authority given to those substitute decision makers, the authority given to them in that document dies or ends when the client dies.
So basically no one should be using that power of attorney after mom or dad or whoever's named in the document has passed. They're trying to cash out the estate with the power of attorney, something's gone wrong. So they take off that power of attorney hat and hopefully they have another one that they're going to be moving on to. So from there, hopefully we can avoid a guardianship and a conservatorship, but if they haven't taken the opportunity to sign that power of attorney before they lose capacity, that may be the situation that we're in. So we're going to go over some power of attorney specifics. So for durable power of attorney for finances. So actually executing that document, anyone who has
competency or capacity, like Kelli mentioned earlier. The ability to say, I have bills, I have finances, I have a house, I know, like she mentioned, maybe I don't know who the bank is anymore because they've merged 5 times, but I have some things that may need to be managed, and I know who I trust. So if I can't do that, then I want my spouse to do it. And if he's unavailable, then I want my child to do it, and pick the order of children or trusted family members or loved ones who would step in and handle those things if we were unable to. So when it becomes active, so the document itself, we have to look in the first couple of paragraphs because some of them will say right at the top, this is effective immediately upon signing. There are some that we call springing because there's a certain condition that has to be met before it can be used. In that situation, it's a doctor note or 2 doctor notes saying this person is incapacitated, they're no longer able to handle their finances. So in our office, we make them effective immediately because if we think about that situation, something has happened to me, I'm unable to manage my finances, and now my husband has to go get 2 doctor notes before he can take care of my affairs, that slows him down. But it's important to look in the document to see, is it effective immediately upon signing, or does that condition have to be met of the doctor notes before it can be used? So some best practices in using the durable power of attorney for finances is to annually review it, refresh your memory of who's appointed, in what order, check and make sure something hasn't been updated or changed. Actually, these are frequently updated. Our clients come to us and want to change the order around, or someone has moved out of state, or for whatever family dynamic, they may have changed it. And it's important to make sure that it was properly executed. So sometimes people try to do this on their own, maybe last minute try to throw together a document or pull it off of the web like you mentioned. These documents are supposed to be signed in the presence of 2 witnesses or a notary. And before the agent begins using it, the agent is supposed to sign off agreeing to those responsibilities.
Important thing to acknowledge too when it comes to witnessing is it has to be an independent witness. And what we mean by independent witness cannot be related to the principal, so the person who is signing the power of attorney cannot be anyone that they are related to. Really shouldn't be anyone that is in, I don't think there's a legal requirement for this when it comes to the financial one versus the healthcare one, but it really shouldn't be anybody that is employed by a care facility that they're living at, just as a best practice, because these documents are typically signed at the same time. And the notary has to be unrelated. Melissa and I are both notaries. I tell my family it's the most useless skill that I have for them, because I can't notarize for them. Don't swing by the office. I've got 13 notaries at your disposal, but I am not one of them. So it's always important to remember when we're going over these things, look to see who witnessed it. It is very, very common that family members will have a family meeting, get together, and one of them will serve as the witness. Now, if they have an independent notary with a financial power of attorney, you're still in business. But if both of those are in trouble, then technically the document is not executed properly, and there is no kind of fail-safe for, well, we tried under the law. We really want to make sure that that's executed properly. All right, I'm going to get into this as well. This is a recent change. The world of estate planning it's not like super dynamic. Medicaid planning changes all the time. Estate planning, like once a decade, maybe we'll have something really kind of upheaval. Apparently we're due for this. The last update to the durable power of attorney statute, the financial one, was done in 2010. There was a new law that was signed into law on November 2023. It does not go into effect until July 1st of this year. But it is a significant change to the durable power of attorney for finances. So Michigan, in an attempt to become more uniform for people traveling intrastate, has adopted the Uniform Durable Power of Attorney Act. This is going to change how financial power of attorneys are done, for lack of a better term. What this was designed especially for, this came out a lot of the guardianship reform, and this was supported by the Attorney General for State of Michigan's office as well. But what this is designed to do is to provide some mechanisms for all of these things. I deal with durable power of attorney for financial issues probably 3 times a week. I'm usually dealing with a family member saying, I've taken it to the bank to get, because I need to pay mom's bills, and they're telling me it's no good. Well, it's not fitting with their policies. Michigan has currently no way to enforce those, to say, look, this is a valid power of attorney, this is the process by which we go about it, you need to accept this. We have some enforcement mechanisms when it comes to trust. We had no enforcement mechanisms when it came to the financial power of attorney. That's one of the things that this law aims to fix, is to provide an enforcement mechanism. So basically when a financial institution or a credit union or whoever it is that you're dealing with refuses to interact with the financial power of attorney, it gives you a process by which to appeal or allow them to reduce their liability so that they feel comfortable accepting it. That's one of the positives that we're hoping to see out of this law, but with any law, there's a lot of unknowns when it comes to this. One of the bigger unknowns that comes with this law is it actually incorporates a form power of attorney in the document. If you've heard me speak before, you've probably heard me talk about some of the dangers of forms. I'm not a huge fan of printing forms off the internet and executing them without an understanding of what the form looks to achieve and what the specifics are. Specifically, as an elder law attorney, there are things that we need in a financial power of attorney in order to help protect assets. And if it's not contained within the power of attorney and that person later lacks capacity, we are stuck in a position that might put the family at a loss of assets or a time delay or more stress because they have to go through the rigmarole of trying to get a guardianship or a conservatorship at that point. So whenever we're executing these forms, we have to understand what they're doing. And the form power of attorney is designed to help it make legal services more accessible, which is great. It's a great goal to have. But it's just like anything, we have to understand what we're granting somebody to do. I've looked at the form power of attorney that's within the statute. It's very minimal, which usually most of the forms are, is they're very minimal. I have some concerns that it doesn't fully address a lot of the questions that I'm getting from financial institutions on a regular basis. I specifically, will send our powers of attorney, which are very expansive, and they'll tell me, well, you can't cash out this account because it doesn't say you can cash out specifically this account. Well, it says all accounts. All. It's not included as part of that. So I have some concerns that the form isn't as expansive as what I'm seeing on the front lines of this. So what I am recommending to people is to kind of proceed with caution when it comes to this. There are some good things I think it's trying to do, specifically that it's trying to make it limiting more for potential abuse or misuse. That enforcement mechanism is one of the things I'm more excited about because I'm usually dealing with this on a regular basis. I have some financial institutions that'll just outwardly reject everything. Everything. Even they tell me it needs to say this. Okay, make it says that. No. Okay. I think it'll provide a little bit better of an enforcement mechanism for those kind of routine rejections. But it's like with anything, it remains to be seen. It does include a couple of new provisions in terms of how a document becomes durable, has a slight new definition of incapacity. Nothing that's going to super upset most of, I think, good estate planning powers of attorneys that I've seen, specifically like our office. I know a lot of the other attorneys that Bob had mentioned previously, I know do really good, thorough powers of attorney. But the dangers of the forms remain to be seen. And whenever you've got a form and you don't understand how you're filling it out, there's always a danger for that. We're optimistic to see how it's going to go about. One of the things, though, that I really want to point out is that if you have an existing power of attorney, this law does not make that invalid. It is allowing any powers of attorney that were executed previously to continue. So it's not saying, okay, everybody has to run out and go get yourself a new power of attorney. However, whenever there is a major change in the law, I typically recommend an update whenever it's possible. Not because I think that there's any concerns with my powers of attorney, but because I don't want to have any other potential roadblocks that the families are going to interact. So if this new law takes effect and somebody thinks, well, that means that all the other ones are void and that everybody starts over again. Sometimes it's just easier when it's possible to get a new power of attorney signed. This is probably one of the most frequently updated documents in our office, are the financial power of attorney and the healthcare powers of attorney. And really they should be. Those should be the ones that we're nurturing as part of that estate plan, that we're looking at these things more frequently to say, okay, so you nominated your daughter. Your daughter moved to California and doesn't talk to you anymore. Maybe she's not the best person in that position anymore. Or maybe you would never have trusted your son when he was younger because he spent all his money on Transformers. That's what I'm worried about. But now, you know, he's doing great. He's got a job, a family. He's in a perfect scenario for that. Absolutely, we want to update that. We want to reflect wherever our current state is. So these should be looked at regularly. What happens when you die is important, but it really isn't the main focus of estate planning. And I think that's a big misconception with everyone is, you know, when we die, things are going to go the way that they're going to go. But while we're still here, I very much care what happens to me or what happens to my loved ones to make sure that they're taken care of if I'm no longer able to do that. So that's one of the things that we really need to focus on. And this Uniform Durable Power of Attorney law is a big thing. And we're going to talk a little bit about this more in Hot Topics. But that is definitely one of the major changes that we've seen probably in the last decade is this update to this Uniform Durable Power of Attorney. There's always good with bad when there comes legislation. There remains a lot to be seen. I doubt that this is the end of it. It's probably a starting point of some adjustments down the line.
And we'll be excited to provide you an update next year. So we'll have 9 or 10 months under our belts with this.
I actually have 2 seminars that I'm going to this summer to meet with a lot of those other professionals that Bob talked about of how we're all adopting this and how are we rolling it out to best serve our clients. Because this truly affects every single person that I interact with in our office. Every single person, from our care navigation clients to our estate planning clients. This is something that impacts everyone.
All right, so that is finances. We're going to move on to healthcare. So same idea. Our clients and our patients have appointed someone, hopefully, in the healthcare power of attorney, also known as a patient advocate designation or a PAD. Sometimes our clients call it a living will or a DPOA for healthcare. So in that document, they've listed who can make a medical decision for them if they are unable to. So the important distinction with this one is for as long as they can make their own medical decisions, they are. So it's only effective until they are unable to. Or it only becomes effective when they are unable to. And by reading the document itself, they're all going to look a little different. I've seen ones that are hardly a page long, where it may just say, in the event that I'm unable to make a medical decision, I appoint my spouse. It may give them some authority to withhold or withdraw future treatment. That could allow them to die. It may say a few things like that. I've seen ours is much longer. It gives our clients an opportunity to go through and answer a few questions about how they actually want their health care to be handled. I've seen ones that have blank lines where they can write limitations. So it's important just to read that document to see who they've appointed and what those specific wishes are. A healthcare power of attorney, again, is they're living, unable to make their own decisions, who are they appointing and how do they want that handled? That is different than a DNR. So we're going to touch on the DNR as well. Also in the healthcare power of attorney, there should be a provision that says whether or not they're authorizing someone to make any mental health treatment decisions for them. So you should be looking for that as well. Some healthcare power of attorney best practices. Try to make sure you have a complete copy, like Bob said, or Kelli scanned sideways. We've got pages 1, 4, and 5. Do your best to get the whole document, review it yearly to see, refresh your memory, who was appointed, what were their wishes. Again, checking for updates, making sure that nothing has been changed. Continue to remind yourself that if that person has capacity, they're making their own decisions, and that comes and goes sometimes. So we won't even be looking to that document if that person can make their own decisions. Also making sure that it's valid, so like Kelli mentioned earlier, unrelated witnesses. The document should be signed in the presence of 2 unrelated witnesses, 2 people who couldn't benefit from this decision, 2 people who are not appointed in the document, just completely unrelated people.
Which is different from from the financial power of attorney. The financial power of attorney allows a notary to sign in witness of that. The healthcare one does not. It specifically requires 2 witnesses. This is one of the problems that we had during the pandemic, is that we did not have access to people in order to witness these documents, and none of you working in the facilities could witness for them. So we were able to do it through a remote notarization and witnessing law through a temporary executive order. Currently, there is no such law in effect. Stay tuned for more on hot topics. But it is one of the challenges with the healthcare power of attorney when access is a problem. Even access remains, I know you know this, I'm preaching to the choir, access remains a problem, not in the pandemic. People that can't leave their house, that live in remote areas, that maybe are isolated either by their choosing or mental illness. Access is a continuing problem that is going to be something that our professions deal with. So it's important to understand the witnessing requirements of this.
Okay, so the power of attorney documents have given our clients and patients the ability to appoint for themselves who they would pick. That's the ideal situation, but sometimes we're in a situation where the court is appointing the agent. So that would be in that scenario where they don't have the capacity, they really can't name their children, they don't know what they have, they can't even meet that basic level. So in that scenario, if they have failed to sign a power of attorney and they have lost capacity, now we're in a situation where the court is involved. So the basics of that, there is a court process. I'm going to talk a little bit more about that. It is very restrictive. We do proceed with caution on these to make sure this is our only road, because it's very involved and it's not always the best situation. So we have to do an analysis to make sure that is in fact what is best. So those 2 court proceedings are guardianships and conservatorships. So just a breakdown of what the 2 are. Guardianship is when the court appoints a person and gives them the authority to make personal decisions for someone. So that's medical decisions, it could be where they live, but generally to their well-being. The conservatorship side is where the court appoints who would make decisions for their finances. So all of the financial matters would be under the conservatorship. So it does provide that oversight, and sometimes that is what's best for someone. They are unable to, and they need a different person to manage their guardianship or their conservatorship, but as it says up there, it limits their self-determination. It terminates their ability to make their own choices and manage their own life. So to give you some more explanation on a conservatorship, so what do they do? Again, generally the court is giving them broad powers to handle all of the finances. So sometimes they will restrict certain things, but generally anything that could fall under the finances, they would be responsible for. So the person would no longer determine their budget or what they buy or any of that. So their conservator would be managing all of their finances, paying their bills, filing their tax returns, anything of that sort. So how do you become one? So this is a court process, and it's not quick. It takes some time. So first it starts with filing that petition with the probate court. And so there's several things we have to show the court. But one of them is we have to prove by clear and convincing evidence that the person is unable to manage their own property or business affairs effectively anymore. So it's not a short term, maybe, but generally once we're going into this situation, we're showing that they are unable to do this anymore. So it's a pretty high burden to meet, and during that hearing, all of the interested persons have an opportunity to be a part of that and make an objection. The person who needs protecting, they have an opportunity to appear at that hearing as well. And the judge is going to grant or deny that petition. So, and then moving forward, I'm going to tell you a little bit about some of the things that pop up with that later, but just generally the court is going to be the one who gives the authority to the person. On the guardianship side, they're making all the personal decisions again, the medical treatment, the place of residence, all of their healthcare choices. So we've seen some of that frenzy in the media of a person being told they have to take birth control. That's what the guardian can do. So they make all of those decisions. And again, how do they become one? It's also a petition with the probate court and standing in front of the judge and proving that this person is impaired. And why are they impaired? It could be physical illness, mental illness, a deficiency of other sort, but that they lack sufficient capacity and understanding to make or communicate informed decisions. So they can't have that conversation about what's best for them. So that hearing will take place and the judge makes a ruling. And if so, then their rights are terminated to make their own decisions. And sometimes that is what's best. You may experience that on a daily basis. Someone who doesn't have somebody making those decisions, they clearly don't understand what's going on and need a guardian. So at the facility, you can petition for a guardian, but you cannot be one. And later today, again, the presentation later today is going to dig into this more too, so we're giving you a high-level understanding. So court oversight is more protective, right, Kelli?
Sure.
Not always. Not always. We have seen a lot going on with this in recent years. The person needs protection, a guardian or a conservator is appointed, and then sadly things go wrong. Their assets and funds are misused. So they're a victim of financial exploitation. Sometimes they're neglected and they're not getting the care they need. This person probably has all of their own life going on and now they're guardian or conservator of someone else, and sadly things get missed or are not handled correctly. Sometimes they're physically and emotionally abused. So just because the court is involved does not mean that that's a perfect solution.
And the court isn't necessarily trying to do a bad job on this. They're overburdened with a lot of these. The court has very minimal time to thoroughly investigate these, to make sure that the wards are being protected, that they're not being exploited. And though it's become more center stage, it's made national headlines for some horrible reasons, it's still not going to fall on the court to supervise these things. Frontline people typically will be witnessing possibilities for abuse much quicker than the court's going to see it. So there's problems with these. There's no perfect solution for it, but just because there is a guardianship or a conservatorship involved, we don't assume that everything is going correctly.
And so court troubles, what we mean by that is, really just getting through that process, even once the judge says, signs the order, yes, this person is now a guardian or conservator, we're not done. There's reports and things that have to be filed starting at 56 days and every year thereafter. There's times we have to stand in front of the judge for certain things yearly, sometimes every 3 years, and then even if you want to terminate a guardianship or a conservatorship, there's an entire process for that as well.
Yeah, it's not a job you can just quit. You can just say, I'm done.
Right. So, all of that being said, we, of course, prefer that our clients and patients have signed a power of attorney. They've picked somebody who can step up and act for them. If not, we're in the court process and we make the best of it. That's what we have to do.
Absolutely. So one of the things that we want to talk about in terms of one of the things that have come out of some horrible situations. How many of you are familiar with the battle that Casey Kasem's family went through? Yeah, so awful stuff. I had an opportunity this past year to see Karrie Kasem speak on the legal battle that her and her siblings went through in order to visit her father who was dying. And had been isolated by his wife at the time and moved around in secrecy, and just some terrible things that have gone on. So as part of Karrie's experience, she has gone around to several states' legislatures to promote the ability for families to prevent this isolation, this exploitation, in order to visit people who are incapacitated and otherwise being isolated by the person who has care and custody of that person. So Michigan adopted its own version of the Casey Kasem law. This was done back in 2020. If you're an absolute nerd and you want to read the statute like me, MCL 700.5306 subsection C is the area that provides this. It became effective in March 2020, and it has 4 prongs that need to be satisfied in order to grant a visitation. So this is what it is doing, is to promote visitation amongst somebody who is being isolated by court order. And if you don't comply with a court order, you can get in a lot of trouble. So that's what this is basically designed to do. But there's 4 prongs that need to be satisfied. You have to prove that the person that you want to visit is incapacitated. Not that they just don't want to see you. So you have to prove that they are incapacitated. You also have to prove that another person has care and custody over that incapacitated person. Your third prong is you have to prove that the person with care and custody is denying access to visit the incapacitated person. And the fourth one is you have to prove that the incapacitated person desires to visit with the person who is petitioning, or that it is in the best interest of the incapacitated person to visit with this person. So what this is designed to do is to prevent those isolations and those potential abuse cases from a family member that is swept in and isolated a loved one. It's just like anything with court stuff, there's always good and bad, but this is designed to provide that enforcement mechanism. Even if that person who is shielding them, in Casey Kasem's instance, it was his wife had guardianship conservatorship over him. So even in circumstances where there is a guardian who is isolating that person, this law allows petitioning for visitation access. The other thing that I want to get into is some of the emergency situations. So Melissa talked about it's an ongoing kind of process when it comes to petitioning for guardianship or conservatorship. There is such thing as an emergency guardianship. There is no such thing as an emergency conservatorship. So let's keep those two very separate. Emergency guardianships are allowed by state statute, and that's basically in circumstances where there is a life or death scenario. There is no one who has the ability to act on behalf of this person. We need the court to appoint somebody as soon as possible, and it can be appointed in as little as 1 day, if at all possible. You got to provide sufficient facts for this. I know a lot of judges that are going to judge that life or death standard very strictly, that there truly has to be something, not that the person is otherwise stable but there's nobody able to make a decision for them. That is not necessarily rising to that life or death scenario. You got to know your probate court kind of going into this as what justifies it. We had to look at one in Oakland County recently, and Oakland County has an actual instruction for all of this. It's fantastic. But it lays out the criteria that you need to set forth and prove. That if you're going to go in and ask for that, here's all the documentation that you need. Not every court does that. So it's important to kind of understand what your court is going to be looking for. The statute gives a good framework for it, but certain courts are going to have more particular provisions for it. Petitions for instruction, they're very helpful and underutilized tools, I find. So petitions for instruction are basically asking the court, what do we do? Here's the scenario, we're not sure what to do. For frontline people, they can help reduce liability, that if there's certain things that are going on and you're being told to do one thing and someone else is telling you to do another thing, and we're not clear what's the best path, you can petition the court to say, tell me what to do. And then it'll be a court order that you're following instructions for. So we use them in a couple of different ways, but they're very flexible tools, are those petitions for instruction, and sometimes those can actually head off, be very proactive in preventing issues later on. Then there are some family consent laws. I'm going to get into a couple of this, and this dynamic is changing a little bit. We'll get into this a little bit more in hot topics, but there are some implied consent laws for when we don't have any of these things. We don't have a power of attorney. We don't have an agent. We don't have any of those things. What are our options? And currently there are 2 state statutes that deal with this in particular. So the implied authority. So there's 2 state statutes that provide some implied authority for all of that. The first one is the Social Welfare Act. The Social Welfare Act is providing a mechanism for people that are in a skilled nursing facility or are otherwise on Medicaid, that if there is nobody stepping up to be someone's advocate, that you can get consent from a family member. Now, it's an implied authority, so it's not the greatest level of explicit authority. So it's not a court-appointed agent. It's not somebody appointed under a document. It's saying, hey, look, if it fits within this criteria, these people can make informed consent. There are some problems, being that it's implicit, so you're not necessarily fully covered. It's not clear always who gets to make that priority decision. There is no set priority. Family disputes can still happen. If you've ever tried to get people to agree where to go to dinner, now escalate that to what kind of care mom and dad are going to get. You're going to have problems. The other implicit authority is the Dignified Death Act, and this is limited to specifically those that are terminal or expected to pass away within 1 year, and that's basically if nobody can provide informed consent, there is a mechanism under the Dignified Death Act to allow a family member or next of kin to make that decision. As I've indicated, though, there are some problems with this. There is no clear-cut authority of who that priority is. That's probably the biggest problem, is that it says, okay, next of kin or a family member. Okay, how is that defined? Especially if you've got families that have 15 kids. Okay, so am I gathering 7 of them? Do I need all 15 of them? What do I need to do in order to move forward with that? Now, if all the family members are getting along and there's no issues, this implied authority can be quite helpful to avoid the trauma involved with trying to get an emergency guardianship or to go through that process. But these are very limited authority. Now, Michigan is hoping to change some of these things. There's a proposal to change the Social Welfare Act to make it a little bit more broad. But as we'll get into hot topics with that, there's some pros and cons with that as always. All right, DNRs. This is probably one of the biggest questions that I get in our office as far as, can you do a DNR for me? I want to be very, very clear on what a DNR is. A DNR is not a legal estate planning document. A DNR is a physician order. It's not something that I can draft for my clients and pop it into their estate plan binder and say, yep, look, you're all set with your DNR. DNR should be very specific to someone, and they should have some medical counseling as part of that by their physician, because this is a physician order that's done as part of it. DNRs are typically done in circumstances where people have long-term chronic illnesses or terminal illnesses to the point where we are concerned that those heroic measures may cause more damage than good, or that they just simply would not want to go through that. Those DNRs are allowing people to have more of that self-determination portion of it. And we've got the legal authority thrown up on that. So one of the more common questions that I get is who can sign DNRs? And there's a couple of levels of DNRs depending on what's going on. Who are we dealing with at this point? So obviously the patient or the resident or the person who is the subject of that can sign a DNR if they are able to. So if they have the ability to talk with their physician, understand everything that's being told upon them, they can of course sign a DNR and discuss the requirements of that with their physician. If they are not able to, we've got some other people that might be able to, and I say might because it depends on what the rules are for them. A patient advocate, so that person who is nominated under a healthcare power of attorney, may be able to sign a DNR if the document allows them to do that. So that's why it's important to look through the document to see what authority the agent has. And even then, we should not be looking towards that person if the principal is able to do it for themselves. So if they're able to understand it, we shouldn't escalate it to a side person. It should always be the person first, and then if not the person, next person in line. The patient advocate does not authorize signing a DNR. We might want to consider going to the court for that petition for instruction or some other mechanism. If the person's able to sign a new document, great. But the patient advocate should only be doing that if it's allowed under the patient advocate document. So that's why it's important to look at these things. Have a clear copy of it. If you're missing that page of it, it's not going to do you a whole lot of good when you're like, well, we relied on the patient advocate. We need to make sure we've got everything for it. And then to also make sure that it's valid. So that's why those execution requirements are really important. Guardians, can they sign a DNR? Yes. There is a clear authority after 2014 that any guardian that has been appointed post-2014 can sign a DNR on behalf of the person. If there was a guardian that was appointed prior to 2014, what I normally recommend is that it might be best practice to get court clearance for that, especially if there's an active guardianship. It's not super challenging for a court to receive that petition for instruction to say, hey, just want to make sure, is this okay? That way it's covering the guardian, it's making sure that everybody is like on the same page when it comes to that. But that's really only pre-2014 guardians. And I'm specifically talking incapacitated individual guardianships. Developmentally disabled guardianships, whole different process. That's actually governed by a separate act. So I'm talking adult, legally incapacitated guardianships under EPIC, so the Estates and Protected Individuals Code. If you've got a developmentally disabled guardianship, I would recommend getting court authority for that prior to doing a DNR in general, those operate very differently. So in order for a guardian to sign it, though, there has to be some requirements with it. So the law requires that the guardians visit with the patient within 14 days prior to executing the DNR. If possible, the guardian should communicate with the ward as much as possible about signing the DNR. So if they're still able to have that conversation about it to the extent possible, they should absolutely be discussing that with the person. And they should also consult with the physician. The treating physician should also be part of that consult. And again, it's a physician order. So they should be involved in that in general to make sure that they have it. And again, if you don't have all your ducks in a row when it comes to that, consider getting that court approval. And that process, that whole review, communicate with the patient and the doctor should be done every year by the guardian, just to make sure this is still what you want or that this is still in your best interest. All right, the validity portion of it. So a patient must be 18 years or older. This kind of generally applies for estate planning documents in general. You have to be at least 18, a legal adult. The DNR should be signed by the patient who is of sound mind to execute on his or her behalf, or by a validly appointed patient advocate or a guardian. Assume that they've gone through all their T crossing their I's dotting. Statute also requires that the patient's attending physician sign the DNR unless the refusal is due to religious purposes. The physician can opt not to sign it if it is against his or her religion. It also should be signed by 2 witnesses who are 18 years or older, and at least, this is a different portion of it, because they can't ever make witnessing requirements consistent, right? At least one of the 2 witnesses cannot be the patient's spouse, parent, child, grandchild, sibling, or presumptive heir. So one witness can be, but the second one has to be somebody unrelated. It would be so much easier if they just matched things for everything, but they don't. So it's important to remember that the witnessing requirement is specific. So we've gone all the way from financial power of attorney that doesn't need to be witnessed, could be notarized, to healthcare power of attorney, 2 unrelated witnesses, DNR. 1 witness is fine to be related to, but you got to find 1 outside party. So walking through those requirements, and these are all laid out in the statute. So again, if you like reading laws, it's fantastic for that. But they're pretty straightforward in terms of how they're written. Now, I'm sure a lot of people have questions on this stuff, and we've got some time built into it. What questions, concerns? I'm going to make Savannah run all over the place at this point.
Hello. Oh, there we are.
There you
Well,
go.
that kind of scared me a little. Okay, we have a couple microphone holders today, so we'll start here because you're closest.
I understand with the new DPOA law that it gives the agents additional powers. Is it like to execute a trust or?
Yeah, so what it specifically is included in part of that form is if the principal marks a box appropriately, it's extraordinary powers. Those extraordinary powers, they don't come with a cape, they don't make you a superhero, it's not Red Bull gives you wings. But the extraordinary powers are very important. It's literally foundational powers that we need as elder law attorneys to help protect assets. Now here's my concern when it comes to this, because in the form, you go through and read the form, it looks real bad. There's all these warnings that are like, don't do this, don't give this authority. It requires specific counseling, right, to understand what these specific powers do. Because if you read them, you're like, well, I don't want my agent to be able to make gifts to themselves. I don't want them to be able to execute a trust. You don't know how that necessarily is going to be played out. So the form does include those powers. They're not standard, so it's not like if you sign the form, it's going to be included. There are a section of them that they have to be, I think, initialed or marked. And they do come with a lot of warnings with it. My concern, and I think Bob's concern and Melissa's concern, we've had these conversations, is that people will skip that not knowing what it actually can do. And that's where that counseling element is really important. So yes, the extraordinary powers are in the form, but they're not default.
Savannah.
Good question. Okay, we got Danielle over here. Go ahead.
Hi, I work in a hospital, and so we've had a lot of issues with out-of-state medical power of attorneys because, like, our guiding counsel is telling us you need 2 witnesses in Michigan. Some arrives, they're notarized.
Yep.
And I say, well, the intention was that it was for this state, but they're on vacation or they moved to Michigan and had an accident the next day. And so how would you deal with that?
So we deal with it in much of kind of the same way. Normally, so Michigan snowbirds, right? We've got people that go, Arizona, Florida. Normally, if you're going to be located and you're spending significant times in portions of other states, I normally recommend that you consult with an attorney in that state to have one of those. You'll head off a lot of your concerns when it comes to state-specific things. That's one of the reasons why the uniform durable power of attorney for finances, I think, is moving towards that, is to help head off that interstate travel. I counsel very much kind of similar that the intention is there. If I had to stand up and fight it, I probably would. But if you can be proactive about it, that would be my recommendation as far as like if you're spending a significant period of time. I network with a lot of attorneys all over the nation, and I would refer them to getting those powers in multiple places, specifically ones that have the multiple residences. The interstate travel, like if you're in Ohio and you get in a car accident, those are ones that I would fight up against to say, hey, look, they're a Michigan resident, this is what they had, this is who they're deeming it for. I would be willing to fight those. They're a little harder challenges to make. There's not really a good solution, but like you said, the intention being there is a good argument to make. Planning, bottom line, planning is still better than having nothing. So even if it's not in a perfect scenario, the fact that you plan is still better.
All right, we have a question over here.
Yeah, hi. Is there a credentialing requirement to be a guardian or a conservator?
So not currently. Michigan is trying to pass a bunch of guardianship reform bills. They're actually trying to create the office of the state guardian. Those currently have not been passed. There's a lot of bureaucracy involved of like where that's going to be housed, what's going to happen with it, but currently there is no credentialing for it. But that is likely to come about, I would say, in the next probably 5 years at the most, simply with the focus being on guardianship reform in the state of Michigan right now.
Kelli, we have a question over here. I have a couple questions about the DNR. So you get the paperwork from your physician, and then do you talk to the family? Who should have a copy of it? Should the hospital? Should you keep it on you?
Yeah,
How do you show that you have a DNR?
Yeah, so as part of the statutory requirement, it actually, after it's signed by all of those people, so after the person or the agent signs it, the physician signs it, it's supposed to become part of their medical record. Now, if they're transporting with it, I would recommend that the family understand what's going on with that. There is some legislation as far as the post form that's supposed to help outside of a medical thing. So if you're in one hospital and you've got a DNR in place that's part of your medical record, well, if you have an event at home and the EMTs show up, chances are they're going to perform compressions and do all of those things that they're supposed to do. There is a post form that is supposed to help kind of bridge the gap between different places. I normally recommend that those be consulted with at the same time. So if we're meeting with a physician, we're putting it as part of the medical record. Also discuss that post form, or I think national it's called POST. They add an L into it. Michigan it's called POST. I would recommend that those be discussed at the same time. But the family member should also, that should be part of the family meeting. That nobody should be surprised by these things. It should be, hey, this is what mom and dad wanted. This is what we go through. But I would recommend putting it as part of their medical record wherever they're going. So as part of kind of your mission paperwork. If they have a DNR, that is something that should be highlighted every single place that you go.
And Kelli, if you ask our care navigators, we'll tell you to staple it on the back of your door.
Yep.
So if EMT does show up, they can see it.
All right, we have another question over here.
Yeah, this is also regarding the DNR.
All right.
Before my mom passed, she went to the hospital several times. Once she wanted a DNR,
yeah.
Then she didn't want a DNR, and then she did again.
Mm-hmm.
So how do you
go about dealing with that?
Yeah, and the physician explained, we explained to mom, because she, knew how to explain things to her. But it's like, especially when she said she didn't want the DNR, we're going.
Well, yeah, you perks up. And I would say that experience is fairly common. I have that very frequently where people are adamant that, no, I absolutely, If something happens, I want you to do everything you possibly can. Then they might have a moment where they're like, no, absolutely not. I don't want to deal with this. And everybody's experience is slightly different. And that's why I say revisiting these things is part of that self-determination. It's part of that pre-planning, because we are entitled to change our minds. My favorite color is green today. Tomorrow I'm entitled to make it pink. I don't think it's going to happen, but it could. So as long as they're still able to participate with that, I realize the yo-yoing is very frustrating, but we need to take what they're saying to heart, and that back and forth can be very frustrating. Yeah, because you want to do the right thing. Yeah, and I would say that process in general is very complicated. I mean, we never know. When we're in our right minds, I could be like, yeah, absolutely, I want this. And then something happens and I'm like, I don't know that I want this anymore. So it's very challenging. And the biggest thing that I can recommend is that consistent communication and making sure that we're walking through everything.
Danielle?
Thanks. For the DNR form, you said one witness can be a family member.
Yes.
And the other can be...
An unrelated person.
Yeah.
Yep.
So I work for a hospice, and when the social worker will do consents, and part of the consents is the DNR form for the specific hospice. But we've always been told that we can't use any family member at all to witness that.
That's why I said these witnessing requirements aren't confusing at all, right?
Is there an act or something that's...
Yeah, so the DNR, and it's referenced in the materials itself. Let's see if I can find it real quick. The DNR requirements are different from like a healthcare power of attorney, and I think that's probably where the confusion comes in. Healthcare requires 2 unrelated witnesses. DNR can have an unrelated one. By practice, so this might just be kind of industry specific to say, hey, look, we're going to require 2 unrelated witnesses every time we see this. It's not technically required by the statute. The statute says one person can be related, but that's where the requirements can get fuzzy, because one statute's requiring something else for this type of agent. DNRs are requiring something different. So it's really important to kind of refresh and look over these. The DNR statute's pretty clear as far as reading who can sign stuff. The patient advocate one's pretty clear as well. They actually have a section on witnessing. But if you ever have questions, concerns, feel free to reach out to us. I'm happy to go over that stuff.
All right, we have one more question back here.
Regarding capacity.
Okay.
Who determines that on your team? And then what if it's disputed? Like, I've had situations where family members were like, they weren't able to make that decision.
Yeah, so capacity is a fun thing to go about in our office as far as how it goes. The attorneys are all very qualified to do it, but our elder care coordinators are very qualified as well to go through kind of those questions. If they question anything, they're going to bring in one of us, and we're going to make it, because capacity at its core is a legal determination. So when it comes down to it, if there's any question, Bob, me, or Melissa is going to be in there to make that determination, and I'm going to document it thoroughly. But we do have other members of our team who I'm comfortable with them making that determination. But at the end of the day, it's a legal test.
I wanted to add just a bit to that. So we use the capacity test, but we don't always use the capacity test. There's times where we say, okay, we probably want a higher standard here because we can see the family dispute.
Yep.
If there's going to be people arguing about it, we don't use the lowest standard. If everybody's in agreement, everybody is pointing in the same direction, then I do believe that we can use the lower standard as to whether they can sign the new documents or not.
Yeah, family disputes are always challenging, and document, and escalate whatever is appropriate. And that's why I say our team is great, that if they think that there's going to be a challenge, they're going to bring in Bob or Melissa or I.
Here we have one more question.
I remember going to a different elder law training and them mentioning that if someone has lost capacity but hasn't done advanced directives, instead of filing for like conservatorship or guardianship, if it would work out the same way and it would be the same people that would be spelled out in the advanced directives, they could still have them do advanced directives. Is that the case or no? So
it might be that they're confusing that competency capacity standard. Okay. I would say that that's probably more likely, but also it's a subjective standard to a certain extent. So some people's comfort level is going to be different than ours. But my guess is it's probably confusion between that higher level and that lower level, but it's really kind of a subjective test. Sorry, that's not going to be very clear. The law is, quite frankly, very shades of gray most of the time. All right. Well,
Great
Melissa and I
question.
will all be around if you guys have questions.
All right, thank you guys. If we can go ahead and give another hand clap for Kelli and Melissa. Okay, so now we're going to go ahead and shift gears and head to the Elder Care Science Lab. So just like any good scientist, navigating the world of Medicaid, Medicare, veterans benefits requires the perfect formula. Today, Amy and Bob will be mixing and matching the elements to create a plan that best serves our clients, your residents, your patients. And it also helps you help them. So grab your lab coats and get ready to experiment with attorney Bob Mannor and Amy Persails.
Elastic tubes and pots and pans, bits and pieces, and the magic from the handle make it weird science. Oh, things I've never seen before. Behind bolted doors,
Okay. So, when we're dealing with government benefits like Medicare, Medicaid, veterans benefits, lots of other initials and such, one of the things that it's a struggle is helping families understand why it matters or how it fits in. So what we're going to try to do today is instead of just kind of going through those programs, we're going to kind of walk you through the way we walk our clients through it. And because a lot of people assume, and a lot of you probably know this, that a family, lots of families believe, they've heard of Medicaid, and they think, okay, if you run out of money, no matter where we're getting those services, we'll be able to have Medicaid pay for it. That's not true, right? And so that's a hard thing to get over. And so what we want to make sure that people understand is different programs fit better in different living environments, different care environments, things like that. So we're going to focus on the programs just like we always would, but we're going to try to put it in context because, you know, we have basically three, I think this is an accurate way to say it, we have basically three types of calls that at our office. One is what we call planning services. So that is involving anything that you've heard about from the care navigators to basically anytime somebody needs care. There's a dementia diagnosis, there's a care issue going on. We've got estate planning, and then we've got estate administration. So they're alive and well, they're sick, or they're dead. The three basic types of cases that we're looking at. And so Amy is the director, or the director, is that right? Okay, director of planning services. So she runs that department, and so she's going to help us through this process that we look at to try to make it more useful. This one will work better? Okay. All right, let's see what we got. Okay, so in other words, something's happened. So we're going to be talking about planning services now. We just talked about estate planning. We're going to talk about planning services. So in the context of the family's understanding of this, it's what should we do? Where should we go? And how are we going to pay for it? And that's basically the questions that, now they may call up and say, we need a power of attorney. But when we always ask the question, well, why do you need a power of attorney? Because the vast majority of time when they're calling us, it's because something bad happened. Dad falled, grandpa doesn't recognize grandma anymore. There's some reason why they're asking for that. And so we always dig in, and what their real questions are, what should we do, where should we go, and how are we going to pay for it? All right. Okay, so this is I'm going to have to step down a little bit so I can see the screen a little bit better. I'm getting a little old. So, Amy, tell us a little bit about this form and why we think it's helpful.
Okay, so obviously we've seen this form already today a few times, and you'll see it a few more times today. But the level of care form helps us narrow down options, gives us more ideas of the better options for our families, whether they should be at home with care, or if they are in independent living or should go to an independent living. One of the things that we deal with a lot is the wife has some memory issues and she needs care, right? But the husband is also having some issues. He's falling. He needs a little bit of help. But they want to stay together. So how do we do that? That's one of the things that we deal with a lot, is trying to figure out the best place for both of them that maybe they can either stay together or be very near each other.
All right, I'm going to trade places with you, so you don't have audio feedback. So
Okay.
you probably have to. And my eyes aren't that good that I can look at this without looking closer. So, why is this valuable? Well, there's a couple different things. Families come in sometimes by the time and they see you or they see us, they have certain ideas in mind. A lot of them are not based on the real options that they have, but sometimes they've already kind of come to certain conclusions. And one of the things that we notice over and over again is that they're having difficulty seeing beyond the next 7 days or so. And so they say, okay, well, it's going to be okay because Susie's coming home from California and she's going to stay there for the weekend. And then Roger is going to be able to take a couple days off. And okay, so great. First of all, and I don't mean to be crude, but are you going to be cleaning up after your parent when they're incontinent? Or, sometimes the answer is absolutely yes, but some families aren't necessarily thinking that through. Oh, I'm going to have to shower my dad. Oh, I hadn't thought about that. And also, secondly, they think, okay, well, this is what we can do. We've already scheduled for the next 7 days. What was it that, I think it was Nikki said that sometimes people think that they're going to be doing somersaults out once they get out of the rehab facility, the skilled nursing facility. And the idea is, it's hard. Sometimes it's a denial, that they're in a bit of denial. They just want it to go back to the way it was. And so what we try to do is then walk them through this chart to say, okay, well, what are the reasonable options? And I'm not saying this is the only reasonable options. These are just the probably the most common. So go back home with care, okay? Often that's people's first instinct, and that's a good instinct. Then I like to make sure that we specifically point out independent living, because independent living is a different category the way I look at it. The way we look at it legally and the way we look at it in conjunction with government benefits is it actually is sometimes easier to use government benefits when we're in independent living, and because we pay 2 checks, right? We write 1 check for room and board, and we write 1 check for care. And so if we're getting those care services through waiver, maybe even PACE, we're getting those care services through, whatever program that's out there, through maybe the senior millage, whatever it is, it's easier to associate that with the independent living because we're already writing 2 checks, right? So it gets a little bit more difficult as we go down the line, and now we got adult foster care, we've got assisted living, we've got memory care. And the thought is, okay, well, how are those going to interact with waiver or PACE or other programs out there that can pay for care, veterans benefits? Veterans, well, we're going to get to that in a second. Skilled nursing, okay? And so sometimes what it's helpful is to at least kind of have them understand the categories that we're looking at. And on hospice, a lot of people don't understand hospice. When I was in my 20s, my experience with hospice was they'd come in the last few days of life, they covered everything, full room and board, they had the family, it was a nice room, it was a room for the family to come and visit while your loved one was dying, and it covered everything, and we never got a check, we never had to pay for anything for 24-hour care. Is that still around? I guess, but it's not around very much. That's not what most people experience on hospice. So hospice can be great, but that's what a lot of people's mentality is. If I didn't practice in this area, I'd probably still believe that because that's what I experienced 20 years ago. 20 years ago was in 2000.
Just keep with it. Just keep with it. It's okay.
It wasn't 20 years ago.
Okay.
It was a little longer than that. But
you don't have to age yourself.
20 years ago is still 1980 for me. So,
yeah. Right. Me too. I agree.
So then I put in, because I did present this to lawyers, I put in some of the licensing. Some people are interested in what the licensing is. The only one I find that it's important to really know about the licensing is that last one, skilled nursing. And the licensing in Michigan is actually a nursing home license, okay? All of the licenses have kind of old-fashioned names for them. So the ones that we're most likely to see is nursing home, a home for the aged, and adult foster care. And all of those kind of sound old-fashioned, adult foster care, home for the aged. We don't usually like, using that. Now we like to use assisted living and memory care and things like that. There is no licensing in Michigan for assisted living. There's only a licensing for memory care is if you already have a nursing home license. So the vast, vast majority of memory cares out there don't have a memory care license because it's only an add-on to a nursing home license. And so why I often will look at that website on the skilled nursing column there is because that'll tell us how many beds they have, how many beds are dual eligible, all those types of things. Just for the family's perspective, we did put a column in there, is it a locked facility? This is difficult sometimes. We don't always have to have a locked facility, even if somebody has dementia. But we want to look at that, and sometimes people get really focused on that, oh, it's got to be a memory care. Well, that one place doesn't call themselves memory care. Well, what we know now is memory care is not a specific license or defined by law in Michigan unless you're already a nursing home. And so most of the memory cares out there, and I say this with due respect and with knowing that memory cares can be really great and the best place to be. Absolutely. But it's a marketing term, and I don't mean that in a derogatory way. It's marketing in that they get to define what memory care is, and most of them do a great job with it. Mm-hmm. But they don't have a definition of what memory care is, and so one memory care may offer different services than the other memory care. Okay. So that's where I want clients to kind of get some perspective on this. All right, next one is, can it be covered by VA? So the next two columns are, can it be covered by, let's do the next column. Is it covered by Medicare or health insurance? All right, so a lot of times we'll see this where people think they're going home and they say, well, they're going to set us up with a nurse and they're going to set us up with people coming into care. And we always have to remember, okay, that's skilled. That's skilled care. That means they're going to maybe send the nurse by physical therapy, occupational therapy, all those types of things. But there's not going to, unless we get it through a different agency or different services, they're probably not going to get you up and dressed and showered in the morning. They're probably not going to shave you in the morning. That's not usually covered by Blue Cross or Medicare. And so we want people to kind of wrap their heads around it because all they're hearing is, oh, your Medicare is going to provide care in the home. Maybe for a few hours a week, well, the therapist is there. Well, the nurse is there to take in the blood pressure, things like that. So trying to get the family's head wrapped around that. But most of the other ones, it's a limited time or a limited amount. Then now we're looking at the next two columns, which are both veterans. So the first question is, are they a veteran? If they're not, then we can just cross out those columns. But the portion paid by aid and attendance. If they can qualify for aid and attendance, and we've talked about this through the years many times, there is a benefit for certain veterans that serve during a certain period that have at least 90 days. We're going to go through it in a minute here, but the idea is if they qualify, this is great because it's cash, and we can use the cash in any of these settings. And so it's a great option. Now, they put a lot of restrictions on this a few years ago. Back in 2018, they put some asset restrictions on it. So we're going to come back to that in a second. I just want to get through the chart. The next one is highly overlooked, and that's VA healthcare, health services, and compensation benefits. Often we call that disability, okay? So the VA has some great options that they can, unlike Medicare, and I know if I had any, well, I know I have a few lawyers in the audience, I'm saying this wrong, they can prescribe home care. Now, I know that's not the words they use, and that's probably not technically accurate, but in the way a layman's perspective is the VA doctor can prescribe home care where a regular doctor can't prescribe home care. If they're eligible for health services through the VA, and there's a whole chart as to whether they're eligible or not, they can prescribe home care. They can prescribe adult daycare that could be covered by the VA if they meet certain requirements. They can prescribe nursing home care. If you're over 70% service-connected disabled, they'll pay for the nursing home. Now, it's only the nursing homes that they have contracts with, so sometimes it's hard to find one of those. But this is a great option that a lot of people forget about. I can't remember if it was Danielle or Nikki that talked about the baby boomers, and now we're getting into the Gen X. Well, this is going to be our clients in the real near future. It's the Vietnam generation, okay? Anybody in Vietnam is presumed to have been exposed to Agent Orange. If they put boots on the ground, or they were in the blue water or brown water around Vietnam, they are presumed by the government to have been exposed to Agent Orange. So we're going to come back to that. So those are often overlooked benefits. What we're trying to do, what I'm trying to walk you through, is what we do with the client. To go through these benefits, not just the standpoint of here's what the benefit is, but to say how is that practical. So when we can get VA, it's often we can use in any of the circumstances. If we can do VA health care, we're probably going to be limited to whatever the VA has a contract with, and having to deal with the bureaucracy of the VA, which is not easy. So we were trying to place somebody who was over 70% compensation, service-connected disability, and I thought I had found this website that showed us all the VA-connected hospitals or nursing homes, and that would accept or had the VA contract, and I called a bunch of them. They're like, no, that's not us. And so we ended up going, what is it, in what township?
Chesterfield, yes.
Yeah, Chesterfield's the new VA one. And so we thought we were going to be able to get closer, but we couldn't. All right, then the final three. These are the big ones, right? PACE, waiver, and what I'm referring as long-term care Medicaid. Basically, that's your traditional nursing home Medicaid. So you notice in the first two columns, PACE and waiver both have an income limit. All right, we're going to talk about that a little bit later, but if we know that our client, or the one that needs help, it doesn't meet the income limit, I can cross that off of the chart. Because a lot of them are thinking, and this happens sometimes, I know there's a lot of confusion when it comes to Medicaid and the PACE and waiver, so they might go to some place and they say, oh yeah, we accept, they might even go to independent living and they'd say, oh yeah, we accept PACE or waiver. But then we got to tell them, well, not unless you want to private pay for it because your income's too high for this. And so I want to make sure that they're setting their mind straight as to which options they have. If they can't afford it on their own, if we need to preserve some assets for the spouse, whatever, we've got to cross off a bunch of these options, because if you can't afford it, you're not going to, stop looking around at places that don't meet that qualification. But you see, with PACE and waiver, they work well at home, they work well at independent living. When we get into adult foster care, assisted living, and memory care, there has to be an arrangement or an agreement between the PACE program or the waiver program and that place. Okay, why? Because, waiver is, you can get waiver in your home, and your home is wherever you live. Okay, so it could be your house, it could be your daughter's house, it could be an independent living. But then, if it gets to the question of adult foster care, assisted living, or memory care, do they break up their bill? Can we set it up so that, that they already have a contract with waiver or contract with PACE to do that? You don't necessarily just get to pick free range and qualify for waiver or PACE in these programs. And then finally, if you look at that last column, you see a bunch of no's. This is what people think often when we say Medicaid. They think, oh, this whole chart is Medicaid. Every place that I've listed here, I can get Medicaid. But if they're over that income limit, it's only the one that pays for room and board and care, okay, in most circumstances. PACE can in some circumstances, but it's limited. All right, having said that, now I think we can switch places again.
Okay.
Okay, so talk to us about realistically, what are we facing, or not realistically yet, hopefully, what's the, when the client comes in, what are their experience, or what are we looking at?
So hopefully the families have given permissions to loved ones, trusted people in their lives that they want to take care of things for them. And they've planned ahead, right? So they have their power of attorneys, which Melissa and Kelli spoke about a little bit ago. So the power of attorney, letting someone help you pay your bills, take care of things for you, call someone to fix the water leak because you're out of town. That could be a simple thing. Someone asked me earlier, when is too late to do this? And I said, there's not an answer to that. It's never too late. We'd rather have you plan ahead, but it's never too early either. So we always want to make sure that you're prepared, and if you're over 18, you should always have these documents. Your extraordinary powers, Bob talked about, they talked about earlier, giving you authority, or giving your family authority to make healthcare decisions when you're not able to. So they only go into effect when you're unable to make your own decisions, and any of those surgery, you need surgery, you're in a surgery and they need to do another procedure and they need to get approval for that. So the family is able to make those quick decisions without anyone interfering in them.
So the idea here is that I know we've talked about this in the last presentation. You're going to actually hear even more about it in the long-term care ombudsman's presentation. This is so important. This is what every day, Kelli said 3 days a week. I think it's 5 days a week. And if we worked on Saturdays, it'd be 6 days a week. Every single day we're struggling with these things because we need to make sure that we're following the permissions that we're given. And if they have a form, or if the form is not valid, we not have legal permission. We jumped through so many hoops recently. Melissa will tell you this. So she drafted their estate planning, and we could only draft the estate planning in a very precise way because of the way that it was worded in that power of attorney. So that the wording matters. It gives permissions to do certain things and not certain things. Let's think about that in the context of somebody coming in, a married couple coming in and saying, oh yeah, we have powers of attorney. And we say, okay, well, your husband needs round-the-clock care. Are we going to be able to pay for that? And we said, well, we could probably pay for it for 8 months, but then wife is going to be impoverished. Wife will have no money to live on. Or, what happens if she needs care in the future? So we say, okay, well, good news is that there's a legal way in Michigan that we can protect that $80,000. But one of the first steps, there's multiple steps in this process, but the first step is we're going to have to move the asset out of dad's name and into mom's name. Your power of attorney doesn't let us do that. You say, well, it's mom and dad. They've been married 60 years. How could it not do that? Because what did we talk about with those extraordinary powers? The power of gifting. Does anybody think that moving money from dad to mom that have been married for 60 years is a gift? Well, the state of Michigan does think that, okay? And so if we don't have that, most powers of attorney that you see is actually going to say you can't transfer it to your agent. Who's your agent? Usually your spouse. So you can't transfer it to your agent. That means you can't transfer it to your spouse. You also have to have additional permissions that the Attorney General's office many years ago in Michigan has said that if it's not specific about it, even if the power of attorney said you can do anything I can do, Attorney General's office said, but you can't do this unless it's specifically outlined in the document. So that's why it's really important that we have, we always want, first question we always have and we struggle with every day when we meet a new client is there a power of attorney? So once they say yes, we breathe a sigh of relief. Is it readable? Do we have every page? Okay, second sigh of relief.
Yes.
If they have extraordinary powers, then we get really excited. It's like, wow, that's great. But then the question is, and this happens all the time, do they actually still have capacity? Is there any really dispute here? Can we sign new powers and it's legally feasible? Somebody asked, I can't remember, how do you defend it? I want to be prepared. For a long time, I insisted one of the attorneys was always there present for this because I want to be prepared to testify in court that we went through the test and we have evidence of their capacity, so if we're ever challenged on it. Now some of my staff is so experienced that I will occasionally allow them to go out and sign a power of attorney without one of the three lawyers here, just because they probably understand some of this stuff better than we do because they're dealing with patients on a more ongoing basis. But then the final question is, could we go to court? Sometimes we don't have any of that. And the answer is, it depends. It depends on the judge. Usually judges are understanding of this situation, and we haven't really had problems with judges, but sometimes it's the question of, how's the IRS going to think of this when we're dealing with IRAs? Sometimes it's the question of, well, if this person doesn't have capacity, can they really consent to the planning that we're doing? And is the judge going to consent to the planning we're doing? Sometimes yes, sometimes no. It really depends on the plan that we do. So this is, hopefully we have one of those bullet points is a positive. But realistically, Amy, what do we see a lot of times?
Like I said before, many families plan to or fail to plan ahead. Unfortunately, it's no one wants to think about when they are gone, and we don't want to deal with those things. I know my family, I've tried to talk to my dad about this numerous times, and he just, pushes me off because he doesn't want to talk about it.
Yeah.
He doesn't want to think about it. But if it's too late, or you think it's too late, it's not too late. We can still help. There are still things that we can do to help in those circumstances.
It's very rare that we can't find some way to either get a judge to authorize it, or that we go, that we find a way to use the existing documents. Often that means we might not be able to protect as much money. It may mean that it's going to cost more, and it may mean it's going to take longer. But there's very few, I can think of maybe 2 in our entire career, where we said, I don't see any way that we're going to be able to get permission to do this. So these are the documents. I know that we kind of went through those. I just like to point out the circles that, most everything is divided into either lifetime or after death, except for the trust, which kind of covers both lifetime and after death. So, if you're prepared, many families unknowingly spend a lot of time, money, and frustration thinking they have to go to court to get a guardianship. This happens all the time. We see this all the time, that the people had a perfectly good power of attorney, they had a perfectly good health care document, and they were still told that they had to go get a guardianship because the person's starting to show dementia. Or because the person's not capable of handling their checkbook anymore, not capable of balancing their checkbook anymore, they're told, well, the credit union, whatever, the bank, the nurse, anybody might say, oh, well, you got to go get guardianship. This is not the case. You're going to hear this over and over again. We have the table over here from the Michigan Justice Initiative, and that's one of their promotion things to say, we don't always have to burden the courts with this. We don't always have to take away somebody's right to make their own decisions.
Okay, some powers of attorney don't work unless 2 doctors declare you incompetent. So that's a springing power of attorney. Our office doesn't typically do those. Our powers of attorney are effective immediately upon signing, and so you should trust the people that you are giving that authority to. What if you are competent but are just temporarily not able to get out and pay your bills? Like I said earlier, that's what our power of attorney allows. That's why we make it an immediate power of attorney, because if you're out of town, you're on vacation, and you have a water leak in your house, that allows your loved one or family member, or another family member, a neighbor, to come over and take care of that for you, get those phone calls, pay that bill for you, because they are assigned as your power of attorney. So it's something you don't have to rush home for to deal with.
All right, so do you individually have your ducks in a row? And I don't really mean you, but you as you're counseling people and things like that. So is there a power of attorney? Does it have the authority to be able to protect assets? Is it immediate or upon disability? Like Amy just said, we prefer it to be immediate. And is your healthcare power of attorney, patient advocate, or healthcare proxy up to date?
And then make sure you're telling the people you're appointing that they are appointed as your power of attorney, so that if something happens, they're aware of that and they're able to stand up and take care of it for you.
I did this, 2 years ago now. I had an opportunity to go overseas and with a group of lawyers, and brought my wife with me. And I realized, well, bad things could happen while I'm gone. And so my sister was my trustee, but she has no idea what assets we have or where those assets are or what documents to use and things like that. So I sent her a quick email saying, okay, just so you know, in case anything happens, here's where the life insurance is, here's where, the other accounts, talk to Kevin Mannor about my IRA, and call this person for advice. Obviously, I'd have them work with Kelli and Melissa, but also from the, other people on things. And so I just wrote a long email saying, this is what, these are where you'd find my stuff, and just in case. And fortunately, I came back. So
we're really happy about that. So it's not always about Medicaid. As we talked about earlier, my department alone, planning services, encompasses your Medicare, your Medicaid, and your VA benefits. It also has our care navigators, where they can help provide the direction that the family could go in, help them navigate through all of the complex things that are care needs. It's just unreal how things can unravel in just 24 hours.
So this is something that we realized over time. So, years ago when folks would come in and, maybe we were looking at government benefits, but they weren't quite ready for that. They weren't quite ready we weren't sure. I mean, there's just so much information here that when we try to go through every possible scenario in an hour-and-a-half meeting, they walk away and then it's very easy to get confused about it. And then they still have all these decisions to make because they come in the crisis and they're not ready for some of these decisions. And that's what we realized, and that's one of the main reasons why we have care navigation, is because it has to be that step-by-step process. They may never need Medicaid, so a lot of our clients don't get government benefits, but they still need to make sure their legal documents in a row. They still need help making decisions. They still need advocacy. So, it's not always about Medicaid.
Exactly.
But sometimes it is.
Sometimes it is. So obviously, we talked about that. I take care of our Medicaid applications. I have Liz, our timekeeper here, that is also part of our department taking care of those Medicaid applications. And then we have Zora. She's over there at the advocate table, and she is new to our group, but she's very familiar with Medicaid applications and all of the ins and outs of all of that.
All right, so let's go through some of this real quick. This you can, you can print it off of it's just really the numbers. So you can print it off of the printouts that we gave you, or the online printouts. I was surprised by this number. We don't usually see a house that is worth $700,000, at least in Genesee County. And but you can have a house that's that is exempt up to $713,000. Problem with this is the state can come back and take it after you die, right? That's where state recovery comes in. So we want to still make sure that we've done something with the house. You can have one car, you can have a prepaid funeral, you can have a life insurance policy where the face value is less than $1,500. You can have your household goods. I always say $2 a day. What do they call the $60?
Yes.
What is that? Personal needs allowance is $60. So that's, a 30-day month, $2 a day. And for a married couple, this gets confusing, half of the assets of the married couple up to $154,140. So if they have $200,000, they don't get to keep $154,000. They get to keep $100,000. Okay. Now that's without planning. That's the default rules. With proper legal help for a single person, we can typically save the house and about half of the assets. Now, sometimes we can do a lot better than that.
Yep.
But for a single person, that's what we typically do.
I have one right now that where you can save about 3/4 of the assets.
Yeah, so it can be up from there. Married couple, one spouse, in the nursing home, we can typically save everything. Now, we don't always do it, so if somebody comes in, nobody ever comes in. So just to be clear, from a politics standpoint, nobody ever comes in to see us when they have $4 million. They're not asking for Medicaid when they have $4 million. Now, if they have $500,000 and it's a married couple, they do, because we don't know we need to help make sure that the spouse, the healthier spouse, is still protected. All right, so you want to talk about gifting penalty real quick?
Yes. So Medicaid will penalize you for making a gift or transfer to anyone, basically, except your spouse usually, in the last 5 years. And for every $10,870 you give away, you have a 1-month penalty at a skilled nursing facility, which, okay, that number changes every year, and it usually goes up. One time it did go down. And that's what the state of Michigan says is the average cost of a skilled nursing facility, which is probably pretty close. I have some that are in the $8,000 and $9,000 range, but I also have some that are in the $14,000 and $15,000 range. So if you're being penalized for 1 month and paying $14,000 a month and you only gave away $10,000, that's not really fair, is it?
Now, that's the bad news. The good news is it's the same divisor for PACE and waiver. And so PACE, we know, costs less. It's private pay, I think it's 54 or something like that. And then waiver, it really depends on what you're paying out for care, but we know it's likely to cost less than a skilled nursing. So we are able to use that same divisor, and that's one of the strategies that we can use to help protect some assets.
So giving money away to a child can actually cost you more than the amount of the gift that you need for long-term care. Just like I just said, if the monthly payment is a lot more, it can cost you a lot more. You wanted to help your son build a garage at his house. That seems harmless, right? Parents want to help their kids, and that could cause a problem if you have an issue, a medical issue, in the next 5 years. So, most of us, if you're healthy, we never know what could happen.
So this is really important because whenever we talk about gifting, it's always very strategic, very precise, and on a given day. And I mean that very seriously. So we always, and anytime you see me speak to the general public or speak about this, I always say, don't do it. Don't do gifting. Now, the reason is because if you do it before you're supposed to, it's not going to help you and probably going to hurt you. So when we look at gifting, we want to do it in the precise time and place and amounts that would be appropriate, because there's no way to do that math until you know what the cost of care is, until you know what the divisor is next year, until you know what the family situation of the person you gave it to. I'm not going to give you enough details that you'd be able to pick out the case, but we had a family come in recently where they said, oh, well, Mom gave us $30,000. I heard you said that that's not okay, so we'll give it back because my brother has 15 and I have 15 because we both kept it. She told us to keep it and we have it, and Bob, you said we have to give it back, we'll give it back. I said, perfect, we'll give it back, we'll start the plan. Call a couple hours later, well, my brother didn't keep the $15,000. So the plan there was, okay, do you have an extra 15 to the good brother that kept the money? Do you have another 15,000 that you could give to him that he can give back to Mom so that we can solve this problem? And so it's messy. You don't necessarily want to do it unless you have doing it very precisely in the right timing.
Right. So the Community Spouse Resource Allowance. So the initial asset assessment it's determined on when the person goes into a hospital or long-term care facility for 30 days or more. So someone falls and they break their hip. They go into the hospital, they have surgery, they're there for 2 weeks. Okay, then they go to the nursing facility and get rehab. They're there for 3 weeks and they get their rehab, right? And maybe they go back home. So that happened. And as long as it was after September of 1989, then it's accountable to go back to that, to get all of your assets from that time and determine whether, how much you get to keep now. So in 1989, if you had this issue and you fell and now you need long-term care, we can take your assets that you might have had more of back then. You've been paying out for care since then, and utilize those to determine how much you get to keep. So like Bob said earlier, if you have $200,000, it's half or up to that $154,000.
The lesser of.
Right, the lesser of. So half of 200 obviously is 100,000. But if years ago you had 300,000, obviously you get to keep 150,000. So it really depends on when that long-term care started. For a lot of our clients, it's pretty recent. We don't run into years and years ago normally. I can probably count on one hand where we've seen that, but usually within the last couple of years. But if you think about it, they probably did have more money back then because they started paying out for some extra medical needs, prescriptions, care.
And, it gets a little confusing on those 2 points. One is calculating what is the Community Spouse Resource Allowance. It's not 154. It could be, but it's not. And then secondly, there's only one IAA date, initial asset assessment date, in your lifetime. That's it. You get one. And so you're supposed to go back to the first one, even if you didn't apply for Medicaid at that time.
My choice waiver. So waiver can help pay for care in the home, in the independent living, and some assisted livings. So some assisted livings have contracts with the waiver agency, and they're able to accept waiver, which is really great. And we've seen a lot more lately of those facilities that can take that. They can transition into long-term care from there. They can get Medicaid in a skilled nursing facility. But again, there's an income limit, and that income limit is a barrier for a lot of people. But even if you make 1 penny over that income limit, you don't qualify. And you can't stop income. So a lot of people will say, well, what if I forego my pension? I don't, I can give that up. No, you can't do that. It's not allowed.
And, we keep trying to get this income limit changed, and we're still working on it. We'll talk about it a little bit more in Hot Topics. So for the My Choice Waiver eligibility, you still have to meet that same level of care. They call them doors or categories. So you have to meet that medical category in order to qualify for waiver. That's the same determination that's skilled nursing. Now, we all realistically know that that's a pretty subjective standard, meaning that one person that's determining level of care might look at it and a different one says that they do qualify, where one says that they don't. Our experience is that waiver and PACE tend to subjectively have it might be slightly easier to qualify in those levels of care if we're in waiver and PACE, because we're expecting that person still to be home, whereas nursing homes sometimes are a little stricter about that level of care determination. Yeah. Financial eligibility is going to be the same for long-term care nursing home, and but except for the income limit. So that number is this year is 82, I'm sorry, 20, I wish it was 82, 2829, and that is on the one sheet that we have laminated too.
The My Choice Waiver waitlist priority category. So we can get on a wait list. A lot of counties have a wait list. A lot don't. So it just depends on where you live. A lot of times in Genesee County, we don't really run into a wait list normally. After COVID, there was quite a wait list. But then there's priorities on the wait list. So it could be someone that is nursing facility transition participants. So they're in a skilled care right now, but they've gotten better and they can now go home. So now the spouse or the child can help take care of them in their home. So, which is what we all want. So we can get them on that list, we can get them transitioned, and that's usually a high priority. You can bypass all of those other people on the list. Current APS, obviously, they have authority to get you into waiver, and they are also a priority.
The one that we probably use the most is that transitions program, because if somebody's already in the nursing home, I was just talking to another lawyer yesterday about this. They were wondering, how do you get waiver once you're already in the nursing home? And so that's what we usually sometimes recommend. We tell the nursing home, hey, we're not planning on staying there, but we just need to get approved in the nursing home so that we can then already be approved for waiver, and then we make that a smoother transition. Partly because otherwise we'll have a wait list, and we'll be at the top, closer to the top of the wait list if we get approved for while we're still in the nursing home. And then there's that immediate risk assessment if there's an immediate risk of somebody in the community having to go to a nursing home.
Right. Then we have PACE program, which has the same income limits program for all-inclusive care for the elderly. It's basically a center they can go to during the day. Bus will pick you up, take you down there. It's very nice. They have doctors in the office that you can see. It's a really great program.
I'm going to really quickly go through some of these other things here. So the Veterans Pension Benefit can be used in any setting. This is the one that's cash. So we all know this as aid and attendance, right? And so it's really called a pension benefit. There's a long history as to why that is. But the nice thing is it's cash, so once we qualify, we can use it wherever we need it. So then how to qualify, these were the basic qualifications, are going to be served during a wartime period, 90 days of service, a discharge other than dishonorable, unreimbursed medical expenses that come close to or exceed your income. And if you're in independent living, they do have an additional requirement that you are private paying for 2 activities of daily living. Okay, a lot of people say that you need the 2 activities of daily living to get in attendance, no matter where you are. From my reading of it, that really is only a requirement of the VA if you are in independent living, because we helped fight this fight 10 years ago or whatever it was, because they started to say that independent living rental costs don't count as medical expenses. We said absolutely they do under your rules, they should, because it's a protective environment. And so finally they compromised and they say, okay, we'll call it a protective environment and the rent costs will count as medical expenses, but only if you're also paying for 2 activities of daily living. You can have a house, now these are the new rules, you can have a house with up to 2 acres. So if that house is $7 million, that's still exempt under the VA rules. Go figure. You can have, this year it's $155,356 in other assets. One of the things it says is you can have family cars. So you know how earlier we said you can have 1 car? That was Medicaid. For veterans, you can have 7 cars, I guess. It just says the family of cars. So there's no gifting within 3 years, or no gifting. It's worded improperly. After October 18th of 2018, they basically put a gifting penalty like they have on Medicaid. It's just the gifting penalty is more difficult because it's based on the benefit you would get at veterans benefits. So it's one thing to say, okay, for every $10,000 that you give away for Medicaid, you get a 1-month penalty. But for VA, it's like every $2,700 that you give away as 1-month penalty for VA. So it's a harder calculation. There's this thing on annuities. It's basically if you've purchased an annuity that has that pays you out monthly, they're going to say that was a gift just because you happen to purchase that kind of financial product. Dates of service. This is pretty standard. So you just have to have served at least 1 day during one of these periods and 90 days total. So we've got up there. There's special rules for Vietnam if you were in Vietnam, but I get that confuses people a lot of times, so I just put up the dates of if you served anywhere. You don't have to have been in Vietnam. You served anywhere during that time period to qualify. You get some extra consideration if you actually were in Vietnam. All right, this is the other one we talked about earlier, Agent Orange. There's so many different diseases that are now tied to Agent Orange, and so it's really a good idea to have an understanding of that. So if you have somebody that was in Vietnam, and sometimes for some people that were in Korea, Parkinsonism, what else we have? Peripheral neuropathy, ischemic heart disease, Hodgkin's disease, prostate cancer, a lot of the cancers, actually. Yes. So it's something that you're presumed to have been exposed to Agent Orange if you were there. It's presumed that the disease is tied to your exposure.
And just to point out where it says, even if you were previously denied, apply again, because that just came about just a few years ago.
So I'm going to defer to Savannah. Should we take any questions? We're kind of getting close to lunch and people are probably getting kind of hungry.
Do we have any questions? We'll just take this one because it's an initiative.
There you go.
I come almost every year, and I hadn't thought about this before, but with the gifting and the look-back period, so there's clear gifting, like, you give your children $10,000 or you buy them a car. But what about like events, like you take the family on a cruise, or you take the family out to eat every Sunday after church? How do they look at those things?
That's a great question. So there's exemptions to every rule, right? And so one of my friends up in Mount Pleasant, Attorney David Kerr, has been successful many times arguing that those things were not done for Medicaid purposes. They didn't contemplate trying to protect assets by doing it. That's not, my experience has been the standard, that they have a presumption that you paid for your kids' stuff, the presumption it's a gift, and the presumption it's a penalty. So if you can prove otherwise, then that's fine. So I recommend against it. Now, if there's no way to believe that that you have any kind of terrible disease or anything like that, and you did it 4 years ago, that's kind of hard to argue that was done to hide assets or to protect assets. So we can certainly make that argument, but just know that it's a risk because I feel the department most of the time presumes that it's a gift. I want to close, and I'll do this again later when we do hot topics. I've offered this every year. My point on this is that if you have a specific question like that, something else, or there's some dilemma you have, then feel free to reach out to our office. We can't offer that to the general public. We can't just say, call our office if you have a question. But for other professionals like you guys that are working in this field, if you have a quick question, you want to send an email, we'll do our best to answer it. Sometimes we're going to defer you to your counsel. So there was a question earlier about, well, general counsel at the hospital says that we shouldn't accept out-of-state healthcare documents. I got to defer to your counsel on that. My answer would be maybe they could then do a petition for instruction from the probate court. So you don't have to initiate a whole guardianship, but you could do a petition for instruction. So we will do our best to answer questions. We're never going to interfere with your organization's lawyer, and we're very cooperative with them. So, but if you have a quick question like, hey, is this, what can we do in this case, or do you think that this is something that you had a question about how Medicaid works or something like that, don't hesitate to reach out. So I think we're going to bring up Savannah, and we're going to get ready for lunch. And I'll talk to you later in Hot Topics.
All right, everybody, let's give a round of applause for Amy and Bob. I know I've worked here for 5 years. I've been to more than 5 boot camps because we used to do more than one a year. And I still learn something every time I hear Amy and Bob talk. So it's awesome. Raise your hand if you learned something in that presentation that you're probably going to use going forward. That's awesome. Okay, so I don't know about you, but I smell food. And I'm hungry, so I think we're going to go ahead and break for lunch. If you are thirsty, don't forget to visit the center well table for a margarita to go ahead with your food. And we'd also like to thank Mannor Law Group and Bob for our lunch today. So thanks again, Center Well, and let's enjoy our food and some margaritas.
So hopefully a lot of you are familiar with the Michigan Elder Justice Initiative, and they have a table here, by the way. We're going to talk a little bit about that later. But it houses the Long-Term Care Ombudsman's program. And so we are fortunate to have one of the ombudsmen and the lawyer for the ombudsman. And I wanted to come up before we do the quick introduction here because you're going to definitely notice a theme, like I talked about earlier. We're spending a lot of time. There was a few years ago we kind of really focused on Medicare. One year we focused really on veterans benefits. This year it's really about that substitute decision making. And so there's so much nuance here, and each has a different perspective. So I just kind of want to set the stage for that because it's a really great presentation, and I'm really pleased that we were able to get the folks from the Long-Term Care Ombudsman's office. I'm not as good at introducing people as Savannah, so she's going to actually go and introduce them. So.
Thanks, Bob. No pressure now or anything. So our next presenter, as Bob mentioned, they are truly both champions for the long-term care industry, for the residents, for our clients, and even for us. So from our first presenter, from her work as assistant ombudsman to her leadership roles in assisted living facilities, she has dedicated her career to ensuring the well-being of our elders. And she is joined by our second keynote presenter, who is an attorney with 25 years of experience, who's fought for seniors facing abuse, neglect, exploitation. From her work with the CVLAP Elder Justice Initiative to her legal expertise, she's dedicated to protecting our most vulnerable population. So let's go ahead and give a warm welcome to Karrie Craig and Mireille Phillips.
It might seem crazy what I'm about to say. Hot air balloon.
I'm Karrie Craig. Sally Pung is the state ombudsman, and she was supposed to be here today. So I'm asking for a little bit of grace during this program because I've seen the slide twice. Just bear with me. Usually I have got a pretty good spiel, but I'm not quite sure today, so bear with me. I have been a designated ombudsman for 8 years now. Before that, I was actually an administrator at a 60-bed AFC. So I understand the system. I've worked in long-term care forever, which makes me kind of old, but that's okay. But I'm really excited to be here today. How many of you know the Ombudsman program, have worked with Ombudsman? Good. Some of you not. So this should be fun. All right, for those of you who don't know about the Ombudsman program, I want to give you a little bit of background. We actually are a federal program, so every state, including District of Columbia, Guam, Puerto Rico, every state has a state long-term care ombudsman. I am the assistant state ombudsman. We have our own federal regulations, just like nursing homes have federal regulations. We also have federal regulations that we have to follow, and we are authorized through the Older Americans Act. So as ombudsman, we can enter any licensed home in the state of Michigan. So those licensed homes includes nursing homes, adult foster care homes, and homes for the aged. They have to be licensed. We don't have authorization to enter any other type of home. Nursing homes are the only home that are required to post our information. So a lot of times what we find are AFCs and HFAs don't really know that the Ombudsman program exists. So when we go to enter those homes, they're like, who are you and why are you here? And you can't enter my building. And that's okay. We just provide some education and then we all move forward. So we can enter any of those settings. What we do is that we work with residents in order to have the residents be able to make choices for their own life. So a resident has a concern or a complaint. We listen, we validate, we say, hey, how would you like to handle that? And we move forward at the resident's direction. So it's all about the resident. It has nothing to do with what I want or what I think is a good idea. It has everything to do with what the resident wants and the choices that the resident wants to make for their life. And it's really important we always share that we work for a nonprofit. We don't work for the home. We don't work for the government. And that way we can build trust with the resident. All of our services are completely free and confidential. I think that's important too. Okay, so what we do, we investigate concerns. So anyone can call the Ombudsman program and have a concern. Let's say Mireille calls and says, my mom is at the nursing home and she's getting the worst care ever. Could you please go and talk to her? No problem. I'll go and talk to Mireille's mom, and Mireille's mom says, no, my care is great, but I'm getting cold coffee, which is a huge problem, which I can relate to. Cold coffee is awful. So we can't move forward and investigate the care concerns because they're not the resident's concern. But we absolutely would fix the cold coffee because that increases people's quality of life. And that's important to some people. And it could actually bring joy. Brings joy to me. And if I don't have coffee, people around me don't have joy. Yes. We also respond to notices of involuntary discharge. Some of you may know what that is. If a home says that they no longer want a resident to live there for a number of reasons, our program is usually given notice and we respond to those. We can attend care conferences, resident council meetings, family council meetings. We provide information and assistance on long-term care supports and services to anyone, the public, residents, staff. We do lots and lots of trainings. Our program has a really, really great abuse prevention training for nursing homes. We participate in surveys at the nursing homes and do fun stuff like this. Okay. We have in the state of Michigan about 103,000 beds, licensed beds. And right now we have 23 ombudsmen to cover the entire state. So those 23 ombudsmen are meeting with residents, advocating for what residents want in those 103,000 beds. So for example, we have one local ombudsman who covers the entire Upper Peninsula. The type of work she does up there is a lot different from the type of work that our ombudsman in 1A or the city of Detroit. And the nursing homes are different. So it's completely different from one end of the state to the other. We don't have authority to access non-licensed homes. As you know, there are a number of non-licensed homes in Michigan. Our program structure, so we are federally funded, mostly. We do get some state funds. Some local ombudsmen actually receive local funding as well, like millages. Like Ingham County has a millage, Kent County has a millage, Kalamazoo County has a millage that are all help to fund the ombudsman program. So this is the interesting part of our program. The state office is contracted through the Michigan Elder Justice Initiative. So there's a few of us in the state office. All of our local ombudsmen who are out there in the nursing homes, working and meeting the residents and resolving concerns, most of them are employees of the local area agencies on aging. So our program, we hold the program, and the local area agencies on aging just have the personnel oversight. I've never been involved in a program, anything like this before. It's the strangest relationship because the AAAs, they really can only know that they're coming to work on time and they're dressed appropriately and this is how much we're paying you and how much vacation time you have. And they can't know anything else about what the work that we do because it's completely confidential. So it's very interesting. This is probably more information than any of you ever wanted to know, actually. So there are 5 of us in the state office, including myself and Mireille, and then there are currently 23 paid ombudsmen across the state and 11 volunteers. We're always looking for really good volunteers. Okay, so what we do, we empower residents, first and foremost. I think that's the most important part of our job. So I'm going to give you an example. A resident calls and says, I'm diabetic, but I love chocolate cake. And I'm like, right on, I love chocolate cake too. I'd like to eat it every day. So he tells us, I want to eat chocolate cake. I understand that I'm really not supposed to eat chocolate cake because I'm diabetic. I make my own decisions, and I want to eat chocolate cake. And so he's on this side. His family is over here saying, Dad, you can't eat chocolate cake. We want you to live a really long time. And the doctor is saying, you can't eat chocolate cake and because you're diabetic. And the home's saying, well, the doctor says you can't eat chocolate cake, so you can't eat chocolate cake. So you've got the resident on this side, and you've got about 5,000 people on this side. I know I'm very dramatic. Saying he can't eat chocolate cake. So what we do is we come in and we say to the resident, I'm not going to judge you. I've got your back. If you want to eat chocolate cake, you understand the risks of eating chocolate cake. I'll stand behind you, I'll stand beside you, I'll speak for you if you want me to. We can take this however you want it to go. And I will work to help you to eat chocolate cake. It's the best job ever, right? So that actually is the beauty of our job, is that we advocate for what the resident wants, hands down, just what the resident wants, no matter what it is. If the resident knows the risk, what's life without risk, right? We all take a little risk. My risk usually includes actually ice cream and exercise. More exercise, less ice cream would probably be what my doctor would tell me, but right? Your own form of caffeine with lots of sugar. What could be better? Yeah. So we empower residents. We want residents to feel like they have control over their own lives and that they can make decisions, because we all want to make our own decisions, right? If somebody was in my house and said, I'm sorry, you can't, you have to do this, I'll allow you to do this, right? Even though I'm a grown adult, somebody telling me that I can't do something and that they would allow me to do something in my own home would be a problem. And that would make me feel, in my professional words, yucky. Right? Nobody wants to live like that. We all want to have a little control over our lives, and residents have the right to that. We validate residents. So, it's interesting that I think what we see a lot is we walk into a home, a resident has a concern, we say to them, we listen first and foremost because we have the time, right? Staff are busy. They just are, and that's okay. And we sit and we listen and we say to them, I'm so sorry that that's happening to you. And I think what we find is the minute we say that and we validate how a resident is feeling, because only they know how they feel, then they feel like they're heard. And sometimes they can move forward from there. And the other thing I want to say about that is I've never been in a situation where I've been completely vulnerable, where somebody else has to take care of me. I haven't, and I feel very fortunate that I haven't. But the fact that a resident has to have somebody take care of them, help them throughout the day, makes them vulnerable. And sometimes when you're vulnerable, you don't want to tell the person who's taking care of you that they're doing it wrong, or that something else is bothering them, or they don't like the way that staff member talks to them. And that's okay. That's what ombudsmen are for. We can come in and we can listen and we can help educate. We don't judge anything, and we can help maybe bridge that communication gap that sometimes happens. And that's a good thing. You know, we're not there to judge the staff either. People don't know what they don't know. And if a resident doesn't feel comfortable saying, hey, that care's a little rough, then we can come in and put it in a way that maybe everybody can be happy and understand. And that the staff will be educated because, again, they don't know what they don't know, and that's okay. We investigate concerns at the direction of the resident. You'll probably hear me say that 1,000 times today. Completely resident directed. We cannot do anything without the consent of the resident, including talking to anybody in the home. We have to have consent on who to talk to and what to talk to them about. We can't just talk to anybody. We can't share information with anyone. We can't even tell someone that we're working with a resident because that still is information. Really interesting thing is that ombudsmen are not mandatory reporters. I know, I love that response. We're not mandatory reporters. It's really, really important that residents can trust us completely. So a resident could say to me, that staff member just punched me in the face, but don't tell anyone, and I cannot tell anyone. That doesn't mean that I'm gonna be like, oh, okay, good luck. Yeah. No, you know, we would continue to work with the resident and make sure that they felt safe or would take the actions necessary for them to feel comfortable in their own home and to move forward. Whatever that may look like. It could be making a phone call to a hotline. It could be making a phone call to a family member. It could be anything, but we would lay out the options and talk about the consequences or what could potentially happen and then move forward at the resident's direction. Again, our services are provided at no charge. We are not a regulatory agency. We are considered a health oversight agency. And we're also not a placement agency. Probably should know that too. So our work in fiscal year 23, we did a lot of work. We investigated and closed 3,284 complaints. And all of that work was completed by 20 people. I just did the math because I was interested just a minute ago, actually. It comes down to over 40 cases a quarter. That's more than 10 cases a month, which is a crazy amount of work. Yeah, that's a lot of work. I'm really proud of the program and the work that we do, and that just says it all. And that's just the casework that we do. That doesn't mean everything else on top of it. Of the complaints that we receive, 85% come from the resident or the resident representative, and that's really important. But we can receive complaints from anyone at all. Somebody could call our office and make an anonymous complaint, and that's okay too. But we have to go directly to the resident. So somebody calls and has a concern or a complaint, we have to go directly to the resident and see if it's the resident's concern, because if it's not, there's nothing we can do about it. Of the complaints that we received in fiscal year 23, 405 were on discharge and eviction. That's our highest complaint. But that being said, if you add in all of the care issues, care is actually our top complaint. Like if you add together the medications and the personal hygiene, the failure to respond for requests for assistance, care is our top complaint. And then also rights and preferences are in there as well. So Residents are concerned about their care, and they're also concerned about the fact that they want to be able to make choices, as well as not being discharged to homeless shelters. That is important. So when we get a concern from a resident, I guess this is probably important for all of you to know. We go to the resident, we listen to what the resident wants, we lay out all the options, and then the resident makes the choice. Typically what that looks like is speaking with somebody at the home, maybe walking through the grievance process, or so we have it in writing, which is always a good thing. Having a care conference, but sitting down with the home, because ultimately we want to be able to work with the home, whether it's a nursing home or an AFC or an HFA, it doesn't matter. We want to be able to work together in order to meet the needs of the resident, because if the resident's not happy, guess what? Nobody's going to be happy, right? So we want to be able to work together, and a lot of times I think the easiest way to look at it is, it's not my decision, it's the resident's choice. So it kind of takes the personal aspect off of it, right? Has nothing to do with me. I'm not making this decision, it's the resident's choice. So let's figure out a way to get there. You know, we might have to look at the risk. We might have to try different things. If the first thing doesn't work, then we might have to look at it again from another direction and just see how we can get the concern resolved, because that's what's important. And it's the resident's home, so we want to make sure that a resident feels safe and comfortable in their own home. And that's our information. We have a really good website that has all of the local ombudsmen on there, and pictures of them, and more information, fact sheets, all kinds of good stuff. And then I'll let Mireille talk more about, I'm not even sure what you're talking about. I didn't look at your slides.
It's all right, I gotcha. Good afternoon. Thanks, Karrie, and thank you, Mannor Law, for inviting us today. I serve as legal counsel for the Long-Term Care Ombudsman Program, and I'm relatively new to long-term care, although I've been an attorney since the 90s. My practice previously focused on commercial litigation, representing media clients, and I also did some elder justice work out in Macomb County. I've also worked at Wayne State teaching legal writing. So I'm relatively new to the long-term care space. But equally important, I'm a caregiver. Take my lawyer hat off. I'm a mom. I'm a mom of 4, including a young adult son who lives with intellectual and developmental disabilities. And I'm a caregiver to aging parents and in-laws. So I know that aspect of long-term care coming into this job. In fact, my mom's journey with early onset Alzheimer's dementia is what inspired me to go in this direction later in my career. So I am so proud of this program. It is an incredible opportunity to come to work every day and support the 23 fantastic local ombudsmen in Michigan who are out in the trenches advocating for Michiganders who are living in licensed long-term care settings. I honestly have never worked with a more incredible, caring, thoughtful group of people. So as I got rolling in this position 2 years ago, I noticed 2 legal issues that just kept popping up over and over again every day in my work. And the issues are capacity and surrogate decision making. So I thought today it would be a good use of our time to talk about those issues, because this is what I'm grappling with every day. Questions keep coming up from ombudsmen and providers, and this is what we are struggling with every day to figure out. So I thought it would be helpful to share with you the analytical framework that I use in grappling with these issues. So we're going to talk about capacity for a little bit first, and then move into surrogate decision making. And by surrogate decision making, I'm referring to guardianship and power of attorney, patient care advocate designations, things of that nature. And really trying to figure out who is in control Who is in control when a question comes up about resident rights? Maybe the resident wants to have visitation with a specific person. Maybe the resident wants to have an intimate relationship with a partner. Maybe they want to eat chocolate cake. Whatever it is, who gets to make that decision? Okay, so I think that this might be something that touches your work as well, and hopefully it'll help you today. All right, so we're going to start with a very basic definition of capacity that you see up on the slide. And just very simply, capacity is the ability to make a well-reasoned decision. So here's your basic definition of capacity. What's really important to understand, as I'm sure most of you do, is capacity isn't static. Okay, it's not like a one-shot thing. It varies day to day, hour to hour. A person can have capacity in one aspect of their life, but not in others. So perhaps someone needs help making financial decisions, but they know who they want to visit with, they know what they want to have for dinner. And I personally like to think about capacity on a spectrum. So at one end of the spectrum, you've got, an independent adult, genius IQ. The other end of the spectrum, you've got, someone who's comatose. All of us are on that spectrum somewhere, right? And where you are on the spectrum depends on a lot. It depends on, are you in pain? Are you well rested? Are you ill? Do you have a UTI? So lots of factors can impact a person's capacity. Okay, we're gonna go to the next slide. Okay, so digging a little deeper, thinking about capacity still, when I think about capacity, I have found it helpful to start asking myself, capacity for what? So that's kind of my mantra, and if you leave here today and you think about capacity, and in the back of your head, you think, capacity for what? I'm gonna be really happy. And that's sort of how I've been working with the Ombudsman. We get a lot of calls. When I first started, I was getting calls all the time where I was being told, this person, this resident, has been deemed. Deemed. And that term, deemed, is not one that I had ever heard before coming to work in long-term care. And I thought, well, gosh, did I miss that day of law school? Because I don't know what that means. So I did a little research, and funnily enough, come to find out, that's not a thing. There's no legal state called deemed. There is possibly a finding of incapacity that could have took place in a guardianship case, but there's nothing that says that someone is deemed and like falling off into the abyss of they're forever deemed and they're in that pit. That's not a thing. So determining capacity is really hard, but it's so consequential, okay? So sometimes you hear capacity in law journals referred to as the black hole of legal ethics. For something that's so important to who we all are as human beings, and it's so final, how can capacity be so ambiguous? That's why it's called the black hole. Okay, it's really hard to get your arms around it. And there's so much conflict about how to even assess it. There's not a bright line test. I was not trained in law school. Lawyers are not trained on how to assess capacity. However, as an attorney, it's something that we have to do every day. Does someone have the capacity to execute a will? Do they have the capacity to sign a power of attorney document? This is not something that I was trained in law school on how to assess. And even more, sometimes things outside factors like poverty, domestic violence, family strife, these all impact capacity as well. So quite frankly, sometimes I think that folks are tempted to jump the gun on finding incapacity because it's just easier, cleaner to have someone be deemed, especially if that person is making bad decisions or decisions that objectively might seem not ideal. So we see this balance playing out between, on the one hand, you've got concerns about safety and convenience, and on the other hand, what do you have? Someone's dignity, their autonomy. So, okay, I want to give you some facts, and I'm going to give you some myths. Fact number 1, people are presumed to have capacity. That is your starting point. Okay, when you're analyzing a case or working with a resident, that person is presumed to have capacity. The legal standard in Michigan to get a guardianship is, number 1, the person has to be incapacitated so they can't make and communicate informed decisions. The second prong of that test to get a guardian is that the guardianship has to be necessary. Okay, so that's kind of the legal standard. So going through this, if you want to challenge someone's capacity, the burden's on the person doing the challenging. It's not on the vulnerable adult. And in the absence of a judicial determination of incapacity, the vulnerable adult or the individual involved has capacity. Okay? And the fact that someone has executed a power of attorney document and had the foresight to do that, which is awesome when they do, that doesn't mean that they've given their capacity away. I've executed a power of attorney document. It was valid the day I signed it, but I think I still have capacity, most days anyway.
I might say something different.
Yeah? Shh, don't tell. Okay, I think the next slide is the myth. I love this slide. So capacity is a binary all or nothing on-off switch. That's a myth. Okay, so this is getting back to what I was talking about before about capacity being domain specific. So here you have on this slide all of the areas that might touch any one of our lives. So money, medical decisions, property, visitors. You'd be surprised at how many cases I get that involve visitors, where one sibling is trying to block other siblings from coming to visit. It's something I deal with weekly. Intimate partner relationships, contracting, smoking, food issues, powers of attorney, and living arrangements. So instead of thinking about capacity as that light switch, that on-off switch, where someone's fallen into an abyss of being deemed and then guarded, I think it's really helpful to just start thinking in your head about all of these different areas, all of these domains, where someone may have capacity, to know what they want to have for lunch, but maybe not capacity to sign, a high-level contract. When we see this, I'm sure you all see this in your work all the time, and it just makes sense. So, what I'm inviting you to do is to start to conceptualize this concept of capacity for what. In this way, you're going to view capacity not as the light switch, not as this on-off switch, resulting in people being deemed, guarded, but you're going to start thinking about it a little bit more broadly, like the DJ controls on the sound system in this slide. So some areas of a person's life are going to come in loud and clear and strong. Maybe they know what they want to do for activities. But other areas they might need more support navigating, okay, such as like the higher level medical decisions, financial planning, things like that. Everyone is individual. All right, next fact, capacity can come and go. And this slide demonstrates that confusion can be temporary. So if someone is, dealing with some confusion, maybe it's reversible, maybe it's temporary. We've all experienced times in our lives where we're not at our highest level, at our normal baseline. So the takeaway here is just, it's really important to constantly remind ourselves just to revisit evaluations, and it's best practice to do that. So bad decisions. It's Friday. I'm sure I personally have made at least 20 bad decisions this week. Okay, that doesn't mean that I don't have capacity. We are all human. We all make bad choices. The key is whether do we understand the consequences. And dignity of risk. So I know over my recent spring break trip, I made some pretty poor choices when it came to foods I chose to eat or how many cocktails I wanted. And I stood at the top of the Smoky Mountains and really thought long and hard about letting go on that zip line. It was terrifying. I chose to do it. It might have been a bad choice. I don't know. But this does not equate to me having less capacity. So we often see folks who struggle with poverty, domestic violence, life choices. Maybe they don't keep their home as clean as others would like them to be. Maybe they've got a lot of stuff that, you know, they've inherited and they don't want to part with. And we see these folks ending up falling into this abyss of deemed and guarded, and it drives me bananas. The key, you guys, is whether the person understands and chooses to act that way anyway. But the struggle just continues to exist between, again, the balance, safety and convenience on one hand versus what? Dignity and autonomy on the other. Okay. All right, real quick, and I don't want to spend a lot of time on this because I'm sure y'all can run circles around me when it comes to these assessments. Assessing capacity is hard. It's not easy. There's 3 ways on this slide of doing that. Interesting story. So with regard to the mini mental status exam, we had a recent elder law task force meeting, gave the mini mental status exam to a group of unsuspecting young legal aid friends. Y'all, they did not do so well. They struggled with the backwards counting thing, which I can't do that either, so I get it. They also had issues with motor challenges that got in the way. So it just wasn't a good experience for them, and it really stressed people out. And I thought, my God, like, we're giving this to people who are vulnerable, who are not feeling well on what's probably the worst day of their life. So I had dental surgery yesterday. Had they given me this, I would be in the abyss of the deemed. It was not a good experience. I was not feeling well. I was stressed out. So it's really important to just think about these tests, take them with a grain of salt, just keep reassessing. I know that, you know, it's difficult to get a comprehensive neuropsych. There's limited time, there's limited resources, but just keep leaning into the tests and reevaluating people and getting that holistic approach where you're looking at what adaptive skills does this person have. It's just, these are a tool, but they shouldn't be the trigger point for deeming a person. All right, I want to move on into surrogate decision-making real quick. So there's lots of types of surrogate decision-making. The first one I want to talk about is guardianship, because it's one that I'm sure most of you are somewhat familiar with. So guardianship, what is it? I've got some definitions here. It's the appointment by a court of one person or entity to make the decisions of another. But what's wrong with it? It strips an individual of their rights to make their decisions themselves. It oftentimes results in abuse, neglect, and exploitation. I've seen cases where, a married couple both fell under the same public guardian, were separated and placed in 2 different nursing homes, and their cell phones were taken away, and they didn't have communication with each other. And, that was just a disaster. So it's really hard when you see these cases of people suffering abuse at the hands of someone that's supposed to be assisting them. Guardianship, the last part of this, it should be the last resort. Sometimes it's necessary, but it should not be the first place that anyone's head goes when someone is struggling and needs help making important decisions in their life. Again, the standard for guardianship in Michigan, I'm thinking most of you are from Michigan, but I did meet a couple folks from out of state. In Michigan, the standard is the person has to be found incapacitated. It's a 2-part test that the judge has to look at. They have to have incapacity, and part 2, guardianship has to be necessary, you guys. So that means there's no other alternative, right? Court's supposed to consider that at least. So I love this quote, and the reason I love it is because it's going back like at least 30 years. And it just shows you how dire it is for folks who are under guardianship. It's not changed a lot today. There is some hope on the horizon. We have a package of bills in the Michigan House that's passed, and it's going to the Senate for guardianship reform. I'm not going to get into the weeds on that, but there is hope. Okay, so when is guardianship needed? Sometimes it is, okay? And it's your emergency type situations. So in Michigan, we are not a next of kin state. So think about this, guys. We're not a next of kin state. So if you don't have a power of attorney or patient advocate care designation executed, and some accident befalls you in Michigan, guardianship really is the only avenue for folks to make your decisions during that crisis. So if you don't have your own power of attorney stuff done, you might want to consider doing that. Guardianship is also needed to support people who are facing a crisis and don't have any interest or any ability to lean into that and make decisions. And sometimes it's important to protect people from abuse. On the flip, guardianship is not needed just because someone is a certain age, just because they have a specific diagnosis. So just because someone's diagnosed with advanced dementia does not mean that they need a guardian. It's not necessarily needed because that's just always how we've done it. And it's not needed just because it's for your own good or because you're making really bad decisions. So in reality, and that's what you see in red here, people under guardianship are often called not their own person anymore. How undignified is that? To say that I'm not my own person anymore. That just makes me sad. You'll hear the term legal ghost used, and it's also called the highway with no off-ramp. So once you're in the guardianship system, it's not easy to get out of it. It's not easy to graduate from guardianship. I never thought that I'd be talking about Britney Spears, but I'm sure you guys saw about her in the media. In California, they called it conservatorship, but it's actually, that's what guardianship is in California. And look how many years that she was under that conservatorship with people just making her work and taking, possession of a lot of the fruits of her labor. That's the highway with no off-ramp, folks. Even with all that money, she couldn't get out of it. So, folks who are working in long-term care, if you think that surrogate decision-making is needed, so if someone is needing assistance, what do? Think about what alternatives exist. And I'm going to touch on them briefly in the next slides, but where my brain goes is, what's the problem that the person's dealing with? Are they dealing with managing their finances? Are they dealing with getting food? Say they're living in the community, but meals are difficult, right? Would Meals on Wheels just be a solution? There's so many things if you look at a situation holistically and start noodling on that. How can you find a pathway outside of the guardianship system? Is there a tool? I mean, we all ultimately have the same goals, protecting adults who are vulnerable and honoring their rights at the same time. Okay, so here's your best practice slide. Consider less restrictive alternatives to guardianship. We've talked about guardianship as this broad brush that takes away a lot of authority, maybe unnecessarily. So before you go down that path, start thinking about what's the problem that this person's dealing with. Is there an alternative that might be the solution for that person? And that'll narrowly address the problem, right? And I love that our friends from MEGI are here today. The Michigan Elder Justice Initiative houses the long-term care ombudsman program in Michigan. And MEGI thinks that guardianship diversion is so very important that this year we launched a pilot program on guardianship diversion. It's in 4 Michigan counties right now: Bay County, Genesys County, Muskegon, and Grand Traverse counties. So these are pilot programs where MEGI is in the probate court in those counties and working on guardianship diversion. And if you have time, step by the MEGI table. If you haven't already, my colleagues Laura Cubitt and Rachel Richards are over there. They have pamphlets and materials to share, and it's a really exciting project, and it's in partnership with the Elder Abuse Task Force by the Attorney General's office. So next slide, we've got just a list here of different sorts of surrogate decision making. So again, this is where someone else is making the decision. It's not a guardianship, but you've got a list here: financial power of attorney, medical power of attorney, conservatorship, etc. Social Security rep payees. So you'll have that list. How am I doing on time? Oh, good. Okay, I want to switch gears and talk about the last part of this presentation, which is how do you figure out who's in control? You're working with a resident. There's maybe a power of attorney, maybe a guardian, maybe a patient advocate. Who gets to make the decisions that are important to this person? I've kind of got a little analytical framework that I use that I think has been really helpful to the ombudsman, so I want to share that with you. This is the process that we go through. Okay, step 1, extremely important, get the documents, okay? I can't stress this enough. It's critical to get the paperwork, whatever that surrogate decision-making paperwork is, whether that's a guardianship order from the probate court, or a patient advocate designation, which is also called a medical power of attorney, or a financial power of attorney. So often, I get a call and I'm told, oh, resident is deemed, they're guarded, they're under a guardianship, the guardian is trying to make medical decisions, or they're banning a visitor. Maybe they don't want Aunt Jane to come because no one likes Aunt Jane, I don't know. And it seems like folks use really loose, indiscriminatory language when it comes to what's going on. So I get those calls from the ombudsman, and what's my first question to them? Where's the paperwork? Send me the paperwork. I'd like to see the paperwork that this person who is putting themselves out as the decider, I want to see what authority they have. Because maybe they don't have what they say they have. And you know what? Shockingly, a lot of the time they don't. They'll be like, I'm the guardian. Okay, show me. It's really easy. Sometimes, the person's not guarded. They just have a financial power of attorney, and maybe they didn't even sign it. Maybe it wasn't executed properly. Maybe they don't want that person to be their financial power of attorney anymore. These things aren't set in stone forever. If the person still has capacity to revoke it, they can revoke it. All right, this is the slide on fiduciaries and the type of paperwork that you'll see. I'm not going to spend a lot of time on it, but just the different sorts of paperwork. So power of attorney for finances, guardianship, it's going to be a court order. All right, the documents are the key. Read them precisely, get the documents, read them precisely. The words that are in that document matter a lot. Likewise, the words that are not in the document matter a whole lot. My point is, I want you all to get curious with the documents. Lean into that. Just be really curious and look at those documents and what are they. And I get it, not everybody here is going to like reading a 20-page power of attorney document. I get that. But certainly somebody in your organization, develop a cadence within your own organizations, with the people that you work with, at who is going to read these documents, who's going to sort this out, and that's for y'all to decide. It's just important that you don't skip that super important step. Step 2, so once you've got the documents, determine who has the authority, who has the power, and what is the scope of that power. So it's super important to remember that if the power isn't given in the document, who has it? Anyone? The person, yeah. Like if you don't give that power away, you retain it, okay? This next slide walks you through like a number of prompts that I thought are helpful. So once you get the documents, here's some prompts to help you figure out who has the power. So who's the named agent? Is the power activated? Sometimes, like with financial powers of attorney, they're activated upon signing. Sometimes they're only activated at a later date, like if someone, falls ill and a doctor signs off. What powers have been given to the agent? And the word agent just means the person who's got the power of attorney, who's named. What powers are not given? And is there anything unclear? Sometimes these documents even have a definition section that helps you to sort out if there's something that's not very clear. So just because someone has executed a power of attorney doesn't mean that they've lost power to make their own decisions. This is tricky. So can the individual, so here by individual I mean the resident or the vulnerable adult, and their agent, so the agent being the power of attorney or the guardian, can they simultaneously have decision-making power? Sometimes yes. Okay, and it's tricky. So takeaway is what you see in red. Merely by having executed the power of attorney doesn't necessarily take away the rights of that person. Have they been found to lack capacity by a physician, for example? Depending on how that document is written is going to help you figure that out. It also is possible that a guardianship could be limited. So maybe it's just a guardianship for contractual and financial, and the ward or the vulnerable adult is retaining control of other aspects of their life. So don't exclude the individual, and by individual I mean the resident or the vulnerable adult. Even if you've already confirmed that the fiduciary has a valid power, you've read the documents, that fiduciary, and this is super important, they should still be consulting with the vulnerable adult. They don't get to sit off site and just, wield their authority and not ever consult with that vulnerable adult. Okay? And if the individual isn't happy with how things are going, they may have recourse. They could possibly make a motion to terminate the guardianship, maybe modify it. They have options, potentially, okay? So, takeaway for folks here, if the resident already has a power of attorney, advance directive, guardianship, get the documents, keep the documents in their chart, read it, it becomes part of their record, and it's the only way that you're going to be able to figure out who has the power over what do they have power, over what do they not have power. And I think we're at the end. I brought a little case example. I think that might be fun. It's a little long. I'll read it through. This is a fun one. Let's try working this through with a real case example. I've totally made this up. It's hypothetical, but I think it's there to illustrate some of the points throughout the presentation. Okay, we're gonna have Anna. She's a retired English teacher at the community college. She's residing in a nursing home now for just over 3 months. She's got a medical history that includes a diagnosis of diabetes 10 years ago and mild dementia 2 years ago. She's 68. Prior to her nursing home admission, she fell, broke a hip, had hip surgery, went to nursing home originally for rehab, and she stayed. So she's now approved for Medicaid, in a Medicaid bed. You find Anna to be sweet, but at times pleasantly confused. Anna's got a daughter, Kate. Kate reports that Anna was deemed last year by her primary care doctor. Kate explains to you that mom hadn't been paying her bills and it was a real mess to clean up. She reports that she's mom's guardian and offers to provide you with all that paperwork. Since her admission, they've got her on Medicaid. So last Sunday, Kate arrives to visit mom and take her to church and brunch. Kate learns Anna's already gone out with her boyfriend, Bob. Kate is absolutely irate. Maybe this has happened to some of you, maybe. Yeah, she's pretty ticked off. She approaches you and demands a meeting Monday morning. Okay, so you meet with daughter, Kate, on Monday, and she demands the following. 1, Anna is not allowed to leave the nursing home with Bob. Not happening. I'm the guardian. She can't go. Anna is not allowed to have any of the candy that Bob brings, and she's diabetic after all. And the nursing home needs to stop Bob from bringing these things in. Like, what kind of place do y'all run in here letting her eat candy? She's diabetic. Seriously. And 3, Anna, why are you letting her visit with this boyfriend in her room? Why would you do that? No, that's not happening anymore, says daughter. So after Kate leaves, you being a resident friendly advocate, go and speak with Anna about her preferences. Because you want to know, what is Anna? Where is she in this whole thing? Anna tells you she wishes to continue visiting with Bob in her room. They enjoy watching movies together. They enjoy having dinner together. They like to hold hands. And they have a nice evening. And she wants to go on outings with him. She looks forward to this every week. And she really likes the candy. And it's so nice that he brings it to her. It brightens her day. So that's the situation. So what do? So Kate's going to send you the documents because you're like, step 1, get the documents. You review the documents yourself or whoever in your organization. You've got a nice cadence developed. Somebody there is looking at documents. And you realize Kate is not the guardian. So if she was the guardian, what would she have given you? Like a court order, right? There's no court order. What you get says durable financial power of attorney. All right, stop. So, who gets to decide the following things? Can Anna go out with Bob? Absolutely. Can she eat the candy that Bob brings? And what about visiting with him privately in her room? Yes, because the daughter has no decision-making authority whatsoever. So the question in my mind is, well, on what authority is she saying that she gets? So point is, let's assume that the daughter isn't like being mean-spirited. She's just confused. People use the word guardian when they mean power of attorney. It's not like the daughter's out to get the mom. Let's assume she's kind, but she just doesn't know what she doesn't know, right? All right. Questions? We've got a couple minutes.
All right, I'm coming.
And you're going to help me with the questions, right? Get up here, girl.
Okay, I have two questions. The first is there such a thing as a temporary guardianship?
Yes.
Okay. And are guardianship records releasable under FOIA?
You can get the guardianship paperwork from the court, and depending on your county, some of the counties it's even online. Wayne County, you can see almost everything online.
Do we have any other questions?
You just go to the probate court and there's usually a case lookup tab, and click on that and search the name.
Oh, there's a
Lady
question.
in the back.
So in the scenario you just said, if she had been the guardian, the actual guardian, could she prevent her still from those things? And I ask because she clearly still has capacity to make those choices regardless of guardianship. So I was just wondering if...
I love that question, but I don't love the answer to that question. So yeah, that's you hit the nail on the head. Sadly, like say she does have guardianship, and like you look at the orders and everything is as it should be with those orders, and it's a full guardianship. Sometimes you'll see the word plenary. Yes. She should be consulting with her, and I don't like the word ward, but it is the legal word. The guardian is supposed to consult with the ward about their preferences. But yeah, I mean, ultimately, if that's what the guardian says, like someone can't go outside or can't smoke or can't eat chocolate cake, it sucks. But that it is the law. I don't like it sometimes.
Call your ombudsman.
Call your ombudsman. Yes. Thank you, Karrie. Absolutely. Yes, ma'am.
I see you.
So back to chocolate cake. What if the person really is not realizing that because of their diabetes, they are putting themselves at risk? When you're talking about having the capacity to understand the consequences, and whether you're going in, or the ombudsman going in, or anybody else, what happens then?
Well, it really depends on what the situation is with the paperwork. So that's, are we assuming that the person doesn't have a guardian that's plenary? So there's no decision maker in place. So it's like me deciding that I'm going to eat something I shouldn't every day. I have the ability to make a bad choice. We all do.
Whether you understand the consequences or not.
Well, if you don't understand the consequences, then perhaps if there's no power of attorney paperwork in place and nothing to be triggered, then what would the next step be if someone was really concerned? they could go to court and make a request for guardianship, but they're going to have to prove what two things to the judge? All right, so right, you got one, the lack of capacity, the lack to make the informed choice, which let's assume that the judge says yes to that, right? What's prong 2 under the Michigan statute? Necessity, right? So the guardianship is only going to be put in place if the court also finds that it's necessary, meaning that there's no other less restrictive alternative. Right? Great question, thank you.
All right, do we have any other questions? Oh, yes, we do. I'm coming.
Other than the court, is there any sort of like governing agency that watches over guardianships?
Not right now. One of the proposed new laws in Michigan is to have an office of the state guardian. So if you're interested, I can give you the numbers. I actually printed it. If you want to look up, there's 5 pending bills in Lansing on guardianship reform. And one of them is to create a state office of guardian to do some oversight. The numbers are House Bill, so HB 4909, so 4,909 through 4,912. And then the House Bill 5047 is the bill that establishes the Office of State Guardian. Those have passed the Michigan House, and they are pending in the Michigan Senate in committee.
All right, do we have any other questions? Okay, let's go ahead and give a big round of applause for our keynote speakers, Karrie and Mireille.
Thank you, guys.
And pop quiz, capacity, finish the sentence, capacity for what?
Capacity for what?
Yep, I'm going to be sticking with that one.
There's our contact. So if anyone wants to reach out.
Email Sally.
Yeah, email Sally. Or me.
I'm just kidding.
Thanks, guys.
All right, thank you so much. Let's give them one more hand clap. Okay, so we're going to go ahead and take our very last break of the day. So go ahead, stretch your legs. We have another snack that's coming out. We also have still the margarita bar. You can go. This is we'll call this last call for margaritas.
All right. So what we thought about with the 10th anniversary, like Savannah said, was it's really important to us, everybody that supports boot camp and all of the sponsors, and there's many that are sponsors for years. And we thought it'd be appropriate to recognize 3 of the sponsors that have kind of go above and beyond in their support of boot camp. So the first one has been the premium sponsor for the last 2 years. But I just want to say a little bit more about Tom Farrell from Crown Real Estate. So Tom's once we met him, I think we started doing business immediately. Come on up, Tom. We started doing business immediately, and he's just one of the most reliable guys I know. So what we found is that when we need somebody and we're not sure that, we're going to be able to get the results that we want. Here, I'll make the door. That Tom's always there. So there's cases, occasionally when we're dealing with Medicaid planning, there's cases where there's a house that's worth $3,000 and we're like, no realtor's going to take this case. Call up Tom and he's like, we'll take care of you. We're going to take care of you. And so he's just been a real big supporter of Mannor Law and a supporter of boot camp. So first award goes to Tom. So the next one, I think they've sponsored every year and just have always been very open and welcoming to getting the word out and getting education out. And that is Lockwood Senior Living of Waterford and Clinton, that they've always been welcoming of our... I'll just turn my mic on, that will be easier. Hope I don't break it. Okay, is that mic on or no? No, this one's not on. Okay. Anyway, so we're going to Lockwood. They've always been very supportive. Very supportive of the education efforts we do, inviting us in to do presentations to their residents and to the community and using their space to do that. And we just really appreciate all the support that you provide. Okay, so the last one, and this is my last chance to actually drop it and break it. Similarly, Vibrant Life Senior Living and has always been our big supporter. We've always had just a great relationship with them. And I think, boy, at least 2 or 3 times a year we're out there doing presentations, and they've always just been very supportive, always been very supportive of boot camp, and they just have made a big difference in their community. So, Vibrant Life Senior Living, appreciate it.
All right, let's give another hand clap for our award recipients. Okay, we're going to go ahead and dive into our final presentation of the day. But first, we actually have a video. Attention, all guardians of the elder care and advocacy galaxy. The force is strong with us today as we tackle the hottest legal battles in elder care. In our corner, wielding the lightsaber of sharp legal strategy, is attorney Kelli King-Penner. Kelli's experience is legendary, her knowledge unmatched. And by her side, piloting the starship of elder law expertise, is attorney Bob Mannor. We like to joke that Bob is the Yoda of elder law. It's actually just me. I just came up with that yesterday, and I thought it sounded good.
I like it.
Together, these legal Jedi Masters will navigate the legalities of estate planning, dive deep into the Death Star of complex trusts, and explore the far reaches of the guardianship galaxy. So settle in, grab your lightsabers, metaphorically of course, and prepare for a crash course in the hottest topics of elder law. So go ahead and let's welcome to the stage Kelli and Bob.
that was my request. We did the Star Wars theme a few years ago, and I thought that was so cool that they had the scrolling thing. So I was like, bring that back. You guys can hear us okay? Can you test your mic, please?
Can you guys hear me okay?
Okay. Okay. Go ahead and advance the slide here a little bit. Is that you?
Yeah.
Or?
You need me, right?
Yeah.
I had one job. I don't know if that advanced or not because it's just
No, we
it's
can't
just
see.
you.
It's just me, so we need to switch back to the slides. All right, well, while we're waiting for that, we have a huge announcement. This is actually really big for us. So we are opening a new office in Brighton, Michigan, and Kelli King-Penner is going to be running that office. So. So this is a partial picture of our team here. Is it who?
We keep adding people.
Yeah. But I'm curious, who's Princess Leia?
Yeah, I don't know who that is.
Abby's
Abby.
Princess Leia. Okay.
That makes sense.
Also, we have 2 more people starting in like a week. So,
Yeah,
and then
like that.
probably some people.
And then
in
a whole new
Brighton.
team in Brighton eventually.
Yeah. So. We hope to eventually offer the same level of service in Brighton and the same, build up the same kind of team there as we do in Grand Blanc and Rochester. So anyway, if you've been to boot camp before, you may have heard this before. So you haven't heard from Liz yet today, but she's been an integral part of boot camp today because she's the timekeeper today. You need to start.
Yeah, you didn't start us.
Yeah.
I mean, you can try.
So Liz is, she's the primary paralegal in the Planning Services Department and actually worked for Department of Health and Human Services in
Virginia.
South Carolina,
Virginia, you were close.
Prior to coming here. And anyway, in the past what we've done, sometimes, we have to have a screening process in our office. So we have to have a process where if somebody's calling about a traffic ticket or they're calling about a bankruptcy or something like that, we just want to make sure we'll point them in the right direction, but that's not our case, right? And there's certain things that, we have to have some kind of screening process. So sometimes it can be frustrating to go through a screening process. And so if you, since you're here, you kind of know what we do, and if you have somebody that you think we should talk to, you'll have an opportunity later on. Savannah will give you some instructions about if you have somebody in mind, just write down your phone number and we'll call you. But if 6 months from now you have somebody that you think we could help, we're going to give you an easy button. Do you remember the commercial, the easy button from Staples?
That was easy.
So Liz is your easy button. So what I mean by that is you can call and ask for her directly. You don't have to go through the screening process. You don't have to go through the front desk, whatever. Just call and ask for Liz. She's going to be able to, make sure that we expedite the matter of the folks that we might be able to help you with. So I want to make sure I put that out there. Now we'll get into the hot topics here. Are we good?
Yep.
All right. So. I'm calling this one The Empire Strikes Back. So tell us about the ending of the public health emergency.
So I'm sure everybody knows by now that the public health emergency officially ended at this point. So what does that mean? Well, that means that redeterminations started. And that whole process has been very smooth and not bumpy whatsoever, right? Yeah. So as we've seen in our office, specifically, I know Liz is kind of on the front line with this, there's a lot of unknowns still how this is going. There's no way to necessarily predict when somebody's redetermination is going to come out. We've experienced a lot of bumping redeterminations. I'm assuming those of you that do redeterminations, how many of you have experienced people kind of just kicking the can down the road? Out of curiosity. Some. So that's been a big thing in our office as far as trying to predict when that redetermination is going to come up. We've got the return now of denials. So one of the impacts that we've seen from the redeterminations popping up now frequently is that people are probably over asset. And they're having problems now with that qualification. So people are losing Medicaid benefits or they're being issued denials.
Well, and one of the things that I think you just mentioned was that we're finding that they told us that DHHS had basically 14 months to get caught up to date on redeterminations. So some of them are coming down hard and they're saying redetermination, you got to get your stuff in, you're going to get denied. And some of them are where they're just automatically approved, that somebody just like checked a box and we didn't even get a notice and they're just automatically approved for another year. So that's how they're meeting, because I can't even imagine, they got 3 years worth of work to catch up in 14 months.
Yeah.
So I think that's how they're doing that, is just some of them they're just automatically approving without any redetermination.
So we're seeing a lot of confusion on that route. Weirdly enough, there was a special I watched last night talking about the Medicaid program as a whole too, and this being a national problem. So it's not even a Michigan-specific problem at this point. It's a national problem with people having eligibility issues that we haven't had to meet in 3 years. So that's definitely a return of some frustration.
The other thing is, if you get a denial, if somebody you're working with gets a denial, feel free to call us. Now, do it quickly. And what I mean by that is, just because there's a denial doesn't mean we can't fix it and make sure that their services aren't discontinued or whatever, that there's no lapse in services. It's because usually we're going to have the next month to fix it in. So if they get denied for April, we'll have till the end of May to fix it, typically. So if you think and why would we need, if they'd already been approved, why would you need a lawyer to get it reapproved? Well, it could be they got an inheritance. It could be that the patient pay amount was wrong during redetermination. So for those that aren't aware, the public health emergency, they made a rule that says you can't get denied for any reason. So somebody could have won the lottery and the rule was you can't get denied.
Yeah.
Somebody could have gotten more income, or that their monthly patient pay amount was wrong, and they started accumulating money. They couldn't get denied, and can't get denied, by the way, until a redetermination. So even though the public health emergency ended on May of 2023, they can't get denied until there's a redetermination. So they couldn't just, I think there was the fear that, and when the public health emergency ended, they were just going to do mass denials. Well, that's not what they did. I'm calling this one a new hope. So there's actually some really interesting things on the legislative front, and we've talked about a bunch of them throughout the day today, but I want to highlight some of them. And so this is we're going to start with the ones that aren't passed, and I think either I think they will, I think they're serious bills, or I hope they will. And so the first one is the care contract proposal. So let me set the stage first, then we'll have Kelli describe the legislation. Every year for the last, 6 years probably, I talked about the case from Muskegon. Jensen? Yeah, so I think it was Margaret Jensen, and she got denied benefits because she paid for home care. And there's nobody doubted that she paid for home care, that she needed the home care. It wasn't even very much money. I think it was $18,000 over 11 months. And if that any of the home care providers, $11,000 over or $18,000 over 11 months isn't very much when it was daily care. And so it's not. They didn't pick on somebody that was rich. The thought that sometimes we hear politicians are saying that well, Medicaid. They're not picking on the rich people. They picked on this woman who had barely anything. She spent $18,000 on a caregiver, and they denied her benefits because they said that because she didn't have a notarized care contract signed by a doctor, that it was they were going to deny her benefits. So Kelli and I just graduated, I guess.
Yeah, I was going to say, you just got kicked off.
I was chair of the section, the state bar section, and now Kelli's on the board of directors for that section. And our section has been trying to deal with this for years. And we tried to pursue litigation. We never found the great case. In fact, the department wouldn't let it get to the point where we could make case law.
Convenient.
And so now we have new hope. So Kelli, if you want to kind of go through that.
Yeah, so the state elder bar, what Bob was referring to, we actually got involved in drafting legislation for this. So there currently is a bill, it's Senate Bill 739, is looking to actually put into law to say that paying home caregivers is not going to cause a penalty for Medicaid purposes. So the whole intent of that is to try and keep people off of Medicaid longer, right? We're paying home services so people can stay in their homes longer, they can stay out of facilities longer, they can have that independence, that autonomy a little bit longer. with what Bob had indicated with the Jensen case is they were getting penalized for doing that. Seems counterproductive, right? We're going to penalize people for when they need Medicaid for trying to stay off Medicaid. So the Senate bill at this point seeks to correct this. This has not been passed yet. So I would ask if you have any inkling to reach out to your state representatives, your state senators, to let them know support for this bill. This really shouldn't be an issue for everybody because what we have seen at this point is when people are ready and needing to apply for Medicaid, they are already years into this problem that cannot always be retroactively fixed.
Well, and it's a disincentive to try to stay off of Medicaid.
Right.
That's why it makes zero sense. Even so, when we actually got somebody that would listen to us, and our section had for a while Representative Doug Wozniak was a member of our section and was a senator and now is back to being a representative. But he was able to put us in touch with people in the department, and we had meetings. And even when we talk about this and say, this is what the rule is, this is the rule that you've promulgated, they'd say, well, yeah, that doesn't really make a lot of sense. And yet they still enforce it.
Mm-hmm.
And so it just didn't make any sense. And so I really think anybody that understands the question that's involved, we're causing a disincentive. We're saying basically you should just go to the nursing home and the state should pay more money rather than keeping you home and paying less money and not the state paying nothing because we're paying a caregiver. It just doesn't make any sense. And the fact in Margaret Jensen's case, I mean, nobody doubted that the caregiver provided the services. They're just saying because of the red tape of having to get a notarized contract, but nobody does that for their neighbor. If you're paying your neighbor to come over and help you, get dressed in the morning, do you think of getting a notarized contract or getting your doctor to sign off on it? So I'll get off my soapbox here, but we really think that anybody that understands the issue here would sign off on this legislation. So we're really hoping it passes. All right, this has been going on for a bit too. So what's the status on remote notary and remote witnessing?
So I've talked to a couple people on this side of this, and I mentioned this during Melissa and I's presentation, that during the pandemic we had this fantastic tool, and that was the ability to do remote notarization, remote witnessing, specifically for following certain requirements for estate plan documents. It was a huge game changer during the pandemic because access was a problem. It was a nationwide problem for anybody in facilities. What I feel like some people have gotten away from as the pandemic has gone farther and farther away from us at this point is that access is still an issue. It is still an issue to get a notary to come out to somebody to sign a financial power of attorney, to get two witnesses that are fitting the definition of independent and unrelated witnesses is still problematic. Yes, the state of Michigan does have an online notarization platform. It is extremely expensive.
And hard to use.
Hard to use and will not work for witnessing. Witnessing is a whole different issue in itself from the notarization platforms. So we, as the Elder Bar section, is also still trying to get what we had during the pandemic put into law. I personally did well over 60 of them during the pandemic online. It's really fun to walk people through Zoom. I got really good at it. But it's still really necessary, and that's something that needs a little bit support for it right now, because as we get further and further away from it, our legislators necessarily don't understand, well, why can't you just take mom and dad to the bank? You have access to them from the nursing home. Well, what if they're a two-person lift?
Right.
Trying to get them out and into the bank, that's a huge problem that's coming up. So again, I would ask if you feel so inclined to reach out to your state representatives for support for this. As far as I know, this is still being kicked around. I don't actually think it's been introduced this session yet.
It may have, I'm not sure. We have somebody that's willing to introduce it.
They've been focusing on some other things at this point, but when this comes about, I mean, we've been trying to get this passed literally since that executive order ended about 2 years ago. I personally think it's a great tool that is used. It's much more accessible than the current notarization laws at this point, and it's a lot more cost friendly. It's not super expensive because our office can do them as part of our normal signings, and it really increases the access to good legal services.
So I want to highlight something that Kelli said there about the witnessing. So all day long, we've been pounding this in about you have to have witnesses on your health care power of attorney, and they can't be related, and they can't be caregivers, and they can't work for the hospital, and all this other stuff. there's literally no way to do it if it's if somebody had COVID. That's why they did give us this authority.
Mm-hmm.
When they had COVID, you're not supposed to go in the same room with them. They're supposed to be quarantined. And it's kind of important that they have a healthcare document. And is it HIPAA too? No, just healthcare.
HIPAA doesn't require the witness to know, but
So the idea is that when the governor gave us the authority with an executive order, then the legislature actually gave us the authority, but they had it expire. And then when we went to the legislature to see if we could get one that doesn't expire, there was a lot of feedback, and our friend Howard Collins, who's an attorney down in Farmington Hills there, he was instrumental in advocating for this and testifying before the committees and such. And the feedback that he got was, well, COVID's gone. I mean, not really, but that's the feedback we got is the COVID quarantine's gone, and so we don't need that anymore. We're like, okay, but what about the person that is a two-person assist? What about the person who is in a wheelchair, and it's very difficult to get the wheelchair into a business office or over
on
to the bank?
oxygen or breathing machines or things like that.
Or is immunocompromised, what doesn't want to have that exposure. And so I think there was such a focus on COVID that they weren't thinking about, okay, this is actually a really good thing so that we can help a lot of people. And frankly, sometimes mom and dad don't want to leave the house. I had one client that I think it was it was probably the fall of 2003, and they came to see me. They had been clients forever. And they said, oh, well, this is pretty much the first time we've been out of our house since COVID started. I was like, holy cow. So
I mean, Netflix.
Yeah.
I mean, at this point. But no, so at one point, and that's why I say I've had a couple of side conversations with people here today. If you have a story that would show that this law is necessary, that is an access issue, I would applaud you to reach out to your representatives, because it's those real person issues that make them understand, oh, you mean you can't just take mom and dad to the bank that easily. For us, it's really easy, I think, when you don't have an access issue, when you are able-bodied, when you have resources and you have financial means to figure that out. It's really easy to kind of put on blinders and ignore all the other limitations that other people have.
So our section, the Elder Law and Disability Rights section of the State Bar, has a lobbyist day where they're getting as many of us to go and lobby our legislators on, and those are the two issues we're going to bring up. This issue on remote notary and remote witnessing, and the issue on the care contracts. And so if you do want to state your voice, you might wait till May 9th, because hopefully a lot of them had heard this the day before, that we'll be talking to them one-on-one. What they have us do is they have us talk to our own representatives. So, the lobbyists go around and talk to everybody, but if you talk to one of your actual constituents, that has an impact. So we're going to try to get as many lawyers and the rest, others that work for us to lobby our legislators on May 8th, I believe it is.
From what I hear, there's people from all over the state, so there's a lot of different representatives we can get in front of.
So this is really interesting. I don't know if this is going to go through, but this was something that has been proposed recently, the caregiver tax credit.
Yep, so Governor Whitmer in her State of the State address this year proposed that she is seeking for the state of Michigan to establish a caregiver tax credit. What this is basically doing is to aim to create up to a $5,000 tax credit for caregivers. Now, that's about as much detail as I have currently, because it is a proposal that she wants to see legislation set forth. Currently, 6 other states do offer a form of tax credit to help offset the cost of caregiving. They are Montana, North Dakota, Missouri, Georgia, South Carolina, and New Jersey. For some reason, that makeup really surprised me. The thing that I found most interesting about Governor Whitmer's proposal is it's quite aggressive. So Georgia's has up to a 10% of the cost, up to a $150 cap. Well, if you've got family members that are traveling or doing other things as part of their caregiver, how hard is it to hit a $150 cap? Super easy to hit that cap where you're not truly offsetting the cost of caregiving. So I'm really excited to see this proposal come out. I haven't seen anything yet, but that potentially could be a really good thing for helping out our caregivers. I do have some concerns on how that would impact with Medicaid things, but we'll have to look at the legislation at that point.
Okay, this is a really interesting one, and Kelli talked about this earlier, but is this a proposal or has this been passed, the surrogate and family consent?
No, this is a proposal for legislation.
So it's for the medical decisions. If you don't have that legal document, you don't have guardianship, is there a way that the healthcare industry or the doctor, the nurse, the social worker, whatever, can rely on the family to make the decision?
Yeah, so I mentioned before that there are 2 implicit laws in the state of Michigan currently that in the event that there is no appointed agent, so no healthcare power of attorney, no appointed guardian, that there are some implicit laws that would allow family members or next of kin to possibly make decisions. The problems being is that it's not explicit, it doesn't apply to everyone. Michigan does not have a general family consent law. This really surprises a lot of people. It really surprises someone. My mom got all irritated one day trying to confirm something with my dad, and that was more of a HIPAA issue at this point. But most people assume that, well, if I can't make decisions for myself, my husband's going to be able to do it, right? Well, not true in Michigan. There is no general family consent law in Michigan. You don't have the same authority over certain family members when there are no documents as you would like parent-child. So like minor children, we have the right to make medical decisions for them because they can't necessarily do that from themselves. In the event I'm incapacitated without any other documents, my husband has no say in any of that. So Michigan is proposing to draft legislation that would expand surrogate decision-making for medical decisions of incapacitated individuals, basically replacing those sections of the Social Welfare Act to make them broader and fix the issues that I highlighted earlier, being that there's no priority for next of kin. Who is family member? They're going to try and draft legislation that makes that clear. Now, I've already kind of hit on this before, that legislation always has good and bad. Good being, I am happy that they're providing some level of direction and clarity for when something happens and they don't have any medical planning at all. However, the default rules of the state of Michigan should never be in place of pre-planning for yourself. I always want to have that option available to family members, but it should not be used as a substitute for what you want for yourself. Maybe you're not close with your family. Maybe you would not want them to make those decisions whatsoever. Pre-planning should always be the way that we go, but I'm glad that this is at least closing a little bit of proposing to close a little bit of a gap and providing a little bit more structure and guidance for people that haven't planned.
And I think that's a good point. So we've been kind of pushing this issue all day long. Almost every presenter talked about substitute decision making, and the idea that we definitely support having resources, free resources, the ability to do it if there's if there's nothing in place. We support that. But it struck me, first of all, I thought the presentation from the Ombudsman was fantastic. I thought that was really great. And just listening to Mireille Phillips about the complexity of it, and it is true, and that there's kind of the point of it is that when you fill out a form or you're relying on the statute that says we can just go to next of kin, that gets complicated because when you fill out a form, you're just probably putting in the date and signing it, right? Or putting in the names and addresses. And the thing with that is what Mireille was talking about was really, this gets more complicated than that. So this was one of the things we had concerns about the new power of attorney law is if you check the box and we need more authority later, right now we typically could go to the judge and say, hey, we need this additional authority. We have evidence that this person would want that additional authority and want to help out or protect their spouse. But some judges might look at that form that they signed off on, and because they didn't check that box, they said, well, no, they've already expressed their intent, and they said they didn't want to give that authority. So sometimes it complicates. So here, it sounds like I'm speaking out of both sides of my mouth, but what I'm saying is, of course, we want people to have these resources, and of course, it's better to have a power of attorney than not have a power of attorney. But for those people that do have the resources, you really need to get consultation.
Yeah.
I'd rather have a power of attorney than no power of attorney, but for those that have the ability to have better nuance and possibly better quality of life and dignity, like Mireille was talking about, the ability to choose chocolate cake or whatever, that's the thing. That is one of those things that doing more customized planning, doing more planning that is with the consultation can make a big difference.
Or at least understanding what the form itself says.
So I just wanted to highlight that. So I've been kind of pointing this out throughout the day, and I appreciate the Michigan Elder Justice Initiative being here and having their table. I'm sure, I know we're going to be wrapping things up, but if you want to get more information, I really love this guardianship diversion program. This is something. I'll tell you a story. Do you guys remember Rachel, who used to work at my office? Some of you might remember Rachel. So Rachel and I and one of the attorneys that used to work here back 11 years ago now, we're sitting around and we were saying, boy, so many people are sent to guardianship and they don't need to be. That they either have capacity or they have a perfectly good power of attorney, or they have, there's other reasons why they didn't need to get guardianship, and now it's so much more complicated and so much more expensive because we have to go through the court process. And they were told to get a guardianship before they ever came to see us. And so Rachel and Jen, the attorney, and myself were saying, we should go out and try to just talk to people and talk to social workers and do an education event. And that's how boot camp came about. That was our very first conversation, was how do we make sure that we get the word out that we don't always need a guardianship. And so everything that frankly, everything that Michigan Elder Justice Initiative does, I am appreciative of. And their director and managing attorney is Allison Herschel, and she was our keynote speaker probably about 5 years ago now, and she's fantastic too. Allison is just a great advocate. And she is, like I said, director of this Michigan Elder Justice Initiative. Their goal is to promote and preserve independence and dignity in the aging population. So I said this when Allison was the keynote, and I'll say it again. If you're looking for a good place to donate money to, it's not the worst place to donate money to, the Michigan Elder Justice Initiative. So. All right, this one's a fun one. So our friend, one of our friends, Attorney Jane Bassett, was instrumental in getting a different type of surrogacy law passed.
Yeah, so Jane was involved in decriminalizing surrogacy in Michigan. So I don't know if many people know this. It was actually illegal in Michigan to pay a surrogate to have a baby for you. It seems very archaic now, given all the advances in medicine and the limitations that we know with couples facing infertility issues or simply just not being able to conceive because of their family structure. This is a great law to bring Michigan into the 21st century now, 21st century, to make sure that that access to this type of medical care is allowed. So it decriminalized surrogacy in the state of Michigan.
Can you believe that was a crime?
Yeah.
I think Michigan was one of the few states where they criminalized that.
They viewed it as baby brokering. That was their problem.
Yeah. All right. Now this is a big one, actually. It's going to seem like it's not that big of a deal, but it changed so many things and made things where they are going to be. Wait, is this the one I'm thinking of? No, this isn't. This isn't the changes to.
No, you're.
Okay, sorry.
You're probably
I'm getting ahead of myself.
So this
one is standby guardian.
Yes.
Sorry, I jumped ahead of myself. This is a different thing.
So those of you that are familiar with developmentally disabled guardianships are probably a little bit more familiar with this theory than legally incapacitated ones. So there was a sweeping change. This EPIC Omnibus Act was signed February 21st, 2024. It did a couple of changes in the probate area. This was one of them, where it is now allowing for legally incapacitated individuals the ability to have a standby guardian be appointed. So basically, when the guardian themselves is unavailable, that you have somebody that can stand in their place. This has been allowed in developmentally disabled guardianships for some time, and I think it's actually a really good thing to allow guardians, first of all, to have a little bit breathing room, that they can go out and do some things, and knowing that there's still somebody as a standby guardian that will be able to take care of the incapacitated person. So this has finally been extended to legally incapacitated ones, or adult guardianships, if you want to think about it in terms of that. I think it's a great change. I actually don't have any qualms with this one whatsoever.
All right, so I Nope, I'm still not to it. Okay, the uniform durable power of attorney. We've been talking about this all day, but is there anything else you want to say about the uniform?
So the biggest thing that I want to talk about with the Uniform Durable Power of Attorney Act is a lot, again, with the form. So forms, having that access to resources are great. It's important that people understand what they're signing. And I would say this about any single form. I have the same problem with deeds. If you want to lose 30 minutes of your life, come ask me about what I think about form deeds. There are problems with any of this stuff. A couple of things that I just want to point out for some confusion. So if you're on the front lines trying to get these things to be accepted, is that it does not void any existing powers of attorney. That even as of July 1st, any power of attorney that was validly executed prior is still okay, as long as it was validly executed. I'd love to come and talk to you next year about the first year of this and whether or not those enforcement mechanisms are working as designed. My guess is I'm still going to have to help clients navigate some minefields as everybody kind of grows and adjusts to this, and there will probably be some changes to this law, I would think, in the future. But just be very, very careful when we're executing form documents. Make sure that you understand what you're signing.
So I just want to highlight two things off of that. They've already been said a couple times now, but I want to highlight two things. One is that don't assume or don't follow the myth that since there's going to be a new law, the old documents don't work. Mm-hmm. Okay, so you're going to see old documents for a long time, and this doesn't invalidate anything. Secondly, well, as sort of part B of that answer, is that this only affects financial and legal. It does not affect the medical powers of attorney. Okay. The other thing was the issue of that the statutory form is something that probably better than having nothing. Mm-hmm. Still probably recommend that they get the advice of qualified.
And the form itself, if you're curious, it's in the statute. It has a bunch of warnings, all over the document, warning people to be like, hey, you might want to get legal counsel. You might want to just even find out what's going on about this. But that doesn't always stop people, because if the warning's on page 2 and the signature page is on page 6, they're not going to read it.
All right, this next one was the one I've been trying to get to for the last
yes, this
3
is
slides.
what you've been excited about.
So the Epic Omnibus Act, which was what was referenced earlier, is also made a bunch of other changes. And some of these I think are really good. So to walk through some of those good changes here.
Yeah, so this is, one of the changes that came from this is the small estate to make it an easier probate. So there's a lot of different kinds of small estate proceedings. There's one specifically that involves kind of like a one and done court procedure that you can file what's called a small estate petition. The maximum cap on that by statute used to be about $15,000. It's actually a little higher than $15,000, but it was about $15,000 per the statute. They've now increased that this year to $50,000. So I think that's going to make that a little bit easier for the smaller estates, make it a little bit easier for that probate one and done. It's aimed to reduce the demand on the court system, which is good, to make it easier when it's below $50,000 and it fits within the criteria of that, to get it from point A to point B without doing a full-blown probate administration. Any of you that have ever gone through a full-blown probate administration would appreciate this.
So, we talked earlier about wills, legal probate, whatever. So this would mean that you're not looking at the will. So a small estate means you don't look at the will. So the will still means probate. It just means the small estate, you don't look at the will. They don't process the will. They don't give a letter of authority. Mm-hmm. It is a one-day in and out, whereas probate's going to probably be...
It's a minimum 5 months.
Yeah, 5 months to a year, maybe longer. Full probate, the small estate or the petition is you go in, you get the order, you go out, you never talk to the judge, you just go to the clerk, right? And is this, are there still, I'm not sure if you know the answer to this, I probably shouldn't ask the question.
We'll find out.
Do they still add on the burial expenses to the 50?
That's a good question. I think they
do.
Might.
Yeah, so typically it's not just like we got, a lot of times it's very convenient if there was something left out of a trust, if it's just a small account that didn't have a beneficiary on it, whatever. It just seems like such a hassle to bother the court with doing a full probate over, or to a spouse. they intend to leave everything to the spouse, but the spouse wasn't on the bank account, or it was the hunting property up north that's not worth anything other than, a few $1,000s or $15,000, something like that. And to be able to transfer those to the spouse that, was never put on the deed, things like that. To bring that up to 50 is good. On the old way, it was, you could add on the cost of the funeral. If you paid, and that may be I believe that's still the case.
I think it might be, but I'm not 100%.
All right, more stuff from the Omnibus Act.
Yeah. So this next one has to deal with another one of those small estate provisions that I had mentioned earlier. This one is commonly referred to as the vehicle-only procedure. Basically, there is a provision that if, under the prior cap, if the estate only consisted of vehicles, which could be a boat, anything with a title, boat, camper, things like that, and the aggregate value of those was worth less than $60,000, you didn't need to open up a probate to get those transferred. There's a procedure to get that transferred to next of kin. Well, inflation happened, I'm pretty sure is what the cause of for this is. So they're actually increasing that amount from $60,000 aggregate vehicles to $100,000, which is good. Speaking as someone who is the daughter of a mechanic who has about 17 different vehicles, I think that this will be a good thing. The threshold is even going to increase in the next couple of years. So it'll stay stagnant at the $100,000 till 2026, and then as of 2026, it'll increase every year to adjust for that cost of living increase. I think that'll be a good thing all around.
All right, this next section we call the Phantom Menace. I crack myself up.
I'm glad someone does.
So these are the court cases. So there's some good and bad in the court cases, but most of the court cases, I'd like to say it is that we find something that the law needs to be changed or needed to be clarified, and we find clients that are willing to pay large lawyer fees to have us pursue the case to get better answers. That's never the case. Clients don't want to pursue court cases. They're usually forced into it, and most of the attorneys that are involved in these cases do it pro bono, meaning when we took our case that you'll see in a second, we didn't charge $1 for it because we're basically defending our case. And so what's happening is the Attorney General is pursuing cases, often, again, against poor people. The one case that we most recently had was over $6,000, and it went through multiple levels of appeal. All
and
the
about
way
3 years worth of stuff.
Court of Appeals, over $6,000 when they had admitted it was their mistake. But they say it doesn't matter that it was their. Anyway, I'm going on and on. So the court cases.
Yep. So one of the biggest protection fights that we have is this idea of Medicaid planning techniques. And one of the primary techniques that we had for a really long time was to go to probate court to get what is essentially a protective order for the spouse's support. So there is a provision in Medicaid law that allows us to get an order from the probate court to say, hey, the spouse that is still living in the community needs adequate resources. So we're going to have those assets be assigned over to them.
So this isn't the most recent case that we've had that we tried to take to the Court of Appeals or took to the Court of Appeals, but we were successful on one of the good cases on protective orders, and that was the DeClercq case. That's been a few years back that we took that case, but it went up to the Court of Appeals, went back down. I'm pretty sure that they would have tried to take it back up to the Court of Appeals again. Judge Barkey decided in our favor every time, and but the person passed, and so then the state decided not to pursue it anymore. But there's a bunch of other cases regarding protective orders.
The thing I want to point out with these cases is these are the cases that are being increasingly fought by the AG's office are not really big asset cases. There isn't a ton of money involved in these. These are well under $1 million in some cases, like total between the two spouses that are, for me, on the younger side, like early 70s. And they're being much more aggressively fought. And we're just seeing this continuously. The one that is going back up at this point to the Michigan Supreme Court is the estate of CECC, who is done by a friend of ours, Norm Harrison, that is really trying to keep this as a Medicaid planning technique, because sometimes this is the best technique that we have to preserve what little estate that we have to make sure that the spouse in the community has adequate resources.
So I know some of you I talked to today are from the Tri-County area, Bay City, Saginaw. This case is in good hands with Norm up in Saginaw. He was successful at the Court of Appeals, and but they had to send it back down. So usually, if you don't know how this works, usually when a case goes to the Court of Appeals, then it goes back down to the lower court judge to effectuate the order, to follow through on what the Court of Appeals told him to do. So that's what happened. That's what happened in the DeClercq case. So Norm was successful in the Court of Appeals, went back down to Judge McGraw in Saginaw, got the same result. And again, Norm's a great advocate, and Judge McGraw's a great judge. And it was appealed again by the Attorney Generals, went up to the Court of Appeals. This time it didn't go so well. And now it is hopefully before the Supreme Court. It's in good hands in a couple of ways. Number one, the petitioner, the CECC's lawyer is Norm, and then we're both actually involved, and Melissa's involved in
Melissa's
the
on the board.
National Academy of Elder Law Attorneys. And for the last several years, we've been raising funds to do a legal support fund, basically to be able to support cases like this that we think are of value. And what the fund is supporting now is to pay for what's called an amicus brief, meaning that other lawyers will get to weigh in on it and support it on behalf of the National Academy of Elder Law Attorneys and on behalf of the Elder Law section. So not only do we have a good lawyer taking the case, but also very experienced lawyers that are going to be providing additional briefs on behalf of our State Bar section and on behalf of the National Academy. All right, this is the case that never ends.
Yep.
Hagedorn, this was a great case. If you ever get it, well, you probably won't enjoy it as much as Kelli and I do, but if you ever get a chance to watch the video of the oral arguments before the Michigan Supreme Court, it was one of those cases that what the Attorney General's office was doing was the whole argument that they made and was recognized by the justices was a political argument. So our side made a very reasoned case based on statute, based on case law, based on the written law, and the response was, but we don't think that's right politically. And so at the end of the Attorney General's presentation, one of the most conservative judges on the bench said, Miss Attorney General, I think, not the Miss Attorney General, she's the Assistant Attorney General. But that sounds like a really good argument if you were running for Congress, but we're in a court here. And that's almost word for word what he said.
That was close.
And so, surprisingly, we won the case unanimously by the Michigan Supreme Court, and it has been, now we've been able to do something called a sole benefit trust for the last several years. That particular case had some quirks to it. And the reason it's going back up to the Supreme Court is on some of these quirks. It's not the way that we draft these trusts. So I'm not particularly worried about it. But you always have to be worried when a case goes back to a court. You know, are they going to change their previous decision? I don't think so. But the issue that's going back before the court is I consider a pretty minor issue.
Yeah, but just for a highlight, this case has been going on for like 11 years.
Is that really that long?
Yeah, because it was early on in my career.
All right, you can talk about this one. So there was another case recently. I'm hoping, was it published? Hopefully it was unpublished.
It was published.
Okay, so when the Court of Appeals does a case, they can decide this has value and we're going to publish it, or they can say this is similar to another case and so we're not going to publish it. And so unfortunately this one was published.
Yeah, so this is Henderson versus the Department of Health and Human Services, and I think that this is really important to highlight. So attorneys are different specializations, right? So we wouldn't go necessarily and see a podiatrist if you have a heart issue. So it's really important that if we're going to find an attorney to do specifically Medicaid planning or things like that, that they actually are routinely doing this. This is a very dynamic area of the law. We want to make sure that they have experience in doing this regularly, that they know what they're doing. Because the results of doing it poorly can be very disastrous economically, time-consuming, stress, all of that. So in Henderson, just some highlighted facts. In February, an attorney helped create an irrevocable trust for the purposes of qualifying for Medicaid. So basically, they created a trust. The client put all of their assets in this trust, so they gave away all of their rights, control, possession over these assets and put it in the name of this trust.
Which, by the way, doesn't really work in Michigan.
No.
Or if it does, it has to be done many years in advance.
Right. So then in April, so what, 2 months later, the client filed for Medicaid with the attorney's help. Shockingly, a divestment penalty was assessed for gifting away all of the assets.
Because you can't just create a trust, put everything in there. Now, the SBO trust is different, the sole benefit trust. That's to protect the spouse.
That's not what this was.
Yeah, we're protecting the benefit of the spouse to make sure the spouse is not impoverished. It's based on federal law. The state has accepted it for decades. And so it's very distinctively different than just putting your money into an irrevocable trust. Well, this guy just put the money in an irrevocable trust and then filed for Medicaid.
Yeah, that was not even the worst part of it. So they got a huge divestment penalty assessed because they basically put everything that they had into this trust. On appeal to the Court of Appeals, the argument was...
So this, and I know we are not the type that disparages decent lawyers and good lawyers. This lawyer had no idea what they were doing, and no one stopped them. Like, no one stopped them, because you have to go through 5 levels of appeal before you get to the Court of Appeals. And how the heck did this case get to the Court of Appeals? They had to pursue it through the administrative appeal. They had to pursue it through the circuit court. They had to pursue a redetermination. They had to pursue it to the Court of Appeals. Somehow, no one stopped them and shook them and said, that's not what the law says.
Yeah, so what they argued was, and we just went over the Hagedorn case, right? So the Hagedorn case involved planning for married couples with solely for the benefit of trust, not this type of trust whatsoever. The argument was that Hagedorn eliminated divestment penalties and that you could gift whatever you wanted without penalty anymore. Not really sure where that legal argument came from. That's not at all. Hagedorn does not deal with that whatsoever. Unfortunately, this case is published, so it pops up. Now, again, experienced elder law attorneys who routinely do these are not going to necessarily end up in this argument, but it's really important that if we're going to an attorney that you're really vetting them and understanding, how many Medicaid applications are they doing? How successful are they? Are they standing behind their work? Yeah. This is a very, very challenging area of the law. I know very good attorneys that won't do this stuff.
Well, and so we got the title for this slide, Worst Medicaid Case Ever, from Doug Shelgin. So a lot of you know who Doug is, and he has a really great blog that he does on elder law issues. And so the moment this came out, he posted a blog, saying this is the absolute worst Medicaid case ever. So.
Yeah, it's not great.
All right, Revenge of the Sith, when approval isn't the end, estate recovery.
So Bob and I were talking of different hot topics that we wanted to go over, and this is one that I saw a news article kind of filtered through the listserv that we're on, talking about families in getting hit with that estate recovery post-Medicaid. And the thing that I really wanted to highlight on this is that application approval is not the end. Estate recovery in this state can easily be avoided. For those of you that don't know what estate recovery is, it's basically anybody that is on certain types of Medicaid benefits, specifically like long-term care Medicaid benefits. When you pass away, the state has the ability to act as a creditor against your probate estate. So only against things that were in your name alone when you died, that they can pursue and seek recoupment from your probate estate.
So if we can keep you out of probate, there's no estate recovery.
It's very easy to avoid estate recovery in the state of Michigan.
As long as you plan before you die.
Right. So I was commenting on this the other day in our office. I said there's 2 things that I live in fear of for making sure that all of our circles are complete, our T's are crossed, our I's are dotted when it comes to our care navigation clients and anyone that we're helping with Medicaid. I live in fear of a community spouse dying, and I live in fear of a single person with a house. We want to make sure.
She's exaggerating. We don't fear it. We take those clients all the time, but those are harder cases. Right. What she's saying.
What I'm saying is, though, I want to make sure that our T's are crossed, our I's are dotted, because the approval isn't the end. That's not the end to the Medicaid story, because if someone passes and the assets are still otherwise needed for someone else, so a surviving spouse, Medicaid will cover your costs of care. Medicaid's not going to give you a comfortable life. It's going to cover bare minimum. You're going to be left with $2 a day. You're not going to have the resources to provide those additional comforts in life. Or whatever your family makeup is at this point. Maybe you have a disabled child that really needs money and we can otherwise structure it. So I think the biggest thing that I wanted to highlight with the estate recovery portion of it is to make sure that just because we get the approval that we're not just saying, okay, we're done. there's still things that we can do to make sure we're doing the best thing possible for our clients, to make sure all of their stuff is preserved to the greatest extent possible. And it's really easy to avoid estate recovery. Other states, I've got a friend of mine that practices in Missouri. They have enhanced estate recovery. They'll go after beneficiary designations, assets. It's very challenging in their states. Michigan has a really liberal estate recovery policy. It's very easy for us to avoid it. So just because we get the approval doesn't mean that we're done.
On the other hand, don't be, everybody that ever get filed for Medicaid after age 65 or receive Medicaid after age 65 is going to get a debt collection letter from the state, or their family is going to get a debt collection letter from the state. Everybody, whether they have a dime, whether they had a house, whether they went through a lawyer that knew what they were doing, whether they did anything else, everybody gets that, I call it hate mail. It is strong. If you've ever gotten a debt collection letter, they use very strong language. They try to scare you. The one from the state actually says, you've got to fill out this survey or this questionnaire, and you got to get back to us in 30 days or whatever it is. And it looks like that you absolutely have to do it. It says, we're going to file a probate if you don't, all these things. In very fine print, somewhere it says, this is optional. And it is, and don't send it back, because if you ever got a collection letter, if you actually take the call from the debt collector or give them any information, then they're going to be just pounding you more and more. The reality is, if you don't have assets that go through probate, that need to transfer through probate, there is no estate recovery in Michigan. But everybody gets that. Why? Why would they send out such a hate mail? Well, because they're okay. I shouldn't assign motive to people. But my fear is that some of the families that get that will believe that they have to pay the money back, and will pay it back even though it is not legally required to do so. So if they have a house that disabled daughter's living in, they may think that they have to sell the house that disabled daughter's living in to pay off that Medicaid fee or something like that. That's not the way it is, but the letter is so strongly worded, I fear that people are deceived by it. All right, next section is on advocacy. That section will go pretty well, and we might finish about 5 minutes early. All right, so if you are in Genesee County, I know we have a wide range of folks here, but the Genesee County senior millage is coming up for renewal this year. It has been fantastic, and if you are not in Genesee County, you might want to see if your county can model this, because it helps pay for some basic legal services for anybody over age 60. It pays for ramp construction, senior centers, senior food programs, in-home personal care, homemaking services, intake and case management, the elder abuse through the sheriff's and the prosecutor's office, even lawn and snow removal, adult daycare, respite care. It has been a really great program, and it costs very little for the millage. Fortunately, the voters of Genesee County have always renewed it, and I do know that it's coming for renewal this fall, and so I am very in favor of it because it is a great program. I mentioned earlier that we send a lot of stuff over to Seth at Eastern Michigan Legal Services. One of the reasons why we can do that is because of this senior millage.
Yeah, it's a fantastic resource for the Genesee County area.
All right, I know we've talked about this a number of times now, but that Senate Bill 739 is just a bill. It's not a law, and it's a long way through Capitol Hill. Some of you that are too young to understand what I'm saying here.
He sent us this recently. We had to watch the whole Schoolhouse Rock thing.
This was a Saturday morning cartoon thing that it tried to explain how a bill becomes a law. This is a care contract thing. I really think this is important that we get this law passed, and I want everybody to know that's not the law yet, but we're working on it. And then, I've mentioned this every year for the last several years. We are trying to lobby, and there's a good group of people that are working on it to try to get the state to get rid of the income cap for PACE and waiver. It's not dead yet. Our advocacy on that is not dead yet. We're not done. We haven't gotten the result that we want, but we're still trying. So, actually, it was Allison Herschel from the Michigan Elder Justice Institute that spoke up on this recently, where she said, well, I think we still have a chance. And so you're telling me there's a chance. And we just wanted to do this. This is one of the sponsors here. So I've been doing a podcast for, I don't know, close to 2 years now, Savannah? Yeah. And so we've gotten some really great, this is Dr. Natalie, who's really had some interesting ideas on Alzheimer's and dementia. The most recent one we did was on a physiotherapist that works with the elderly remotely, which I thought, she was actually doing the podcast from Belgium, I think it was. I thought that was kind of cool. Cool. But we interview some really interesting guests, and it's kind of like this, what Kelli and I just did. I just asked some questions. I weigh in on the answers too after the guest asks questions or answers the questions, and we try to keep it around 30, 40 minutes, so it's not too long. It's, maybe a drive-in. You can put the podcast on. So on the back of the agenda today, it has information about it, and the scan here if you want to subscribe.
Give us a like and a follow.
All right. And as I mentioned earlier, you are always part of the circle of care. And what I mean by that is for us to get the results that we want, we all have to work together. If you have questions, if you need some help, you can reach out to us at any time. There's the phone number. And you have the easy button if you want to just call Liz directly. So thank you. I think we've got some announcements that we've got to do here.
While we're waiting for me to click the slide, let's go ahead and just clap for Kelli and Bob.
Yeah, we do it for you.
There we go. So we are here at the conclusion of our 10th Elder Advocacy and Law Boot Camp. It's been a really fun day. Like I said, I worked here for 5 years and I still learned some stuff today, so that's pretty cool. But we're going to go ahead and have you now get out your evaluation form, and we're going to finish the form. So your checkout time that you're going to fill in is officially, Liz, 3:36. So in that checkout time, you'll fill in 3:36, and then you're going to sign it. If you are watching from home, you had a fillable online form that should allow you to sign that. If you have an issue, let me know. In the email, you can just respond right away. If you're here in person, what you're going to do after you complete, there are some questions on the form after you fill out the top part. There's just some, chance for you to rate the speakers today. Like, for example, you see my name first, Savannah Mexto. Next to that, you'll put a 4 or a 5. No, just kidding. You can put whatever you want. Just kidding. So go ahead, please rate us. Tell us how we did. Did you learn something today? Do you want something next year to talk about? We'd really love to hear that feedback from you. We actually, fun story, we get together as a group and we read all the feedback, every single one of your evaluation forms, in person and online. We read them together in this session. And so we really do rely on this feedback that you all give us to give you a better event the next year. So if you're in person, what you're going to do when you're finished is take that outside. We have 3 different stations. They're lined up alphabetically. I know the first one is A through G. I forget the other 2, H through something, and then the other one ends in Z. There are 3 different stations. Once you turn in your form, you will get your certificate. I know some of you just signed up literally this morning, so you probably won't have a certificate, but we'll make sure that we get one to you next week. If you're online, you can mail the form, you can return the form via email, you can fax the form, you can stop by our office and drop it off Monday. All those instructions are on that virtual form for you. But thank you all so much. Have a safe trip home. Thank you. Happy boot camp. Oh, yeah, don't forget your popcorn. Or if you're like Yoda, I already clicked it away, but forget not your popcorn to take. All right, thanks, everybody.